an ongoing family emergency. So I guess I want to put that out there for purposes of the record. Are there any preliminary matters that need to be addressed before we go ahead and begin with cross-examination? Yes, sir.
Good morning, Menashe Magru on behalf of NCJC et al. NCJC et al has two witnesses that have flown out of state. I know we're in a similar predicament to some other parties, including SIGFR. We've talked to the public staff and talked to other parties. They've not objected to our witnesses taking the stand today, but just wanted to let the commission know. I think it should be reflected in the up-to-date witness list. But again, no, I'm not in a unique position. So other parties might want to also let the commission know if there's similar predicaments.
All right. So your witnesses are present today?
They are present today. We have one of our witnesses is in the hearing room. Witness Kime, our other witness, witness Wilson, is in Raleigh and can be here as soon as possible. Again, I've talked to counsel for public staff, and we're just going to sort of monitor how this morning goes. And there's a possibility that our witness might appear either between or after the policy panel, subject to any other requests that are pending. So
absolutely. Thank you for bringing that to my attention, sir.
And good morning, Presiding Commissioner McKissick. SIGFR is in a similar predicament. We have a witness who has flown in from out of state. He arrived in Raleigh yesterday. He is here today and ready to take the stand. We would ask that if he is not able to get up and down today, that at a minimum, he be able to get up and down this week so that he
Sure.
doesn't have to make another trip to Raleigh next week.
Absolutely. We will use our best efforts to logistically work out what needs to be done so that your witness will be able to provide testimony and be cross-examined.
Thank you.
Yes.
Good morning, Commissioner McKissick. Rita Coxton for the Attorney General's office. We are similarly situated for our two witnesses as well.
Okay, and we will likewise logistically get this worked out. I assume that attorneys have been able to coordinate between themselves to try to come up with a schedule that looks like it would work to address everybody's accessibility. Or have you had a chance to coordinate at all? Yeah.
Respectfully, I think the current order, which is Public Staff Accounting Panel, Public Staff Policy Panel, AGO, SIGFR, and then on from there, at least with respect to those four witnesses or witness panels, I would request that be
The order. Okay, very good. Thank you.
And just to be heard on the record, Ben Smith for Environmental Defense Fund. Similarly, we have witnesses that flew in last night. They're here through tomorrow. So just by the end of the weekend, preferably, our panel of witnesses.
We will use our best efforts to address all the requests that have been made.
Thanks, President.
And we will secure it in an order. We will proceed in an order that accommodates each and every intervener that has witnesses that are flown in.
Thank you.
Absolutely. Well, since we've addressed procedural matters, we are now ready to reconvene. Attorney Lohr, I know we swore them in yesterday, and we admitted their testimony into the record. So I assume that we're now ready to begin with cross-examination. Right.
Yes, Commissioners. Good morning, everyone. Nelson McCown from the law firm Spielman, Thomas and Battle on behalf of Walmart. I'd like the panel to turn to their direct testimony beginning at page 22, and I'll give you a moment to get there. So at this portion of your testimony, you discussed the workforce reduction that occurred shortly after the company's previous base rate increase. And based on your testimony on page 23, lines 18 through 20, am I correctly understanding that post the company's last rate increase, this is not the first time that the company has implemented a workforce reduction shortly after receiving a rate increase from the commission? Is that correct?
Yes, please.
Mm-hmm.
So what we are referring to here is based on the last rate case, just the last rate case.
So just the previous rate case. So in response to this prior history on the same page, lines 13 through 17, you're proposing to reduce the payroll costs based on the average percentage workforce reductions that have occurred following prior rate case decisions, correct?
That's correct.
Okay. As an alternative to your adjustment to payroll costs, could the commission order a refund in the company's next rate case in the event the company implements reductions in force after its final decision in this case?
So we have explored that option too, but we thought like it is making an adjustment in the current rate case would be more appropriate because there will be hiring going on, firing going on all the times at the same time in every year. So it won't be. So by the time we come with the next rate case, a refund may not be meaningful at that. Refund may not be meaningful at that time based on what's going on.
So would those be the issues with a refund instead of the adjustments?
I can add that, so, for example, if you give them, like, you cap them at whatever allowed in this case, they can spend the money up to the cap, then eventually you won't have the refund. So I think our direct testimony layout is more appropriate as we review all those evidence based on the past experience, what they have reduced their workforce up to the rate case.
Thank you. That's all I have.
Okay, very good. And I'm not seeing any other intervener that has reserved time to cross-examine this panel. Would that be correct? All right, so redirect.
No redirect.
All right, well, we're going to go on to commissioner questions. We do have some questions from our commission staff. Could you all briefly walk us through DEC's unionization process?
Yes, I can take that. So, based on our review of the company's capitalization policy, so I think they usually within 6 months after the plant in service, they will unitize it. But the reality, they still have a backlog on their unitization process. I believe we have a discussion in the last rate case as well. So if you unitize, so let me step back a little bit. When you put the plant in service, you can record in account 106 or for account 101, right? So 106 is classified, in service, but not classified. In other words, like you can be booked the asset in for example, transmission account. And then later when you unitize, you realize they may have another more appropriate account to account for it. And then you have to reclassify. So that's why each account type or sub-account, they have a different depreciation rate that will impact your depreciation amount, and therefore your net plan amount. So that's why we'll encourage the company to kind of ensure that they are appropriately unitized. The process is being more reasonable than like have a backlog.
Okay. What is the effect of depreciation expense when plant projects are not closed into individual FERC plant accounts?
Do you mind repeat the first part?
Sure. What is the effect on depreciation expense when plant projects are not closed into individual FERC plant accounts?
Yeah, just like I just speak. So if you, for example, if you put, let's say, just one account with a depreciation rate of 3%, so that's when you original book it, and then later when you unitize, you realize it should be moved to another account with a depreciation rate of 2%. That means you only cover 1% more on the depreciation amount.
And does the public staff have any recommendations regarding the type of processes that DEC can implement to reduce the lag time between plant closings and utilization?
Yeah, I think we have some conversation in the last rate case, and we were hoping to pick up a little bit more in this case, but I think we can continue to have a discussion with the company to try to implement a process that to monitor their unitization process. So that way, maybe suggest file a report after a certain time, maybe it's like next rate case, to make sure that they have really improving the process. Similar like what we recommend for the Dominion in the last rate case. So I believe prior to this rate case, is require them to file a report. So I think that can be something that the commission can order them to do.
Now, what are the public staff's thoughts about DEC withdrawal of its request to adjust annualized depreciation expenses? And can you provide me with any potential consequences to future rates the commission should consider with regard to this withdrawal?
Okay, so I believe the public staff recommendation is more accurately reflect what's happening. So if you are withdrawing what you are happening, that means you are misstating your depreciation, like your reality on the depreciation, right? So meaning your current customer may pay more or less and versus a future customer. So you create intergeneration issue.
We're now going to move on to rate case expenses. In NC 5020, you have included rate case appeals expense of $500,000 related to docket E7 sub 1276. Has DEC previously sought to recover the cost to appeal a rate case in a subsequent rate case proceeding?
So because in the last rate case, let me say this way, I personally work on the last rate case, but I don't aware they have a line item as appeal cost in the last rate case. But if they blend inside the rate case expense, then I can't tell, because the reason for that is we are review all these costs, but they have numerous transactions. We are likely do a sampling. So to make sure we are comfortable with the transactions. So if they are incorrectly recorded under the rate case expense, then I can't tell.
Now, the public staff has removed the excessive cost associated with Deloitte's audit fee for preparing work papers for the public staff. What is the amount of Deloitte's audit fee that the public staff has proposed to be disallowed?
We disallow because, so currently in the actual expense, they are, I believe they include 45, is that okay to say the dollar amount? I need to ask our legal, sorry.
Sure, take your time.
I don't believe that's confidential, but I would look to Duke to confirm.
Looks like it's okay.
Okay, so they include $45,000 dollar for preparing work paper for the public staff review. So in January, like each rate case, the public staff will audit the auditor's work paper to make sure what finding they have and whether that will impact the rate we are setting. So they, in the past, at least it's not as single out the line item. They could have blend inside again, just similar like the appeal cost. They could have blend inside, and I can't tell. But this time they separate it as a line item to include. So in January for auditors work paper, because the audit firm to audit company's financial, they supposed to provide those work paper to the company for review things like that. So we feel like the $45,000 just give the public staff the access to the work paper is a little bit too much.
And do you know if these work papers were prepared solely for the purpose of the current rate case?
We review the work paper for the past 3 years available. I believe it's from 2022 to 2024 because the 25 at that time is not available. So those work paper is like the normal routine for an accounting firm to prepare for any audit of the company's annual financial.
Thank you. Now, my next questions are related to a requested late file exhibit,
Mhm.
which our commission staff, to my understanding, has furnished the public staff with a written copy of this specific request. I'll look to Attorney Lohr to see if you've received anything at this time. If not, what I'm going to do is read it into the record and then, but have you received any notification as of this time?
Not to my knowledge.
All right. I will go ahead and read into the record what we are requesting, and there will be a written document that summarizes it quite succinctly in the event I misstate anything as a part of this recitation. Number one, please provide a comprehensive exhibit which starts from the historical test period and sets forth the proposed plant additions and related accumulated depreciation amounts separately for each of the following periods, those periods being, number one, the update period, number two, the bridge period, number three, the MYRP rate year one period, and number four, the MYRP rate year two period. And then, based upon all of the partial stipulations we have seen filed so far in this proceeding, please provide a red line exhibit which clearly indicates the changes to proposed plant items agreed upon in the partial stipulations and also indicates the unresolved plant items with footnote references to DECs and the public staff's testimonies and exhibits. Now, these exhibits should be prepared in a similar format to the public staff's accounting exhibit 1, schedule 2-1A, 1A, schedule 2-1A, 2A, and schedule 2-1A, 2A1, filed on June 18th, 2026, and filed with the public staff. If there are any updates to proposed plant additions and related accumulated depreciation amounts after the comprehensive exhibit is filed, the public staff should file an updated exhibit reflecting the changes in the same format mentioned above. And I think that covers the late file exhibit that we are requesting. As I said, there will be a written document that summarizes what I've stated for purposes of the record. The next question deals with NextGen GIS. The public staff's distribution panel removed the entire NextGen GIS program from MYRP2. In rebuttal, witness Spiros responded to the public staff's distribution panel's recommendation to disallow approximately $33 million of NextGen's GIS costs placed in plant in March of 2026. He stated that the FERC uniform system of accounts permits discrete, complete portions of a larger project to be placed in service when they are ready for use, even if other phases of the project remain under development. Now, assuming the commission determines that the portions of the NextGen GIS project placed in service in March 2026 were used and useful during MYRP1, can the public staff accounting panel confirm whether DEC accounted for the approximate $33 million of plant additions in accordance with the FERC uniform system of accounts by closing those costs to plant in March 2026?
Okay, if I may, I just want to
Sure.
confirm for the first request. So let me say a little bit about our schedule. So I bet you can turn to schedule 2 or schedule 3, either one. We are maybe just go to schedule 2. We are based on the plan amount as of March 31st, 2026. So I think I heard you said you want an addition, assuming what it means from the test year to the March number.
That is correct.
Okay, so I just want to confirm. Thank you.
As a part of its audits of the NYRP1 plant expenses, did the public staff identify any imprudently incurred costs associated with the NextGen GIS project? And if yes, please specify the cost identified and the basis for the public staff's determination.
I think this one probably will be witness Thomas to address the MRP on the reasonableness on the project. So we are based on the engineer, like Mr. Thomas' recommendation, and then we incorporate those costs or the final amount included in the accounting panel.
Okay. And I'm trying to see, it looks as if we have probably covered everything. There's one question here that was, we were asked to address with the accounting panel that came up when Mr. Lucas was on the stand. And that was simply this: if actual costs for plant decommissionings come in below the estimate plus contingency, what is the rate-making treatment of this difference? Are ratepayers provided a symmetrical benefit?
So, yeah, it is my understanding that the decommissioning cost is part of the salvage value, which is included in the depreciation study. So if your estimate is higher than your actual, that means the current customer is paying more for the depreciation cost, and then the future customer pay less. So you will create intergeneration issue. Yeah.
Okay. I appreciate your response to those questions. I think that covers the landscape here in terms of questions that our commission staff wanted posed to this particular panel. Let me look to my left and my right to see if there are any questions from commissioners. Chair Brawley. Commissioner Tucker. Commissioner Gaida. Well, I guess we move to questions on commissioner questions. Go right ahead, Attorney Lohr.
Just one quick question. Ms. Zong, Commissioner McKissick asked for a walkthrough of the unitization process. Can you please state whether DEC has an internal process for the timeline for booking plant to correct accounts and whether they are following it?
So again, it is my understanding based on the last review as well as the current one. I believe they set up to 6 months to be unitized. And I believe during the conversation, they have about 14 months, the average month for unitization. So that's why we put the language there to say they still have the backlog.
Thank you. That's all we have.
And Commissioner Tucker has indicated that he does have a question, so we'll let him ask that question and then go back to questions on commissioner questions. Commissioner Tucker, you're recognized.
Thank you, Presiding Commissioner. Just one quick question, it'd be yes or no, but when a new plant starts up, does Duke start seeking depreciation day one?
So if they are in service, so let's say it this way, in rate setting, so you had to think about the difference between the accounting booking and the rate setting. So if a plant in service, then they will start the depreciation. So if they are on time for rate recovery or there's some mechanism for deferral, then they will capture all those depreciation costs. But if they don't, then you will, at that point, when they ask for rate recovery, then that will be the period they are including the depreciation cost.
So they're seeking through rate recovery day one if they qualify for depreciation and not
Yes.
some extraneous
Yeah, so
method that they can defer expenses, right?
yeah, so for example, like let's say for the MRP rate years, right? So because those are estimate project costs, and then you will associate with the depreciation expense, whatever the amount they are putting in service, then they will start that point to account for the depreciation rate, cost. And that part will become part of the revenue requirement for setting the rate for the rate years.
Okay. All right. Thank you. Thank you, Commissioner.
Any other commissioner have? Doesn't look like it. Attorney Lohr will once again return to questions on commissioner questions.
We have no more questions.
All right. Well, thank you for providing testimony today. I know your testimony was spread over 2 days, but it was so long and exhaustive. So we hope you get some rest.
Thank you.
But you're hereby released. We will, out of abundance of caution, we'll go ahead and swear you in once more. You have in the Bible, raise your right hand. You solemnly swear the testimony about providing this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning, Commissioners. Ann Keyworth for the public staff. Mr. Metz, would you please state your name, business address, and current position for the record?
My name is Dustin Metz. My business address is 430 North Salisbury Street, Raleigh, North Carolina. I work with the Public Staff's Energy Division. I'm the director.
Thank you. And Mr. Thomas, would you please do the same?
Yes, my name is Jeff Thomas. My business address is 430 North Salisbury in Raleigh, and I'm the manager of the operations section of the Energy Division in the Public Staff.
On May 29th, 2026, did you both prepare and cause to be pre-filed direct joint testimony in this docket consisting of 48 pages, 4 exhibits, and 2 appendices?
Yes.
Did your testimony contain confidential and highly confidential information?
Yes.
On June 18th, 2026, did you both prepare and cause to be pre-filed an errata and corrections to your pre-filed joint direct testimony?
Yes.
Do you have any additional corrections to make to your testimony?
No.
If I were to ask you the same questions today as were in your corrected pre-filed joint direct testimony while appearing on the witness stand today, would your answers be the same?
Yes.
Did you both prepare and cause to be pre-filed on July 6, 2026, a summary of your joint testimony in docket number E7 sub 1329A?
Yes.
Have you reviewed the agreement and stipulation of partial settlement between DEC and the public staff filed in this docket on July 2nd?
Yes, and we support the stipulation as a negotiated compromise reflecting give and take between the parties.
Thank you. Mr. Metz, the same for you.
That is correct.
Presiding Commissioner McKissick, at this time, I move that the corrected pre-filed joint testimony of Mr. Metz and Mr. Thomas, consisting of 48 pages and 2 appendices, the 4 exhibits as originally filed, and the pre-filed summary of the joint testimony of Mr. Metz and Mr. Thomas be entered into the record as if given orally from the stand.
Without objection, your motion is allowed.
Thank you. And this panel is available for cross-examination and commission questions.
Right. I see the Attorney General is technically first, but let's see if they're waiving it.
Yes.
All right, in which case, Sickfer.
Thank you. Good morning, gentlemen. I'm going to start by asking you some questions about the cost of service stipulation that the public staff is a party to. Was the cost of service stipulation the product of a give and take between the stipulating parties?
Yes.
And does the public staff believe that the cost of service stipulation is in the public interest and should be approved in its entirety by the commission?
Yes.
Okay, switching gears, you testify in your panel's testimony that Duke's proposed performance-based rate-making plan is not in the public interest. And you are also the policy panel for the public staff, correct?
Yes.
So I have a number of questions on this topic and the public staff's conclusion on this issue. Picking up where I left off with you yesterday.
Presiding Commissioner McKissick,
Yes.
may be heard.
Yes, you're recognized.
Thank you. Once again, it appears that we're going to have some cross from a counsel for a party that has no adverse positions with respect to the topic she's now inquiring about. We've heard on this topic a number of times, and I just want to be clear here that the objection with respect to friendly cross has nothing to do with limiting the ability of parties to be heard. It, of course, has to deal with the efficiency of these proceedings. We are now approaching the third week of this hearing, likely. And the point of not having friendly cross is that we don't need to have questions asked that simply restate what these witnesses have already testified to. And I'll add also that the commission obviously has its ability to ask any questions that it wants of this panel. But to the extent these questions are simply going to ask these witnesses to restate their testimony and affirm the things they said in their testimony, it's just not an interest of the efficiency of this proceeding. And that's the reason why the commission has historically objected or not allowed friendly cross. So we would just reiterate in this case that it sounds like we're heading down that path again. And for the sake of efficiency of this proceeding, we'd ask that these questions not be allowed.
And may I be heard in response?
Yes.
Thank you. First off, my cross is going to be very efficient. And I know that I increased my estimated cross time, but I have worked overnight to pare that down to the greatest extent possible. I am going to be asking not for them to restate what they have already testified to, but to provide additional context, which I believe is very important to this commission's determination of whether or not what Duke is seeking here is in the public interest. And to Mr. Durak's point about efficiency, completely understood and agreed, which is why I did my very best to limit the scope as much as I possibly could.
And to the extent Attorney Durak has stated that he objects to friendly cross, I will sustain his objection as it relates to friendly cross of these panels that are brought upon us at this time. And it sounds like that's what you're not planning to go back over that type of testimony. You're seeking some clarification or have questions that will elicit testimony that is different than what the characterization of friendly cross would constitute. Is that correct?
Well, Presiding Commissioner McKissick, Mr. Durak objected before I even asked my question. So
I understand, and I respect that. And I will make the distinction between having a panel here and doing friendly cross from what it is when we have commissioner questions. Because we as commissioners are finders of fact. We are not witnesses. We're not being cross-examined. We're simply asking questions as a point of inquiry to have a fuller, more complete record based upon issues that are important, significant to this body as we're constituted. I think it's different than when we have a panel here that is in fact being cross-examined. So just for purpose of the record, to be able to nuance and distinguish when something might be addressed as friendly cross of a panel of witnesses versus what would be if we are as commissioners asking questions and you're doing follow-up on commission questions. Since that came up at one point yesterday, you're hearing my thoughts upon that issue. Obviously, whoever is presiding can potentially rule differently, but I think my thoughts are consistent with traditional interpretations and rules of procedure. So with that stated, objections sustained, you may proceed with your cross-examination.
understood. Thank you. So, gentlemen, do you recall generally a discussion that I had with public staff witness McLawhorn during the last two Duke Energy rate cases about the differences between historical test year traditional rate making and performance-based rate making, and multi-year rate plans.
At a very high level, yes.
Can you, excuse me, can you speak to, now that the public staff has had the benefit of hindsight, we are in the third year of Duke's first multi-year rate plan. Can you speak to, at a high level, the differences between traditional historic test year rate making and performance-based rate making as authorized by House Bill 951?
So I'll start with the traditional element. Mr. Thomas jump in with his review of the overall MYRP. At a very high level, when we look at traditional rate cases, which do not include the multi-year element, it would be the company builds a plant, books the cost, they come in for a rate case, and we investigate those costs and bring those findings to the commission. There's not necessarily a forward-looking element to that, but it's more of the utility spends, seeks for cost recovery, comes in for a rate case, and we come before this commission. Oversimplified. So the function of the MYRP is it added a dynamic of this forward-looking element. Now, in terms of workload or work increases, I believe Mr. McLaughlin or myself stated this in the last round of DEC DEP testimonies. It almost became 2, if not 3 rate cases in itself, because we have the entire historic plant that we still have to investigate. And then we have the entire forward-looking element, which is another rate case in itself, and it added in overall complexity. But Mr. Thomas, you want to speak about the MYRP in this case?
Yeah, sure. And just to reiterate Mr. Metz, it's not a it is a traditional rate case on top of a PBR, right? So it's significantly more effort and work. The MYRP investigation is obviously a little bit different because I think I've spoke to this before. We're not looking at incurred costs, invoices, contracts. We're looking at estimates, projections, which are highly uncertain. And we've seen deviation from project costs is we review projects that are completed, and we've seen estimates change even just within the MYRP period, right? We get the initial direct filing, we get a supplemental filing, and then in this case, Duke did not update the MYRP beyond like a single project in the second supplemental. But in the last case, we had multiple updates of project costs, timelines for the MYRP projects. So it gets really difficult. And then even during the MYRP period, as we're trying to evaluate these projects, we see, projects are delayed, sometimes they're accelerated, sometimes they're canceled, sometimes they're swapped. So it becomes a real headache to track through all of these over time to evaluate the performance of the MYRP. But it is a lot of work, and the public staff spent a significant amount of its time, in this case, investigating the MYRP investments and the planned investments over the next 2 years, because they have a significant impact on the increases that ratepayers will experience over this next 2 years. And there is only a limited staff and limited hours in each day. And so every hour or day we spend writing discovery or reading discovery or analyzing an MYRP project in the future to determine the reasonableness of the cost estimates or the need of that project. That's an hour or a day that we're not looking for imprudence or looking for projects that were completed without proper justification or alternative analysis in the historic period. And I'm sure Mr. Metz can attest, but it stretches us all thin, and we do our best. I think we've done a great job in this case, trying to bring this PBR back in towards the public interest, but it is a challenge, and more and doubly so, I think, the more rate years we look at. So.
Add in one more item. I think it's important for the commission to reflect on respectfully. In the first MYRP, the first one, the public staff and, in my opinion, the utilities had learnings. And a lot of those learnings were applied on the front end. The project documentation, in this case, a compliment to Duke's team. They took our lessons learned, our feedback, and we worked together in the off season, and it was very good, delivered, and well-received product. So there are positive attributes of the learning that are going to be applied. In the first MYRP, it was the public staff's first one, and I wouldn't say we reviewed 100% of the MYRP projects, but we reviewed a significant amount, probably greater than 50%, maybe even closer to 75%, if my memory recalls. And it depends. I mean, because distribution is a much larger, so some things were evaluated at the program level versus some things were elevated as a individual project level programs having multiple projects included. So to balance the items, if we provide all our focus on the MYRP, it means we start losing focus on the historic case in which the public staff cannot re-review in a following rate case. So as we apply those lessons learned, we had to do more of a sampling approach to the MYRP in relative comparison to just exactly how we do our historic case. So I think it's important for the commission to understand what the public staff is looking at. We do not look at 100% of the historic case. We do not look at 100% of the MYRP projects. It is a sampling-based approach on both bookends.
Thank you. Switching gears, I want to talk a little bit about the company's proposed project completion PIM. Does that not address some of the public staff's concerns regarding potentially delayed or canceled projects?
So I'll let Mr. Thomas jump in. So when I look at it, I believe it's a step in the right direction based upon Duke's performance of the first MYRP. And it's not to be critical, I would just say I would probably propose a different idea, and I'll try to explain why. And again, Mr. Thomas jump in with his perspective as well. Is that looking at just projects in isolation, just the project number completion does not align with the revenue requirement that we're actually paying for in the projects. If all projects, Mr. Thomas looking at DEC's MYRP1 was approximately 1,200 projects.
Give or take, yes.
So it's 1,200 individual projects in MYRP1 plus or minus, is that every project has a different cost. So if you just look at the project number completion, it does not align with actually ratepayers are paying, because some project costs are much higher, some projects are much cost lower. So if I had to propose a revision to the commission to say, I would probably look more closer to the actual revenue requirement or combination of projects and the revenue requirement. Now, it relates to a PIM and the alternative, I would just propose a rider, a refund rider. Why? Well, the PIM, again, it's a different idea. The PIM has a cap associated with it. To the extent that total costs that ratepayers have paid for incomplete projects, we may be limited by the cap within the PIM. So therefore, I would prefer an actual rider in itself. It's not limited by that constraint. Mr. Thomas?
Yeah, and if I could just, in our PIMS panel testimony, I think they pointed out that the PIMS proposed in this case, the maximum reward or penalty that could be assessed is, I think, subject to check, it was about 69 million. And I think when we identified in DC's rate year 1 and 2, there were $1.1 billion of incomplete projects by the end of rate year 2, in rate year 1 and rate year 2 that ratepayers are paying for. I think we estimated that the revenue requirement, the NC retail revenue requirement for that was approximately $83 million, including just depreciation expense and return. So you can see how the scale, the limits of the PIM at 1% of their revenue requirement limits the effectiveness, right? If that PIM had been in place, it's possible that the entire PIM amount or reward or penalty would have been assessed on DC and no other PIM could have mattered, right? Because it's a cumulative cap across all PIMs. So agree there that that's a shortcoming, and agree with Mr. Metz's suggestion that a standalone rider might be more effective. And obviously the devil's in the details. Is there a threshold for incomplete projects? Do we need to get to 100%? Is 95%? Do we measure it on number of projects? Do we measure it on approved dollars, on some sort of revenue requirement? So a lot of that's in the details, and I think we would need some time to kind of evaluate that. But I would also, suggest that in my standalone testimony, I recommended an across the board reduction in MYRP project spend to account for incomplete projects, learnings, and MYRP 1. And I think both the rider and the across the board adjustment are attempting to achieve the same thing, which is essentially attempt to make ratepayers whole for projects that were not complete and revenues that they paid. The difference is that the across the board adjustment that I recommend provides that relief to ratepayers up front and allows DC to recover the gap to actual completion in the next general rate case, versus the rider charges ratepayers up front, and then after the completion of rate year one, there's a period where the rider would be adjusted. There'd be a filing, there'd be comments and testimony and a commission order, and then the new rider might not take effect till halfway through rate year two or later. Not sure on the exact timeline. So it's really also kind of a question of, when do you offer that relief to ratepayers? When do they need it? When would they appreciate it more? And what's kind of fair and equitable to those ratepayers who, under the filed PBR, are assuming a lot of risk for this type of incomplete project?
I just expand on one more. I mean, to Mr. Thomas's point of the concern of the PIM is setting a value up here, but yet the revenue requirements up here. If you go to page 22 of our testimony and you look at figure 1, that shows the projection of CapEx. Now, it's not it's not placed in service, but that shows you the trend and the orders of magnitude where the expected CapEx is going to go. So our concern is that the PIM may artificially suppress the magnitude of refund of projects of which ratepayers are paying in from our perspective that were not completed. The secondary item of that is we talked about the $1.1 billion that were not completed. That was $1.1 billion based upon this commission's approved MRP,
Right.
which is not reflective of the company's actual ask. Now, in fairness, that was part of a settlement agreement with the utility, which ultimately was a give and take of multiple items and reduction. But should this commission actually approve the utility's ask, the $1.1 billion more likely not would have been much, much higher than 1.1.
Switching gears, there's been some testimony about improvements to Duke's quarterly reliability reports. Are you familiar with this testimony?
Referring to the distribution panel, Mr. Williamson's?
Yes.
Yes. Yeah, I'm familiar with it. But if you have specific questions about the methodology, you would have been the one to ask.
Is there a reason why the public staff has not asked Duke to include MAFI or MAFI-E in those reliability reports?
I'm sorry, I really can't speak to the specific questions there. I think that was Mr. Williamson who reviewed service quality. And the reason why he would have been the right person to ask for that.
Only thing I can expand is I agree, Mr. Thomas, Mr. Williamson will need to expand, but if I'm not mistaken, with the MAFI metric, one of the items of consternation that may be in that analysis is the time series in which you measure the monetary. So if you set it at a second, then it'll be exponential amount of numbers versus if you say you set something at 1 minute or 5 minutes, et cetera. But again, Mr. Williamson would need to answer that in more detail.
Okay. And switching gears, is it fair to say SIGFR and the public staff are not seeing eye to eye on the issue of large load tariffs?
Can you orient me to where we're talking about the large load tariffs within our testimony? I'm just trying to get oriented.
And so as the policy panel, you all are providing testimony about what is and what is not in the public interest, correct?
I'd say our policy panel is talking about the discrete items that are discussed within our testimony. I don't agree with your characterization.
Okay. Do you have any reason to believe that SIGFR would not actively participate in an expedited stakeholder process on large load tariffs?
I'm going to object to this line of questioning. This panel, while the public staff's policy panel did not individually or collectively review, all of the topics within this rate case, and that panel's been here, and these witnesses really can't speak to those topics specifically.
And respectfully, if I may, Mr. Metz is the director of the energy division for the public staff and has been very involved in the issue of large load tariff development and has participated in some discussions outside of the rate case hearing on this topic. And so I do think he is an appropriate witness to answer this question.
And I would just say that the opportunity was here with the panel that spoke to that topic matter. Thank you.
I'm going to sustain the objection.
So, Mr. Metz, is it your testimony this morning then that you are not the appropriate witness to direct any questions related to large load tariffs?
I can attempt to answer questions to my knowledge, but as I'm looking at here is that the testimony that we are talking about here is just within bookends of exactly what we're talking about here.
Yeah. Thank you. Nothing further.
Okay, thank you. CUCA. Get away. Okay. Environmental Defense Fund.
Yeah. Where it just says.
Good morning, Ben Smith from Environmental Defense Fund. I just have a few questions. I think that you all explained what the concept of the shadow MYRP was with Ms. Kress a little bit. So I'm going to skip that, but I did want to bring up, you brought up this concept of a rather than a regulatory lag, a regulatory lead. Do you recall that?
You just point us to the page so we can.
Yeah, one second. Why are you? Page 14.
See that?
Yeah, and line 5. Can you just sort of, I need like a high level explanation for what you mean by this, just because the way I read it and reread it, I want to make sure that I have a little bit of give and take on it.
So how the public staff is looking at it is looking at it from the lens of uncompleted projects, is that the company is essentially recovering money from the ratepayers as a leading function relative to traditional rate making, which would be a lagging function. So recovering money for ratepayers before a project is completed is a lead.
Got some electrical engineers up here, so leading, lagging, power factor, just kind of the opposite concept.
I appreciate it. You have a lawyer who barely can figure out how to read sometimes, so I need all the help I can get. Okay, so the concept of regulatory lead to me, I would sort of say seems sort of opposite of the traditional presumption about regulatory lag and maybe what PBR was sort of intended to get around. Is that sort of what you all are getting at a little bit?
You restate the question, please.
You know what? Actually, we'll scoot past it. I want to ask you a couple hypothetical questions, which I think are appropriate based on your experience and the recommendations in your testimony. And I promise it'll tie together, and I'm going to stay within my lane. You mentioned on beginning around page 38, affordability being a primary customer concern. Do you recall that?
Yes.
And further on, you go on to discuss the amount of consumer statements of position and the potential for the customer flood of customer assistant program applications and sort of other issues that you see occurring now and potentially increasing in the future. Is that a fair statement or summary?
I don't Yes, we talked about our public witness experience with public witness hearings and reading through those responses. Both of us have attended those hearings and listened to customers' concerns regarding the rate hikes proposed in DEC's application.
And have you seen compared to other recent rate cases that you two have both worked in? Has there been more filed consumer statements of position? Is it about the same? Or is the public fervor different in any way that you've noticed?
Well, I think our testimony identifies 4,100 consumer statements of position in this docket at the time we filed, compared to about 1,700 in the last case. So that's in our testimony. Whether that is a result of more awareness on this case or more engaged customer base, I could not tell you, but the numbers are there.
Okay. And Ms. Kress brought up reliability, and I guess I'm certain that you mentioned either directly or indirectly the importance of reliable electric service for DEC ratepayers. So can we agree that in addition to affordability, reliability is a core tenet of the public staff's review and consideration?
Yes.
So one thing you didn't discuss, but is required by law, is the decarbonization of the DEC generation fleet. You all are familiar with House Bill 951 and the 2050 carbon neutrality goal?
Yes.
And I know it isn't directly related to the rate case, but I'm getting somewhere, I promise. So you touched on concerns about the MYRP proposal and other DEC proposals with respect to affordability and reliability. Do you all have concerns with this DEC application, including all the asks, with how it will impact DEC's ability in the future to attempt to meet the decarbonization goal?
Well, I'll just start off by saying we literally just had a hearing 2 weeks or so about the carbon plan, the 2025 carbon plan. And I think the public staff made its position there very clear through many hours of testimony. This case, while there are some generation projects in this case, there's some solar, there's some batteries, there's some uprates and capital projects at hydro and natural gas facilities. This is not primarily a proceeding where we are deciding on what type of generation needs to be built over the next 5, 10, 15 years. So, we are looking here and focusing on costs and rates and whether the investments planned by DC are needed and necessary and reasonable. This is just one component of that and is not really related to system planning in that way. If you have anything to add.
Just when we look at if a new generation resources is added, and again, I'm putting on my hat from years when I've looked at, say, a combined cycle was added to the system, or the particular generation unit was added to the system. So what was the need and what was the termination need? So Mr. Thomas' point, that ties back to an IRP. And then we look at the overall cost and the decisions and how the utility managed the plant. That is the review of within a rate case.
Understood. But you all did talk about risks shifting to ratepayers. Isn't that right?
I think we're talking, the risks that we identify as shifting to ratepayers are clearly outlined in our testimony. The risks of paying for projects that are not completed, for not receiving those benefits, the potential for the quality benefits to the service quality benefits to outweigh, essentially any alternative analysis. So we talk about that quite a bit. But as far as system planning, again, this is just not that docket.
And again, I want to focus that I'm not asking about system planning risk. I'm not trying to. I'm trying to talk about risk. And as I recall, and I will go back to the system planning docket, there was a considerable discussion about risk in the 2040s, where we'll potentially have to make a whole bunch of investments to sort of right size the system to meet the 2050 goal. Do you all recall that?
I think you're getting into CPRP here. This PBR goes out through the end of 2028.
Okay, so
in the overall PBR, or try to identify known and measurable projects subject to the limits that are set by law.
All right, so I guess I'll ask this then. When you all are making your assessment about whether DEC is making or planning to make good investments as proposed in rate case like this one, do you consider the CPRP and the planning that the utility has done?
I'd say, if I may, Mr. Thomas, I think the two go hand in hand. So to the extent that as I talked about this previously, if the CPIRP identified a need for the project, and then let's say the utility came in for a project that required a CPCN, and this commission approved the CPCN, when the company would come in for cost recovery from a rate case perspective, we would look at the lens of what was reasonable and prudent. Now, the MYRP projection is a slightly different function, and Mr. Thomas can speak maybe more his experience, maybe perhaps about the solar projects that are, or at least were included in the last MYRP, but I can't speak to this MYRP.
Yeah, I mean, I can give you some kind of concrete examples and ways that we might look at the CPRP or system planning when we evaluate MYRP investments. For example, as part of our review, we looked at the transmission projects that were proposed in Witness Fogg's MYRP exhibits. And we looked at that and we compared that to projects in the being approved in the Carolina Transmission Planning Collaborative, right? And so we cross-referenced those projects with the MYRP, and we looked at what projects in the MYRP are not in the CTPC, what projects in the CTPC are not in the MYRP. Witnesses Weaver and Hill looked at solar and storage. If Duke was coming in and they're saying in their MRP, we want to build this solar facility that was not selected in a competitive procurement, that is not needed or called for in the CPRP, they might have had issues with that particular investment, said, hold up, you should be only tracking investments that are procured through the annual competitive procurement process that is governed with targets and timelines set by the CPRP. And the same for storage, right? We're trying to make sure that the storage investments in the MRP are aligning with those in the carbon plan. But I want to be clear, when you're talking about the MRP, we're talking about 27 and 28. These are not resources that are being discussed as selected in the last IRP. These are resources that were selected two or even three CPRPs ago because of the timeline it takes to determine the target, get the order that approves the target, establish the RFP, develop the project, get it in the queue, and then get it to a point where you're actually looking at commercial operation by the end of 2028. And that's a tall hill to climb. So while they are slightly connected, and we certainly would object, I think, to any renewable solar, hydro, or storage investment in the MRP that was not reflective of the CPRP. This is certainly a kind of a late entry into the game. And by the time we are looking at these investments, they have been thoroughly vetted through that process and are close to completion.
No further questions.
Thank you. Next in the queue is Walmart.
We've waived cross.
Brings us to DEC and
We have no cross this panel.
across to this panel. Okay. In which case, redirect.
Thank you. I think I just have one question for you all. You were asked, I believe, by Ms. Kress about the, our work in evaluating MYRP applications. Can you speak, you mentioned sampling. Can you speak just a little bit more to what the sampling of both the traditional aspect, or historic, I should say, as well as the MYRP, the scope of it, the magnitude, just speak a little bit more to that.
Sure, I can start, and Ms. Metz can continue. We've both individually sampled projects in this rate case and many in the past. Just very high level, when Duke files its case, we send discovery. And one of the first discovery responses requests we send is give us a list of every project that is closed since the last rate case. And then throughout the proceeding, they provide us monthly updates, everything that was closed in the month prior, all the way up through the capital cutoff period, which is March, the end of March 2026 in this case. And we get those lists of projects. And as you've already seen, our witnesses are split up kind of by functional area and topic. We will look through those projects and select some for further audit. We'll select based on project descriptions, questions we have, absolute cost. And so we typically try to target, at least 10% of these projects. Sometimes it's difficult to get that amount. Sometimes it's easy to get 100% because there may only be a few solar or storage projects, for example, that were closed relative to, say, distribution, where there might be thousands of distribution level projects that were closed to plant. We'll send another data request that asks for things like a list of charges, a book to that project, which could be thousands, tens of thousands of individual line item charges associated with each project, accounting entries and invoices and the like. We send a pretty exhaustive DR, and this is probably a big contributor to Duke's count of their DRs that they explained in rebuttal, right? Each one of these DRs that we send on a sampling of projects, I think it has one question and about, what would you say, about 20 subparts asking for WBS, the work breakdown structure, asking whether there were any insurance payouts, whether so we can make sure those get booked to ratepayers, asking for like change orders and other issues that we want to dig into if it was subject to a stipulation or a regulatory requirement. And then we look at those responses, and typically we'll send out 1 or 2 follow-ups on that, depending on what we discover and what we look into. Sometimes we'll try to look at over a wide variety of projects to see if we can spot, irregularities, like why was the travel so high on this particular project. Mr. Metz in his individual testimony talks about some inappropriately capitalized awards and things like that, that we made some recommendations on. And so that process plays out throughout the whole period as we get these updates. And in this proceeding, obviously, we were doing that both for DC and Duke Energy Progress as well, kind of simultaneously. So keeping all that tracked and digging into those details is it is a significant effort. And I think the public staff team did a very good job in digging through those historic investments. But again, we audit a fairly small percentage, all things told, of the projects, and we make the best inferences we can and the recommendations we can.
And only add is to Mr. Thomas's point. Sometimes when we have to start here and we work our way all the way down to here, we have a finding to a project and you're like, oh, I wonder if this is a larger concern that got applied to other projects. So now you have to go back and resample a different set of projects, but you kind of isolate a variable. And so sometimes it creates this iterative approach. And back to Mr. Thomas, dozens, if not dozens of subparts. There's a reason why there's so many subparts, because I've learned why I have to ask those subparts. I'm trying to use something as a hypothetical, but not an exact example. It says, why did you do it this way? We did it because we couldn't. Provide the support. Has to be a subpart. If you didn't follow your process, please explain why. If you did follow your process, please explain why. So we've had to increase and create these levels of questions in order to move efficiently through the timeline, because oftentimes there's a fork in the road and we need to investigate both decision processes at the same time versus a yes or no answer. Because sometimes a subpart question is just answered as not applicable because the company chose a different path to go down.
And just to put a real fine point on it, table 1 of our testimony on page 19, in this case, that historic review that I'm talking about involved the review of $10,169 million of capital projects that were closed to plant in the historic period. So it is not a trivial matter to investigate it. We could double our staff and probably only audit, a incremental amount. We'd never be able to audit it all.
That's all I have. Thank you.
Right. We'll now go to commissioner questions. I have a few questions here from commission staff, which I'll address with you, and then we'll see if there are any questions from fellow commissioners. Has the public staff previously put forth this notion of a refund rider as a solution to your identification of ratepayer payment for uncompleted projects? I know it came up today, I think, in a question that Attorney Kress raised with you.
Sure. So the immediate answer would be, at least from the energy division, the answer would be no. Why? We're learning. This is just our second MYRP. Our large concern that came out of the MYRP 1 was the magnitude of projects and the magnitude of dollars of which ratepayers had paid for incomplete projects. So we believe this would be, from a risk standpoint, from our view, the risk has shifted to the ratepayer. We would like to bring that risk back into equilibrium, and just the costs are what they are, with the reciprocal refund to be present.
And understanding the magnitude of projects that were incompleted, I mean, did you give thought to perhaps proposing this as an alternative to the blanket MYRP disallowance that you proposed?
So I'll start on that one, and Mr. Thomas jump in. Is the first MYRP we did through settlement, we did do a blanket reduction, and we still ended up at this large dollar value.
Mm-hmm.
Now, I believe I recall the company talking about they have applied lessons learned, and through my personal review of the project documentation, more focused on nuclear, I did see an improvement. It's not that for nuclear in the last case was bad, but I did see an improvement. I did see an intent to say, let's narrow the degree of uncertainty of projects. But this comes the challenge of saying, well, this is how you performed on the last MYRP. Given the magnitude, I don't know if I fully want to go without a blanket adjustment, given the overall magnitude. So it could be a combination of both, but a minimum, I believe a rider would be reasonable. But Mr. Thomas.
Yeah, I think what I talked about in my standalone testimony, that we did consider other options, but for reasons I spoke of before, the across the board, I think, is what we settled on as our final position, largely because it kind of shifts that relief, it front loads the relief to ratepayers, as opposed to delaying that relief to subsequent years. But again, like I said, I think the across the board adjustment and a refund rider that is not bound by the PIM monetary limitation, I think ultimately they both would provide needed relief to ratepayers. It's just a matter of when and the timing, and then the rider obviously has many more details that are really dependent on, the completion rates, how you track projects, how you count projects, how you establish the ratio of completed projects. Do you value larger projects more than smaller projects, or do you value them all equal? There are a lot of details to be worked out there. And so I think they could both provide that relief, but we recommended our adjustment for reasons we've discussed today.
And this refund rider that you've articulated this morning and identifies a particular option, have you presented that concept in your testimony in the upcoming DEP rate case?
In the upcoming DEP rate case, our testimony recommends a similar across the board adjustment.
Got it. And has public staff had a chance to discuss this rider concept with DEC in any discussions you've had prior to this time?
I would say this is something that's still internally being discussed with the public staff, and one of the challenges that we're seeing, it can be implemented, but as Mr. Thomas said earlier, I believe the devil's in the detail. And to the extent that we have ongoing conversations with the utility, I think we need to make sure that we're both on the same page, identify a methodology that is repeatable, consistent. And that way, when we come in before this commission within a rider, if everything is pre-described and defined by the commission, then we don't turn the rider mechanism into a mini rate case, because that would be the last thing that I personally want to do. But I think it can be done.
Understood. Now, and this is more of a clarifying question. It's not meant to be a legal one. So answer it to the extent you can from a policy perspective. Is it the public staff's opinion that refunds pursuant to this rider will be subject to the 1% PIM limit outlined in the PBR statute? Or is there a way to implement the rider such that you could refund more than that amount?
So I think the PIM, the performance incentive mechanism itself, is what's limited by the statute. As I said, I'm not an attorney, but my understanding is the commission has the authority to establish riders as it sees fit, I believe. Subject to check, again, not a lawyer, but we would envision this occurring outside of the PIM construct and therefore not bound by the 1% rule. Were this something the commission were interested in pushing for, that's what we would want to see.
I'm not aware of anything that's, again, not an attorney. I'm not aware of anything that is legally preventing this commission from creating such a rider.
Okay. And I'll shift on. Now, the public staff's recommendation to deny MYRP2 is because the public staff finds it is not in the public interest. Is that correct?
I think our testimony ultimately, I believe, recommends the adoption of the entirety of the public staff's recommendations beyond the stipulation into which we entered with DC and support. So the terms in those stipulations, we would recommend the commission approve that stipulation. And we feel that if the remainder of the items are resolved on the public staff's position, that does bring this PBR into the realm of the public interest. So I don't know that our testimony outright recommends denial of the PBR, merely says that as filed, it is not in the public interest and advocates for our position. But Mr. Metz, if you want to clarify.
I agree with Mr. Thomas, is because one of the things that through our review, again, we felt like the risk has been shifted over to the consumer. And so our adjustments in aggregate, believe, brings that back into equilibrium. So yes, the commission could find the PBR is in the public interest, setting the items that were already resolved through the settlements before the commission and adopting all other public staff proposals.
Thank you for that clarification. Now, the next few questions relates to the public staff's position on PIMS and DEC's performance in MYRP1. Now, Mr. Thomas, earlier on the stand, you mentioned conversing with engineers in the public staff's water, sewer, telephone, and transportation division about their timely completion metric. Can you elaborate as to why the public staff did not include performance metrics similar to those for water and wastewater utilities in its recommendations for DEC?
Sure, I can take a stab at that. I knew I was opening up a door there. But so I talked with one of the engineers at the public staff water division. And so my understanding of the timely completion metric in the water context is that it is a measure, kind of a byproduct project measure of completion. And if certain thresholds for completion are not met, the over earning band over which the company must refund under a earnings sharing like mechanism, I'm not sure what it's called in water, it lowers that band. So it reduces, so it doesn't actually refund money to ratepayers, but it will lower the band upon which a refund would be required if they over earn. And in this context, we do not have that ability because the over-earning band of 50 basis point is set by statute. In water, I believe it is a range, 100 basis point range, which is set. And so lowering that, I imagine that the commission approved that with the understanding that that was within the bounds of the statute. And then water also coupled that with I believe a budget PIM, a tracking metric that looks at how did you complete these projects relative to the costs that was estimated. But again, that was my understanding is that that is not a financial penalty or reward. That is a tracking metric, which may be expanded on in the future. So for those reasons, I think we kind of said, well, we can't take this exactly and implement it. And then if we looked at the PIM itself, again, we were worried about the 1% limitation. And if we saw a repeat of what happened in MYRP 1 occur in MYRP 2, it was possible that the entirety of the PIM penalty could be taken up by this one PIM, essentially rendering the other PIMs completely ineffective because they would not have the ability to maybe move that number up and down in a material way.
Thank you. Now, when Ms. Bateman was on the stand, she appeared to indicate that there wasn't sufficient participation in the PIM stakeholder process. Who from the public staff participated in the PIM stakeholder process, and how robust of a process was it compared to other kind of comparable stakeholder processes?
So as I'm sitting here in real time, I cannot recall the specific members and the dates at which they attended. From my perspective, with the first MYRP, it was the first of a kind. So I would think it's fair to say, from my observation, there was more engagement because there was more unknown. For purposes of this MYRP, I do recall early on conversations, and given the, not as an excuse, but given the course of work and course of pending matters, the public staff had to redivert its resources to other items. So it could be a fair criticism that the public staff may not have been as engaged as the prior process, but we also thought that we had a foundation point which to launch off of, therefore we wouldn't need to spend as much resource time.
And
Mr. Thomas?
Yes, go ahead, sir.
Yeah, I agree with Mr. Metz. I do not recall specifics about the meetings or the times, but I know I will state that, I think our PIMS panel, I think, accurately summarizes our opinion on Duke's proposed PIMS here. And I know that in the last rate case, Duke's rebuttal generally came out very strongly against. There were a multitude of PIMS proposed by different interveners, and I do not recall much give on that front in terms of adopting some of those PIMS. So, whether or not other parties chose to involve themselves in the stakeholder process, if Ms. Bateman says that the stakeholder processes were not robust, I have no reason to disbelieve that from where I sit here. But what I do know is there is a lot of work being done by PIMS nationally. There's many utilities that are adopting this or looking into this. We personally, the public staff, worked in the last rate case with the Rocky Mountain Institute to establish a PIMS database, which we shared with other interveners, and we've reviewed ourselves and shared with Duke. So, the thought that we need interveners to necessarily help come up with creative or effective PIMS, I think that's certainly helpful, and I've reviewed some of the testimony on PIMS here, but I would hope that in the second MRP that Duke would have looked at the PIMS that they had, maybe recognize that some of them were, rewarding behavior that they should already be doing, or not necessarily incentivizing new behavior. And we would have been nice to see some maybe more kind of creative PIMS or PIMS that they really thought would drive and incentivize behavior. But my understanding of the PIMS testimony is that the PIMS promoted or proposed by DC in this proceeding are not likely to result in incremental behavior and pushing them to do better. They're largely an echo of what was approved in MRP 1.
And I'll just add, I think there's a fundamental, I wouldn't say as far as disagreement, but maybe methodology. I always go back to the carrot or the stick. Do you do a reward or you do a penalty? And I'm not resolving that debate for purposes of here, but if you look at that, we should be driving behavior of the utility, but we look at how the MYRP 1 was actually enacted, and we look at this $1.1 billion. There's further conversations of the carrot and the stick that need to unfold. does the utility really need an incentive to keep the lights on while they're collecting money from ratepayers for this magnitude of costs that are incomplete? And then it gets into, well, what's the relative dollar amount? If we set PIMs at $100,000 or $200,000, is that really meaningful? Is that really going to drive difference? And then the other factor that is probably going to be brought up is, does it have to be symmetrical? I mean, I think that is a large debate that we brought forward this commission. Is it can be asymmetrical, but then the argument is going to become, well, is it upside to the utility or vice versa? So these will have to be ongoing discussions through multiple iterations of this. But if the commission were to issue any guidance on that, then I think that would help inform the stakeholder groups to, instead of casting such a wide net, to maybe do more narrowed focused discussions and seek resolution on pointed topics.
Now, the public staff's PIM panel opined that there were foundational differences between the performance-based metrics for wastewater utilities and PIMs for DEC, citing the 1% revenue cap as one concern. Mr. Thomas, you also noted this limitation in your direct testimony on the stand. Given the 1% revenue cap is directed by statute, is the public staff implying that a PBR will never be in the public interest unless the 1% cap is removed from the statute?
No, I don't believe we are testifying to that. I think we're just pointing out that for certain situations, the PIM may not be practical, right? So I think, for example, we looked at, I think our PIMS panel proposed like a cost control PIM that looks at, Duke's actual cost of completing certain projects and compares it to the projected estimate cost or the as bid cost. And so I think, we think that there is a way to design effective PIMs that operate within that 1% cap. But I think, Duke's performance in MORP 1 and then their proposals in this one, which I believe I wrote this down from the PIMS panel, it amounts to only about a quarter of that 1% cap. And so, the more incentive that's there, presumably the more Duke would be incentivized to operate in such a manner to achieve those PIM rewards. But when the rewards are very small and there are other countervailing incentives, then it becomes difficult. So certainly not an indictment of, and I would say that a PBR absolutely could be in the public interest, even with that 1% cap. It's really just about what kind of PIM can you design within that 1% bound.
All right. Now on page 7, in response to the question, do you consider the PBR proposed by DEC to be in the public interest? You include this statement in lines 13 through 14. We have found DEC's PIMs to be ineffective in achieving improved utility performance. At what level of incentive would the PIMs produce improved utility performance?
I can start. Yeah. So I think, and again, I'm paraphrasing a bit the PIMS panel, and I don't want to get out over my skis here, but I think what we're saying here is that the PIMs are ineffective at achieving utility performance. Is that in some instances we found that, for example, I know they spent some time talking about the TOU PIM yesterday. We identified, I think, in our review that, look, the TOU PIM rewards Duke for customers going on to the time of use tariff. And obviously there's challenges with that. But I think we found during discovery that very little in the way of marketing was actually spent on bringing customers into that fold. We recognize, I think, that net metering customers that are being forced through the net metering revisions to transition to the new net metering rider are being forced to also adopt a time of use rate, right? Which pushes hundreds of customers towards that rate, many more, thousands over the next few years. And so we looked at that and said, look, Duke should be encouraging people to join time of use. It's in their interest to do so to improve operational efficiencies. And they already have secured in certain dockets mechanisms to automatically force people into time of use rates. and they're spending very little on marketing. So obviously to us, that PIM is not necessarily effective, and it's not got anything to do with the cap or the dollars. I mean, maybe if the reward for getting more people on time of use was a 30% boost to the revenue requirement, then perhaps Duke would propose making time of use opt out, right? So that would be, maybe a pretty severe example, but in general, I don't think that the 1% cap is necessarily the reason why our PIMS panel came to that conclusion. But
I agree. It's kind of looking at the aggregate, and we're just looking at the overall monetary amount that don't relative to the billions of dollars that we've talked about previously. It doesn't appear to be really driving that behavior. I think I'm looking at it more of the lens. And again, this is our first MYRP that we went through, and the public staff had put some of these forward and worked with the utility. And I mean, some of this is our own investment into it, is just taking a step back and reflecting even our own work product. It's like, this didn't really work out what we expected. And we're challenged to see what we could do as proposed revisions, given what we're seeing in the relative magnitude of the case that's sitting before the commission, while we're also looking at the affordability concerns and the magnitude of spend that's also happening. Because if we start providing more PIMs to drive potential behavior, that will compound to the affordability concerns. That's just more cost that the ratepayers are having to figure out. So this is a challenge that the public staff is trying to continue to review. We haven't stopped. We haven't packed up our bags, but it is something that we're really trying to buckle down and look at.
Okay, give me 1 minute. Confer with some of my colleagues here. It's about the time we would normally take a morning break, but give me a sec. Okay, we go on. All right, we're going to go ahead and continue. One of the issues you identify with MYRP projects not completed timely is coincident accrual of AFUDC in receipt of revenues for depreciation and return of the same projects. Now, if the commission declines to adopt your 1.06 billion disallowance of MYRP2 costs, would it be possible to correct for this in the next rate case by identifying and disallowing a portion of the AFUDC for late projects?
This is where I wish I can phone a friend and bring one of my accountant panels back up here to get into more intricacies, talking about how the accounts would go through.
Answer it to the extent you feel comfortable doing so, understanding that you're not in a position to consult with the accounting panel.
I'll take a crack while Mr. Metz thinks, and he can elaborate. But I think if I understand correctly, you're saying when we're reviewing projects that were actually completed in the next rate case, and we're looking at an MYRP2 project that was completed, but it was late. And you're saying go into that project, and from the time it should have closed the plant to the time it did close the plant, figure out how much AFUDC accrued and disallow that.
That would be correct. That's my understanding.
Certainly that is an interesting concept, and I think that we could attempt to do that. I think that's not outside the realm of possibility. Whether or not it's I believe, I have no reason to believe it would not be in the commission's authority to approve such an adjustment. But I would say that that is just one portion of that issue, right? Because there is also the issue of the depreciation and the return expense that ratepayers have already paid during that time period within that rate year while it was delayed. So there's some factor there, and we have not yet kind of explored what that would look like if we were to try to disallow some rate base to reflect the fact that it should already be depreciated, or to refund some of that depreciation expense. I think we have argued along similar lines that that should be allowed, I believe, in the rate making revisions for R117B. So certainly I think it's something we can explore and look into. I do think we would want to have that that was something that the commission was interested or believed that would be a reasonable way in the next rate case to refund some of these funds. We would like that guidance in this order, because that would require, I think, setting up a special review process to comprehensively go through every single completed MYRP2 project in the next rate case and make that specific calculation.
That's where my mind is gravitating to. How many projects were in MRP2 for DEC?
About 1,200.
So 1,200 individual projects on a depreciation schedule that was set on this case. This would be layers upon layers of additional work. I mean, if the commission orders us to do so, we'll adhere, but you would create probably 1/3 of a mini rate case in itself to do this level of work to track every project on those different buckets that Mr. Thomas talked about. Then while also comparing it to more likely and not changing depreciation rates for that rate case that's sitting here before us. So it could be a logistical bottleneck.
It sounds as if it would be potentially challenging and burdensome to do so.
And likely highly litigated.
Although, just to reiterate, I think if the commission decided not to approve our across-the-board adjustment and the commission decided not to implement a timely completion rider, then, certainly I think we in the next rate case would do everything we could to try to get those funds back for customers, litigated or not. And if that was something the commission would like to see, we could do that. We just feel that that is not the most ideal approach for what we are trying to do here.
Got it. Not optimal. Now, in a public staff's investigation, did you identify any deficiencies in MYRP 2 application? And I guess in terms of a subpart of that question, are there specific projects in MYRP 2 that the public staff's opinion are not in the public interest?
Well, I think we identified projects, some of which have been resolved through the overall settlement. I can't remember the comprehensive list as I sit here right before me. Do you recall, Mr. Thomas?
Yeah, I think, for example, my direct testimony discussed the need to scale down some distribution spending as unreasonable and excessive. Obviously, we settled that and removed the equipment retrofit program. But the overall, I think we did not make significant recommendations. There, yeah, thank you. Yeah, so there were multiple adjustments as shown in our Exhibit 4 on the MRP. We obviously thought that the inclusion of contingency at that time was not reasonable for rate making. There's other adjustments such as the Blues Creek grant, Clark Creek, some other adjustments there that were made. But for the most part, I think we our witnesses testified as to the kind of reasonableness, and many of these projects are reasonable. They're far along, and we have worked very hard with and DEC has worked very hard to provide us with documentation, which in some cases helps us identify what alternatives were considered, and what the problem is, what's going on. And we've sent voluminous discovery on this. So I think for the projects that we reviewed and not recommended any adjustments, certainly we find those to be reasonable. I don't know that we've made any particular judgments on MYRP investments being in the public interest or not. It's really just, are they reasonable? Are they needed? But our testimony here talks more about the public interest of the PBR as a whole.
So would it be fair to say that public staff's objections to MYRP 2 stems primarily from its impact on rates?
No, I think it's much more deeper than that. I think one, it's our concerns to the ratepayers that we have shifted the risk to the ratepayers based upon the company's actions of MYRP 1. So we're trying to bring, from our view, the risk back into equilibrium. Is like, if based upon past performance as a proxy, we're going to recommend that ratepayers don't recover this cost at this time. And whatever the cost is, you can get that in the next general rate case. I mean, in relation to the $1 billion adjustment, Mr. Thomas, what was that in terms of scale? 10%, 15% of the overall MRP?
Yeah, it was about 30%.
30%,
Yeah.
okay. So 70% of the cost, based upon our sample, we're saying it's okay, albeit a few minor adjustments around the edges for specific projects that we identified is okay. But as long as the commission were to agree to all the other public staff's recommendations, which again, kind of brings it back into alignment, what we think is a reasonable risk and a reasonable rate that ratepayers should pay.
Understood.
And if I could just maybe add a little bit, that on page 8 of our testimony, we discuss the benefits from PBR that DC put in its initial application. And I think our main problem with this is that these benefits are not well quantified, and we don't necessarily agree with them. For example, allowing the utility to make significant investments in terms of improved reliability and resilience. Well, as we've seen from the scale and scope of the shadow MRP, they are not bound by this MRP, the PBR, and they're more than able to make investments outside of that. Providing customers with rate certainty. As we testify, I did not hear a single customer talk about how the large increase, 4%, 4%, large increase, 4%, 4% pattern of rate increases from the MRP was providing them any benefit or surety. Approved operational and financial planning was not well justified to us, as for some witnesses testify or let us know that the approved MRP projects do not necessarily play a role in the budgeting process, right? The budget is set. Some projects from that budget are placed in the MRP, but the budget continues at pace. Incentivizing reliable and efficient operations through PIMS. We've talked at length about how we don't believe that to be incentivizing those behaviors. Improving transparency through quarterly reporting requirements. Certainly, that's one I probably agree with. Those quarterly reporting requirements on projects are helpful, but I don't see how ratepayers are necessarily benefiting from that. And reducing the need for more frequent rate cases. We've talked, I think, at length and testified at length about how rate cases expenses are particularly high for these types of cases, in part due to the voluminous test discovery responses that are required. And, in addition, I think it's this cadence that we're in and the way that we are stretched thin, right? I think for the most part, the public staff is one of the only interveners in these proceedings that digs deep into the historic investments for prudence and reasonableness, right? Most other interveners take a lot of their time on ROE and, in this case, large load. So I think we are kind of doing that on our own for the most part. Not, sometimes others do, but we're the primary agent there. So we just don't see their benefits that they're stating as outweighing kind of this push and pull that we've been discussing here about risk and costs and the ability to properly investigate.
Well, is there an ROE adjustment that could be grounded in this experience from NYRP 1? And the notion that if it shifted risks to ratepayers, that was not captured in the proxy groups, was it?
So I would need to defer that to the ROE witnesses in terms of the proxy group. I'm looking for the note where Mr. Fahey, where we reference Mr. Fahey. I don't know, Mr. Thomas can help me find that element.
I mean, to the extent you have an opinion.
I guess I believe that the ROE witness in this case, the recommendation that we made with respect to ROE is attempting to account for the proxy group as well as MYRP adjustment. I think we explicitly call in our testimony there for the commission to approve that ROE, and that would reflect, I believe, that adjustment. Subject to check. I hope I'm not misstating the ROE witness.
I recall a discussion. I can't find the footnote, but I believe Mr. Fahey discussed this in his testimony on the amount that could be an overall ROE adjustment, noting that we are not ROE.
Exactly. I do recall something to that effect. Now, in terms of these late projects, would the work be reduced with some level of reporting by Duke on late projects, something that provides more clarity, specificity, information on an ongoing basis.
I may need a little bit of help to connect the dots here. I'm trying to, when we get into a general rate case, we review the reasonable and prudence and the need of whatever's sitting here before us of the historic projects. So, Mr. Tom.
I would say that just regarding late projects, MYRP projects, I believe that the quarterly construction reports, which DEC files, and they provide us with a more in-depth kind of spreadsheet that kind of has a project by project breakdown by function, which is a little different than what's actually filed. I think it's just more detail, current estimates, what was spent in the last quarter, estimate of completion, in-service date approved. I mean, the quarterly reports that they file already, I think, provide approximately adequate information that could be used as the basis for some sort of timely adjustment rider in the future. And I would not say that, subject to check, I don't think that report could be improved much. I'm actually quite satisfied, I think, with the quality of the information that's provided on a quarterly basis by DC already, and don't see a need to significantly change that to improve.
So what is coming in is adequate. No need for additional level of reporting. It's just
yes.
the issues that are presented by the late completion of the project.
I believe so, yes. The quarterly reports are very good.
What I'm going to do now is go ahead and do our morning break. It's a little bit delayed. We do have a few additional questions to go through. It's now 11:18. We will resume at 11:28, 10 minutes. Thank you. doors to the hearing room. All right. Thank you, gentlemen. At least you've had a chance to collect your thoughts. We have a few more questions, not many, but ones that our commission staff is interested in getting responses to. Now, DEC argues that a core function of the multi-year rate plan paradigm is to better match revenues to cost, or put another way, to reduce regulatory lag. What is the public staff's reaction to DEC's argument?
I mean, I think that is a reasonable conclusion to the extent that the utility is making expenditures and that the cash flow is coming back in at the same time period. And yes, and I think that is enabled by PBR MYRPs in North Carolina.
All right. Now, is it your view that the NYRP paradigm is in fact accelerating rate increases because it enables Duke to build out its system more quickly? And if so, would you have the commission balance this pressure with the company's needs to timely recover necessary and prudently incurred expenditures?
So there's two parts to the question. Mr. Thomas, jump in. I think the public staff's overarching concern is that the MYRP has enabled the company to make more expenditures on the system. And speculation from the public staff's view is that it has enabled the company to make more expenditures. The challenge that we're seeing, me and Mr. Thomas, we are not responsible for maintaining the electrical system and providing services to customers. The utility is. But our concern is the pace of deployment of these resources needed. So, for example, I think Mr. Williamson said something along the lines of distribution spend $1 to $1.1 billion a year, maybe $1.2 billion a year. Could that value be 900 million? Could that value be 700 million? Could that value be 1 billion? We're not disputing that investments are not needed in the system. What we're challenging is giving the factors that have changed since we started down this path. Inflation, world events, generation plant increasing very much in cost, load coming to the state. Should we be making different investments into the system that are more beneficial to the body of the ratepayers while balancing the costs being imposed onto them? Mr. Thomas wants to add anything.
Yeah, I just think this rate year is happening. This case is happening at the same time a lot of other factors are happening, right? We see that Duke is needing to build billions of dollars worth of new generation assets to meet demand. Natural gas, solar, storage, uprates across the natural gas system and hydro system, all to meet growing demand that's growing rapidly. We have an aging and somewhat deteriorating distribution system that is needing to be upgraded. We have a transmission system that needs an overhaul in order to accommodate the new load and the new generation. And in addition, on top of all this, we're dealing with inflation that has hit the construction and electrical component sectors particularly hard. If you look at just CPI, you're not capturing the full image of the amount of inflation that has been touching every aspect of these technologies. Interest rates as well are a factor, right? So I think our perspective is there is not an infinite appetite for rate increases from consumers, residential, commercial, industrial. And so when Duke is looking at making all of these investments, right, I think we are just recommending that, as Mr. Metz said, the pace and the priority of those adjustments be given a much closer look than you otherwise might have. If the cost of distribution transformers had not increased by 70, 80, 90% over the last 5 years, then yeah, maybe we should continue our transformer upgrade program at the same pace as we did 3 years ago. But it's not that world anymore. We're seeing these higher costs. And so a lot of what our testimony is emphasizing is that, the public outcry is significant, and there are ways we believe that the future and planned investments should be scaled down, should be slowed up, particularly around areas where, we have some, potential redundancies, like, for example, in distribution, the stipulation removed equipment retrofit program, which would replace existing infrastructure that is not at end of life, is not proposing any safety issues. And so let's just take that out. Let's slow a little bit down on that type of spending so we can focus our dollars and the, ultimately limited capital available to these types of initiatives on the things that are really going to make sure that service stays reliable at the bulk system level, that we have enough generation to meet load, and that we're providing a reasonable level of service quality to customers.
And I expand in this. So if you go to page 24 in the confidential section, I'm not going to read the confidential section, but to the commission is, I think the overarching concern is you look at page 24, line 24, and read that statement, and I'll pause. So page 24, line 24.
Yeah, give me a second to get there. Okay, you may go ahead and proceed.
So keep that in the back of your mind. So when we're looking at for Duke Energy Carolinas, and now that we filed our Duke Energy Progress case, I've compared the 2026 to 2030 capital expenditures. So how much money is the utility planning to spend per year? And identified it by 4 groups, and this is in discovery, between production, transmission, general, and distribution. For Duke Energy Progress, the amount of money spent in production is 57.5%. And DEC is 59.8%. Transmission, DEP, 12.1%. DEC, 8.9%. In my view, a reason that is slightly shifted to Duke Energy Progress is a function of, more likely than not, the red zone projects, because the red zone projects just were more located in Duke Energy Progress. General, DEP, 3.5% to DEC's 3.9%. Distribution, 27.1% to DEC's 27.4%. When you look at the relative CapEx spend from 2019 to 2030, the utilities are within 1% of one another. So when you look at that statement on page 24, is my concern that is driving the spend in these categories that are too near in alignment. The utilities should be separate. But if there's direction provided, these are what the numbers are demonstrating to me. The compound annual growth for 2 independent utilities on CapEx should not be near identical, nor should the spend per specific categories in the utility be near identical on this much of a difference on operating systems.
But they'll be consolidated soon.
They'll be consolidated, but to the extent that what is driving the rate increase, should things be slowed down versus driving what was listed on page 24? That is a concern of the public staff.
Understood and duly noted. Going to shift gears a little bit. Your testimony generally classifies non-NYRP capital spending as shadow NYRP. Is that correct?
Could you please restate the page, Mr. McKissick?
There was not a page number presented. It was just kind of the concept of this shadow NYRP. And maybe you can elaborate a little bit further on the way you use that terminology in your testimony.
So I may be the genesis for that statement. I think there may have been not necessarily a misunderstanding, but not full clarity, is that when going into this, going back to MYRP 1, is that there may have been understanding that these were going to be all the capital expenditures that the utility expected to complete. And that was at least my perception going into it. Going back in time, I was like, okay, the company's going to outlay its entire plan. We're going to see what is reasonable, what is not reasonable. But what we quickly learned through the process, I believe your reference to something to regards of there was a parking lot of projects, and MYRP 1 through a review, it was the first MYRP. The moment that we were started honing down is like, well, this project really doesn't look needed. And we start going down discovery, second set, third set. Not all times, but the company would come back and reply comment or discovery say, oh, we're pulling that project. We're pulling that project. We're pulling that project. Here's a different project. Now, granted, the rulemaking that we've had since that filing has helped address the substitution element. And thank you to the commission and working with the utility to resolve some of these conflicts that we're having. Is that the magnitude of non-MYRP projects became concerning because we said, hey, when you come into the next rate case, this is actually going to be a sizable rate increase. Couldn't tell you the exact percentages, but it looked to be alarming. And we just wanted to make sure the commission was cognizant and ratepayers are cognizant and interveners were cognizant that there is still additional magnitude of spend that is not collected within the confines of the MYRP. And so, yes, coined it as the shadow MYRP, it is non-MYRP projects.
Yeah, and just to elaborate, because I did read the rebuttal, I don't believe that the public staff that Mr. Metz was attempting to apply necessarily a nefarious nature to the MYRP. It's just simply your MYRP is walking and that there is a shadow of additional spending that is not necessarily disclosed or extensively discussed in the application, right? Because DEC is not requesting recovery of non-MYRP or shadow MYRP projects that it knows that it will be completing in 2027 and 2028. They're not requesting recovery in this, so they don't discuss it. So we're trying to highlight it, but certainly not trying to imply some sort of nefarious. DC did not hide these investments from us. They openly shared their CapEx plans with us. So nothing nefarious. The non-MYRP spending is equally valid term. It's really just the terminology is just, it is spending that is occurring simultaneously, walking alongside the MYRP, and it all gets recovered in the next case.
It's just nomenclature that
Just
you
nomenclature.
choose
Just nomenclature.
to identify and segregate that type of spending that's not on RRP.
Yeah, I mean, in economics, there's a term called the shadow price. That's not a nefarious term. It's just
Right.
the economic term. So
Would denying the MYRP have an impact on public staff's ability to audit DEC's capital spending?
No, if the commission were to deny the MYRP, when the company comes in for its next general rate case, we would complete our normal investigation.
Would denying the MYRP increase DEC's reliance on outside capital to fund capital projects to the detriment of ratepayers?
I do not know for certain that magnitude. I would say that the company may actually have an incentive to reevaluate its CapEx spend and potentially slow down the magnitude that needs to be spent to balance those factors.
Okay, now the next few questions relate to your proposal for splitting rate case expenses 50-50 between ratepayers and shareholders. Why are you recommending an across-the-board split instead of disallowance of a more particular rate case expense?
No, that's a fair question. So, I mean, the core of the argument from the public staff's view is that filing a rate case helps shareholders and as well as something that ratepayers should pay for. So the public staff is not saying we shouldn't pay for any of the costs. We're just saying on face value, it helps the utility and it helps the ratepayer. I mean, for example, this commission was cognizant during the company's ROE cross-examination. I don't know if the commission was aware of the amount of counsel that was from the utility sitting in this room. And the commission you can find a general proxy, you can look online and say, okay, what is the average cost of attorney? Then, okay, $400, $500, $600, maybe north end, just public information, not saying that is what the charges are. So, okay, if we had 10 outside counsels in here, again, as a hypothetical, to defend the company's 10.9, 10.95 ROE in their ask, was that reasonable to begin with? I mean, there are charges by the utility and rate case expense just based upon the nature of their ask. But again, going back to the public staff's overall adjustment, that we find that rate case expense and the ultimate outcome of a rate case helps both shareholders and as well as the ratepayer.
And just to add to Mr. Metz's response, I wanted to highlight, page 29, we discussed briefly, the accounting panel did recommend a specific disallowance to the rate case expenses related to the sub 1276 rate case appeal. And in addition, on page 33, we do discuss the difficulty in auditing these expenses for prudence, right? So I think we talk about the thousands of line items that we receive, many of them kind of representing a subjective judgment, the time and effort that was spent on that. The advice and client communications of attorneys in a litigated matter are often subject to legitimate claims of privilege and are therefore difficult to review. So while we did make one specific recommendation in our accounting panel, we do want to just highlight the difficulty of reviewing these costs for prudence and reasonableness. And that's in support of our overall argument for sharing, which is not based on an imprudently incurred rate case expense, but rather based on this concept of the benefits being shared and that those that benefit from the rate case should help pay for the rate case.
And then my next question is kind of a two-part question. I mean, I know Mr. Metz, you just identified, potentially 10 attorneys theoretically that might be here dealing with ROE or whatever that issue might be. And there's so many issues that are so complex. Are you suggesting or recommending that rather than Duke or DEC using outside counsel for rate cases, that they basically have in-house counsel doing the work instead? That might potentially decrease hourly billings and totality of cost.
That is a very fair observation. And I shared that with you, Commissioner. I think that the company should go back and evaluate the cost savings potentially to ratepayers on looking at internal staffing levels to find that equilibrium.
And are you aware of any other jurisdictions that have adopted this idea of splitting rate case expenses 50-50?
Yes, and it's escaping me those examples right now. I can't not recall them as I sit here.
Okay. Now the commission rejected a similar request to split rate case expenses in a recent Aqua rate case. I think it was W218 sub 629. What evidence is the public staff presenting in this DEC rate case that is sufficient for the commission to come to a different decision?
Yep, that's why I get to be the director. So I think the public staff would humbly disagree with the commission's conclusion on that case. That why I did not work specifically on that case, it'd be my understanding is we just have a fundamental disagreement with the commission. So we presented this back before this commission in this case to outlay our position again and to try to clarify the parts which we may not have been in alignment. I mean, for example, looking on page 31, line items 3 through 7. While I'm not an attorney, I believe that the commission does have the discretion to fix such rates that shall be fair to both the public utilities and to the consumer. And so this equity sharing, now we proposed 50%. I would say it's fair criticism to say, well, why isn't it 51%? Why isn't it 23%? We just thought it would just be equitable to keep it specifically at 50-50, but other factor could also be applied. I just don't have that mathematical derivation.
So it was kind of an idea of intrinsic fairness that led to 50-50 as opposed to some other allocation.
Yes, sir.
And I would also add, we do discuss in our testimony, I think, some of the challenges and concerns about continuing to assign 100% of the rate case expenses to ratepayers, right? I think on page 35, we talk about how some of Duke's measures like ongoing requests for proposals for new legal services are not necessarily effective because we see that they continue to contract with the same firms and it's difficult to they have no actual knowledge of if this substantial discount that they're receiving is indeed a discount. We talk about the the observations we've made on page 36 about about the outside counsel, highly paid lawyers, including the highest billing lawyers, just performing discovery tasks. And we're just talking about how much is involved in that process, right, for those outside counsel. And so, and this complexity increase is being driven by statute. So I think we have genuine concerns that, these rate case expenses, that when Duke is allowed to pass them all on, given our difficulty in auditing them, the claims of privilege that are legitimate that make it difficult to audit, and the scale and scope and subjectivity of the decisions made, is coupled with the inability to for Duke to really check and verify that they are getting the most competitive outside counsel. All that combines to say, look, there's no incentive here for Duke to decrease or control or put tight measures on its rate case expenses. A 50-50 sharing mechanism would not only be equitable, but it would also help establish a check and an incentive for Duke to reduce those expenses, which would be, I believe, in the public interest.
And then further adding, I think on page 35, and it's the confidential section of it, starting on line 17 through 21. Of it, that is concerning.
Duly noted.
I don't want to get into too much details.
No, I understand. Well, thank you. Let me see if my colleagues have additional questions. Chair Brawley?
Yes, thank you, Mr. Presiding Commissioner. I want to start with one of the last things that piqued my interest, and that was the spending on distribution. And I think one thing you said, you were talking about how there were similar amounts between the two companies. How much are those amounts determined in rate cases? And that spending set by this body rather than the company?
So I'll start out with, and Mr. Thomas jump in, is that the values that I listed was the CapEx spend in which the utilities are planning to spend, in my understanding, not of discretion not direction by this commission. This is from again, my understanding is that from the corporate level, Duke Energy, these are the funds that are allocated to Duke Energy Carolinas, and these are the funds allocated to Duke Energy Progress.
Okay, that answers it. But one thing, there was a discussion yesterday where spending on distribution has been going up, but reliability has been going down. And there was some argument about, well, was the money being spent poorly? But I also wondered, could that be evidence that the money was insufficient, that the system is getting older? And then you also mentioned today that the billions of upgrades that are needed with inflation in the supply chain, that those costs are going up significantly. If we make fewer investments in distribution, both expanding it for new customers moving into the state, as well as areas like my own neighborhood in Matthews, where farmland is being turned into houses, and systems that supported 1,500 houses and built that way 20 years ago are now going to have to support about 4,000 houses. That's going to require upgrades as well. If we start trying to kick that can down the road, how much would that have a negative impact on reliability?
So I'll start out there. I mean, those are very fair observations, Commissioner or Chair Brawley. I think that I mean, there's one conversation to go back is why these are the conversations that at least I have internally, is why did we wait so long to make these investments? Why did the utility wait so long to make these investments? Maybe in hindsight, they should have been making the investments in 2014, 2015. maybe in speculation and as a hypothetical, maybe they elected not to because they weren't approved for their Power Forward program. Well, because they weren't approved for a program means they mitigated investments that they need to make into a system. That raises potential concerns. So where I'm going with that thought process is that it's fair to look forward looking, but it's also reasonable to look backwards looking of how did we potentially get in this predicament. But none of us can change time, and we have to look what's going forward. So it's looking, well, how do we build a balance of the minimum electrical service required to ratepayers? And so with that in mind, why balancing affordability, do we have to necessarily include as many elements of sophistication? Perhaps, and I'm not advocating for this, but perhaps we don't need self-optimizing grid deployed at the pace of which it is being deployed at. Perhaps there's sub parts of programs that could be delayed, as Mr. Thomas talked about. The one program is which we ultimately settled with the company for purposes of the MYRP revenue requirement. There's pieces that could be be slowed down.
Yeah, and if I could just add a little bit, I think Witness Guyton discusses in his direct the breakdown of historic distribution spend. And if my memory serves me right, his analysis shows about 27% of the distribution spend since last rate case is related to new customer growth. So that is already taking up a significant portion. And obviously, the standards to which those new customers are served are higher than, different than a customer whose house was built in 1980, right? So we can assume that those new customers are already getting the automatic lateral trip devices and other quality improvements that are going to maintain them at a higher level of improvement than perhaps the system average. But that's already a significant chunk of that spend just to meet that new growth, those new customers. I think about 9% is related to capacity uplifts. Now, while Witness Guyton classifies 25% of the investment as related to reliability, when I found digging into the integrity and maintenance investments, the other 31%, a significant portion of that to me looked like reliability focused investments. So I think my analysis said that I did not include it in testimony, but reviewing his analysis, it was more like about half of the distribution spend was at least tangentially related to improving reliability. And so I think to your question about maybe they're just not spending enough, I think one big driver of the increase in distribution spend is the simple inflation. If we had to rebuild the grid today as it was built originally, it would cost us significantly more because inflation has outpaced in these devices so quickly. And so I don't know right now, sitting here where I stand today, whether throwing more money at the distribution system would cause increases to system reliability versus the kind of flat to declining that we're seeing. But what I do know is that there is a limit to what ratepayers are able to bear, and throwing more money at the distribution system to shave a couple points off of a couple minutes off my SAIDI, I don't know that the customers are necessarily willing to pay that. I think we're seeing an outcry of the rates. And I mean, these are significant rate increases, right? As filed, I think 18% for residential over 2 years. I mean, on top of the increases we've seen from the last MYRP, and these are very significant. My bill personally has gone up by quite a bit since I've been here at the public staff. 2 kids might have something to do with that. I'm sure Duke would tell me, but I think that's what we're looking at, and that's what we're concerned about. And I think that there are absolutely investments, particularly in distribution, that can be scaled back, that can be slowed down in the interest of balancing the quest for, reliability, because you can never build a perfectly reliable grid. And if you are trying to do that, I'm going to stand here and say you should not be doing that. You have to accept some level of outages, some level of disturbances, if you want to balance service quality with costs.
Okay. I want to shift gears a little bit and go back to where we started, and the idea that PBRs and the MYRP is not in the public interest. And there were several things that you say that if the commission included would bring it more in line with what the public interest would be, in your opinion. I think I understood you to say that some of those things you recommended are not included in the stipulation. Is that correct?
There are still unresolved issues that are before this commission as we sit here right now.
Are you encouraging the commission to not accept the stipulation as written, but to include your additional recommendations?
The latter, we're saying adopt the stipulation for those items which are resolved, and the items that are still pending before this commission, we would advocate that you align to our position.
Okay. Now, in a lot of ways, it sounds almost like PBR, MYRP, we shouldn't be doing at all, but that's the law. How much are you encouraging the commission to ignore the North Carolina general statutes?
So in my understanding is that the PBR MYRP is permissive. It is the election of the utility. There's nothing preventing the utility from filing a general, or what we refer to as a traditional rate case. The company can elect to file as general rate case, because what we tried to balance is saying, I believe Mr. Thomas had spoke earlier, that on a revenue requirement, approximately $83 million were recovered on a revenue requirement for each year of the MYRP, which resulted in approximately how much per customer, Mr. Thomas?
About $2.
About $2
per month.
per month. And say, well, what if, and that was just for the incompleted projects that they paid into rates. Well, if the utility were to file a rate case, let's just say hypothetically, the company was to file a rate case every year, as painful as that will be, I have to look at it, is that in the interest of the ratepayer? So if I have an annual rate case expense of 10 or $13 million versus on a revenue requirement that we paid much, much north of $13 million, our estimates is around $80 million, it is more advantageous to the ratepayer in relation to their bill to actually file a general rate case every year. Mr. Thomas?
Yeah, and just to be absolutely clear, we are not recommending that the commission ignore the General Assembly. The General Assembly had the foresight to consider this very matter when they designed the law. So 62-133-16, section D1 says that the commission shall approve a PBR application only upon a finding that a proposed PBR would result in just and reasonable rates, is in the public interest, and is consistent with the criteria established in this section, and says the commission shall consider whether the PBR application assures that no class or class of customers is unreasonably harmed, and that the rates are fair both to the electric public utility and to the customer, reasonably assures continuation of safe and reliable electric service, and will not unreasonably prejudice any class of customer and result in sudden substantial rate increases or rate shock to customers. So I think, in my opinion, just to add on to what Mr. Metz is saying, the commission has discretion to both make adjustments to the revenue requirements sought to bring the PBR in line with the statutory requirements of the act of HB 951.
So as Mr. Thomas pointed to, one of the items is rate shock. If this commission, again, as the hypotheticals we're sitting here in real time, is if this commission considered Duke's ask as 18% as rate shock, as I said here right now, we believe this commission has discretion to modify that value.
Well, I completely agree. We would be allowed to avoid rate shock, but you also mentioned reliability. And we would also have a responsibility to make sure the plan we approve, in our opinion, assured reliability. So we got a lot of balls in the air here.
Absolutely. And I think that just lends, I think, support to, our stipulation. We believe the resolved items would continue to maintain reliability, and the unresolved items, such as the appropriate return on equity and cap structure, and those are levers the commission can pull without necessarily removing what you may believe, what you have concluded to be reasonable investments necessary for the continuation of safe and reliable service.
Well, I know, Mr. Thompson, you know as well as we do that while this 3-week process is going to be, or seem to be very onerous, that's when the real work begins. And for the next couple of months, we're going to be working just as hard on all of this, sorting all this testimony out and balancing.
That's right.
So thank you for expanding your answers, Mr. Chairman. I am done with my questions.
Thank you, Chair Brawley. Commissioner Tucker.
Thank you, presiding Commissioner McKissick. A lot of my questions have been answered. Just in your testimony, the PBRs were authorized in 2021.
I believe so.
2021, 2022, when they filed versus when.
Page 4, line 18 of your testimony.
Yes. 2021 was the passage of the general statute.
Okay. Do you consider the PBRs a success? I think that's been answered, but just clarity, yes or no. Are they a success, and are they productive for the ratepayers and the utility?
I'd say Duke's implementation of MYRP1 was not a success in the public's SU.
Okay. Switching horses on the PIMs, do you find those to have performed in what the beginning thought process was to motivate the utility to complete projects?
1 second for Mr. Thomas.
So I think, and as far as completing projects, I know that we had one PIM in MYRP1 that was specifically related to ensuring the timely construction and interconnection of new, I believe, solar resources compliant with the carbon plan. Is that specifically the PIM you're talking about, or are you talking?
Correct.
Okay.
Yeah.
I'd have to look more in detail at the PIMS panel, but my understanding is that there was no reward for that particular PIM. There was no reward available in rate year 1, and I do not believe they obtained their reward in rate year 2, subject to check, although I'd have to reference their testimony. Whether or not it actually incentivized behavior, did the promise of that PIM get Duke to act more expeditiously with interconnection agreements and constructing transmission infrastructure? With my testimony here before me today, I can't say. The PIMS panel might have more, and I know we sent some discovery on these PIMs and how they incentivize, but not meeting that PIM, I think, is at least suggests that the behavior that was necessary to meet that PIM did not occur. There could have been extenuating circumstances, and I'm sure that there were, but sitting here today, I just don't see that those PIMs in MYRP1 had the desired impact.
Okay. On page 9 in your testimony, it states that recognizing MYRP 3 has not concluded, but your analysis of DEC's MYRP 1 RY1 project shows that only 62% of all the RY projects were complete.
That's correct.
Okay. Does that mean that the ratepayers are burdened with paying 38% depreciation? On the rest of those projects that are not completed, are they paying depreciation on those projects?
Yes. So
not in service,
not in service.
Completed, not on schedule, but yet paying depreciation now.
That's correct. So yes. So for example, across rate year 1 and rate year 2, the authorized amount was 4.7 billion. What was in service at the end of rate year 2 was 3.6 billion. That kind of yields that 1.1 billion gap we talked about. That's projects that in rates for rate year 2, ratepayers have been paying it.
Okay.
They aren't in service. And that revenue requirement from that is in your bill. And I think we estimated for a residential customer with 1,000 kilowatt hours a month, that would be about $2 a month.
based on that same scenario, the shadow projects that you mentioned, what's their amount and is their depreciation included in the rate base as well? That are
So
outside the MYRP.
non-MORP, shadow MORP projects, they are not, if they're not completed, there's no recovery. With some exceptions, there's some rules about recovering construction work in progress associated with baseload plants and things, but on the whole, Duke does not start to recover depreciation and return expense for a capital project that is not included in the MYRP until it is placed in service, and then they come in for a subsequent general rate case.
Is there a true up for ratepayers for projects that are not in service, or is there any delineation there at all? If they put the projects on the books, they start paying depreciation and there's no true up?
No, there's no true up. So, I mean, consider a hypothetical where a utility comes in with $100 billion worth of projects, they complete none of them. In the next general rate case, they would collect all that extra money. In the next general rate case, they would have no additions to their rate base. So the rates would come back down to where they were before, but there'd be no clawback mechanism for all that. Now, it's a very simplistic example, and that's obviously not what's happening here, but there's to date no mechanism to claw that back. That's what our across the board adjustment attempts to do, is to say, well, we can't claw that back, but looking forward, we're going to project our experience with these dollar amounts that ratepayers have paid onto the next MYRP. And then obviously we've discussed all their alternatives that might achieve a similar effect today, but that is our current recommendation.
Okay. Just changing horses a little bit in my last question. What were the advantages to going to an MYRP that were projected by Duke and perhaps even the public staff and the commission? What were the summation of that? Time saved by doing it once every 3 years, et cetera, et cetera. Can you explain those advantages that were promoted when the first MYRP was done?
So going off memory, I believe some of the potential savings were, if you look at the lens of if the utility had to file a rate case every year versus the lens of let's just file a rate case every 3 years, yes, there would be rate case savings. But going off memory is that we've seen rate case expense exponentially take off. The challenge that we see is that, well, now that based upon Duke's performance of MYRP 1 is that the magnitude of rates of which projects, the magnitude of rates which customers are paying for projects and were not completed, I don't know if it was fully contemplated when we started down this path. It's just the orders of magnitude of the impact of ratepayers is far outweighing the benefits of at least rate case expense in this relative example, Mr. Thomas.
Yeah, and again, I've participated in a few over the years, working groups and stakeholder meetings about PBR and about MYRP. And I think one aspect of it that's a promising aspect for that is that it helps utilities recover small, quickly built, quickly closed projects. So in the past, right, when we would have a rate case every 10, 15 years, utilities would generally be able to spend little enough on capital investments in distribution and transmission where they could essentially stay out until they completed a large generation unit. And then you close a large generation unit, you come in for rate case immediately after that to adjust your rates to reflect that addition, and then can stay out a little while. Rate cases have been getting more frequently, and one benefit that is often talked about is as the distribution system and to a lesser extent the transmission system need to be built out. These are not, billion-dollar projects. These are little substation work that's $1 million here, $1 million there, $3 million there, and they build up quickly. And it's harder for utilities sometimes to, I think, figure out the right time to come in, or you start to get into this frequent rate cases. So if I'm remembering some of the meetings we had, stakeholder meetings about MYRP and PBR in general, that was one aspect of it. I think before the MYRP came about, right, Duke had come in and requested a rider for distribution spend, which would have accomplished much the same thing, allowed them to recover those distribution investments quickly without the need for a general rate case. So I don't know if the commission's denial of that rider and the implementation of PBR and MYRPs is related, but I do know that they are, I think, helping in that one specific aspect in a similar manner.
Okay. The MYRPs that have been improved, what's the length of time for those? What you said there was two, right? One before I got here and one since I got here?
So there was MYRP 1 that had 3 rate year 1, rate year 2, rate year 3.
Right.
We're almost at the tail end of rate year 3. And then sitting before here right now, it's MYRP 2, which is only consisting of 2 rate years.
Well, I know due tradition to commission, there were some objections by interveners to go from 3 to 2. Do you have any conjecture or opine on why they wanted to go to 2 years?
I think that,
Versus historically, it was set up to be 3 years.
I think that I think the concept or the thought process was, at least where I'm sitting from, was to leverage the savings from the merger, and the merger was successful. So let's come back in as reasonable or quick as possible. And by only doing a rate year 2 rate years would allow us to come back before this commission to start addressing those inequity issues between DEC and DEP and start on the next evolution of that journey for the rate migration that's going to take multiple rate cases.
Okay.
Yeah, just to maybe add on that too, I think one of the benefits of a PBR is, this kind of stay out provision. You come in for a rate case and then you have a predictable set of rate cases for the next couple of years. In North Carolina, it's a maximum of 3. And this is 2. But I mean, you can imagine a hypothetical where the utility is coming in annually for a 1-year MYRP, right? So you aren't actually saving any rate case expense. You are having a system where you're increasing rates before things are placed in service, and then you're just coming in the next year and kind of continuing that process. And you're being able to continually avoid the 4% caps, right? Because remember, those 4% statutory caps and rate increases
right.
only apply in rate years 2 and rate year 3 if there is one.
Right.
So I'm afraid that we probably, because of the shadow MRP, are going to be facing a pattern of rate increases in North Carolina that is going to be consisting of a single year significant jump, followed by a 4% jump, and maybe another 4% jump, and then the next year, as we resolve the next rate year, we'll get another significant jump, followed by a 4% jump and a 4% jump. So I understand where that concern comes from, but I also understand why the 2-year was chosen in this instance. It, I think, had a lot to do with the merger and the desire to be able to start to align those rates between both companies.
But if granted by the commission, it could be a 1-year big jump and a 4% cap. And then with the 2-year plan, it could be, instead of it being the 3rd year, it would be the 1st year of that new rate case could be a significant jump again and 4% as we move forward.
Yes, but I think it would be a little larger because you think, I mean, the historic period in this is really consisting of kind of 2.5 years of investment. In the next proceeding, when they come in, assuming that they come in time to have effective rates in 2029, you're probably only talking about 1.5 years of spend. So, it'll be hopefully a slightly smaller jump, but it also depends. We might have new generation put into service by that time. I think we may have some Person County combined cycles put into plant, and we haven't even seen the impact of those generation units yet. And so if those are in the historic period in the next proceeding, right, I mean, we could see another 11-14% jump in the 1st year of the next MRP.
And Commissioner Tucker, some of these questions might be better for another panel or another time. Do you have further questions on other issues? I'm just trying to move things along, knowing that we have a lot of other people we need to get to later today that flew into town and may be here for a limited time.
Okay,
but
one question then.
Go right ahead, sir.
Gentlemen, do you think that a 1-year rate case versus a 1-year MYRP, having a rate case annually, versus a 3-year MYRP is more advantageous or less advantageous to the utility and the customers? Which one would you pick?
As I sit here today, based upon Duke's performance of MYRP 1, we would think that the filing a rate case every year would be more advantageous to the ratepayer.
Okay, you agree, Mr. Thomas?
I do.
Okay, thank you.
Thank you, Commissioner Tucker. Commissioner Gaida, go right ahead, sir.
Thank you, Presiding Commissioner. At the risk of obliterating a dead horse from existence, I think this is a unique question, so bear with me. But as we talk about effectiveness of MYRP, my question is general across categories. But as an example, we've talked about the $1.2 billion distribution spend, in which 80% is for reliability. So my question is, with the MYRP's focus on forward execution of discrete programs and projects, do you all view it as a risk that the company is defining regulatory success as simply executing programs and projects versus something like setting reliability strategy and goals and then determining an optimal capital and O&M spend to reach those goals?
So let me jump in first. So a lot of the stem from MYRP 1 and the conversations that were in investigation that we had in that case. And we look at the overall CapEx spend that is allocated to each respective of those groups. It was my finding is that there was no optimization for purposes of the ratepayer of basically taking a step back is from pick a metric, pick reliability, pick affordability. There was no optimization of where to spend that money. In other words, maybe we should have spent 99% in distribution. That would have been the biggest bang for our buck for investment. That optimization wasn't done. And based upon my review of those values that I repeated to this commission a little while ago, that process still isn't being done. It appears to be acting more as a budgeting tool, informed, but a budgeting tool, and then each individual business group enacts its budget. Mr. Thomas.
Yeah, and I think I testified about that, right? Is that how can you figure out what the appropriate level of reliability spend is if you don't have firm reliability targets or reliability goals? And I testified at length about our concerns that, we are not being judicious enough about the places in which we spend this money on reliability. And truly there's nothing in the statute that says the increase year over year under an MYRP must be 4%, right? That's not a floor, it's a ceiling. There's nothing to stop Duke from saying, look, we're only really concerned about this constant barrage of distribution investment. So let's just have an MYRP that's got distribution in it. Distribution actually did north of about 85% complete by dollars at the end of rate year 2. They could come in and say, we're just going to ask for a little 1% increase and 2% increase in rate years 1 and rate year 2. And we're just going to include distribution projects. And we're going to treat everything else in the traditional way. There's nothing that says that can't be done. But I think our stipulation certainly on MYRP investments and distribution investments reflects give and take. And I think we've tried to carve out at least some of the projects that we thought were not needed. But I do think that in general, when Duke is planning and budgeting and including projects in future MRPs, we really need to be judicious about how these are helping us achieve those reliability goals and what is that reliability goal? Because again, building to the perfect system with 0 minutes of SAIDI and 0 incidents annually, that is going to gold plate the grid and never achieve, reasonable rates for ratepayers. And I just want to see that discussion, that trade-off between service quality and cost impacts to be more front and center, particularly given the incredible inflation we've seen in this segment.
Okay. Thank you.
All right. After approximately 3 hours, we're ready to move to questions on commissioner questions. And we contributed substantially to that 3 hours, I might add, as commissioners and with the questions that came from our commission staff.
Yes, thank you, Presiding Commissioner McKissick. Good afternoon, gentlemen. I want to skip around a little bit, picking up on the thread regarding the PIM stakeholder process that I believe was a discussion you had with presiding Commissioner McKissick. Is it correct that there was a single stakeholder meeting regarding PIMS that was held on August 15th, 2025?
While I did not attend that meeting. That is my understanding that it was a 1 hour presentation discussion. But public staff did have some members there. I was not, and I understand other stakeholders were there as well.
And did the companies, to your knowledge, provide a proposal that the stakeholders who participated in this meeting could respond to in any meaningful way?
Again, I was not there, but I did take a look at the meeting invite before on the break, and it appeared to be a summary of MYRP1 PIM performance and a discussion of potential PIMs for the next case. But I do not know the format of the meeting or how open it was to feedback and alternative proposals.
Thank you. Picking up on Commissioner Tucker's question regarding the 2-year proposed MYRP as filed by the company, and your testimony, I believe, Mr. Metz, that the impending merger between DEP and DEC could have had something to do with the proposal for 2 years versus 3 years. Do you recall that testimony?
Yes.
It's true, is it not, that the company could have waited to file a rate case until after legal day 1 of the new merged 1U on January 1st, 2027?
Yes, filing a rate case within the discretion of the utility or to the extent that this commission would bring them in.
Okay, and following up on Commissioner Tucker's question that would the public staff prefer a 1-year MYRP versus what we are seeing with the 3-year MYRP, would the public staff prefer a traditional historic looking test case be filed annually versus a 3-year MYRP rate case?
Generally, yes, with the caveats that are provided to Commissioner Tucker, based upon the company's implementation of MYRP1 from a financial impact to the ratepayer, it would be more aligned in their interest to file a traditional rate case. That doesn't mean that there can't be improvement. That doesn't mean that perhaps as we get further down this evolution that we can't apply further lessons learned where it would actually be more neutral or at least advantageous to the overall ratepayers. As we sit here right now for this particular case, yes, that would be my conclusion.
Thank you. And you had a number of discussions with commissioners about some of the policy justification underlying a multi-year rate plan, including but not limited to your testimony that it is to support small, quickly built projects. Do you recall that testimony?
Yes.
Okay, and small, quickly built projects, would that include, for example, grid modernization projects like what was proposed by the company in its Power Forward program?
Yes, I think that's the basic concept. Yes, those small distribution grid improvement projects.
And so there was some testimony in response to a question from presiding Commissioner McKissick about what has changed in the years since that Power Forward proposal and the present. And now we are seeing the second iteration of Duke's PBR and MYRP. Can you speak to load growth and how that has changed in those intervening years?
So I'll start and Mr. Metz can add, certainly load growth, I think we are seeing, spent a lot of time talking about this in the CPRP, load growth accelerating from large load customers. So I know that's a fact, but I do want to say that a lot of the distribution investments are related to new residential customers. My understanding, without the census data in front of me, is that North Carolina, and particularly areas within Duke's service, DEC's service territory, have been growing quite rapidly for some time now. So I do not think that the growth in residential and correlated commercial growth is necessarily a new thing in the way that connecting a gigawatt at a time at a single site is a new thing.
By chance, do you know how many new residential customers DEC connects every day?
I do not have that information.
Okay. So is it fair to say that there is a stronger policy justification for PBR and MYRP during times of smaller, non-capital intensive investments and no load growth?
I would say the ability for the utility to promptly recover small discrete investments such as grid modernization or new customer connections is one aspect of PBR that, you know, is appealing to utilities, and somewhat it's designed to help encourage those investments. You know, and that's part of the justification or the support for PBRs when you read reports on the benefits of PBR and PBR frameworks and how to design PBR. But I'd say that it's not necessarily by itself a reason to do PBR. You know, I think it certainly reduces regulatory lag for the utility on those types of investments, but so would an annual rate case like we've discussed. So I think there's a lot of nuance there, but the sole reason for PBR and MYRP is not simply to address those small discrete investments. That's just one purported element of the rationale, but.
And so there was some discussion regarding, and I heard both of you say, quote, orders of magnitude. The scale and scope of these investments has changed. And you testified yesterday, Mr. Thomas, that the Power Forward capital spending plan was $13 billion. Is that correct?
Yes, I think my colleague, Mr. Williamson, testified to that, but yes, I do recall the Power Forward being about 13 billion, 10-year program. Although what that would be, what the cost of that exact same program would be today, given inflation in the sector, I could not tell you.
And how does that $13 billion capital spending plan over 10 years compare to DEC's current 10-year capital spending plan?
I don't have Mr. Williamson's testimony in front of me. If memory recalls, he has a graph that explicitly mapped out the distribution element. My numbers have everything aggregated together. So
yeah, so projected, just looking at the distribution testimony, it looks like the projection through from 2026 to 2030 is give or take 2 billion a year. So that's about 10 billion over 5 years.
And you mentioned several times in response to multiple commissioners that we are experiencing unprecedented load growth. Is it also fair to say we are experiencing unprecedented planned capital spending?
Certainly, from where I'm sitting, it looks unprecedented to me in that it is higher than it has been in the past.
Thank you. Turning back to Chair Brawley's questions about the PBR statute. And Mr. Metz, you testified that the statute is permissive and not mandatory. It's correct that the statute actually contemplates the possibility that the commission may reject a PBR application. Isn't that right?
yes,
And in fact, the statute sets forth a process for what happens in the event that the commission decides to reject a PBR application.
yes.
Give me 1 second. I'm just checking my notes. In terms of the rate case expense issue that you've discussed with multiple commissioners, you testified, Mr. Thomas, that when DEC is allowed to pass on all rate case expense, there may not be as much incentive for them to try to manage those expenses. Is that a fair characterization?
Yes, and that is something we testified to in our direct as well.
Thank you. No further questions.
Thank you. Go right ahead, sir.
Menashe Maguire on behalf of NCJC et al. I think I have maybe 2 or 3 questions. And let's, I guess, keep on the topic of rate case expense. I believe the panel was asked by presiding Commissioner McKissick for examples of states or jurisdictions that have a 50-50 split. Do you recall that line of questioning?
Generally, yes.
And I think I heard you say on the stand that the public staff had reviewed states or jurisdictions that had that 50-50 split.
Whether it's 50-50 split or at least some sharing, yes.
Yeah. Does New Jersey sound like one of the states that you might have reviewed that has a 50-50 split?
I remember it was in the Northeast, so it's very possible it could be New Jersey.
And maybe Missouri and Colorado being other states that have situationally a 50-50 split.
Yes.
Okay. So I think this is a line of questioning from presiding Commissioner McKissick. This is, I think, broadly speaking, how we can use PIMS to sort of address some of these big picture affordability concerns. Do you recall that general line of questioning?
Yes.
And I think one of the things that you said in response is that, you know, when you're thinking about PIMS, there's a balance, because if you propose more PIMS, then that actually might be at crosswise or counter purposes with regards to addressing affordability. Do you recall that?
Yes.
And sorry, I might have mangled the paraphrase. Obviously recognizing the two of you are not lawyers, but to the best of your knowledge, under the PBR statute, there's no language in there that requires that PIMS be upside only. And I can rephrase that if it's helpful, if that question is.
It is, going off memory, is my general understanding. There's not prescriptive language that it is upside only.
So conceptually or hypothetically, you know, DEC or any party could propose a PIMS portfolio that is solely downside only, correct?
It is very possible, yes.
And the upshot of that would be a decrease in the rate increase relative to what it would be absent the PIMS portfolio.
Relative when they come back in for that rider portion, yes.
Okay. No further questions.
Thank you. Public staff.
Thank you, Commissioner. And if it's all right, I've got a few questions and then my co-counsel
Sure,
Nadia
that's fine.
will have some. Thank you. Let's see. Commissioner McKissick asked you some questions about the reported benefits of PBR, I think as mentioned by DEC, one of them being rate certainty. You, in your testimony, you talked to, you know, the amount of times per year that rates change through other aspects, riders and storm charges and whatnot. Can you speak some to that aspect of rate certainty?
Yeah, I can definitely do that. So obviously MORP changes the base rates, but as this commission is familiar, there are many riders that are preceded that adjust that. And so I think on page 41, we lay it out, and I'm not necessarily going to go through each and every change, but there's changes in January to recover certain MORP adjustment as well as certain riders. Demand side management, customer system, nuclear production tax credit. There's changes again in July. There's changes again in September. There's changes, and there's also additional changes that may occur outside of those, you know, new riders that might come up or other situations. There's a new quarterly fuel adjustment rider to recover significant under recovery, and that can change rates for multiple times a year potentially. So rate certainty is certainly, you know, these riders can be significant. So rate certainty is hard to promise with the MORP when you are constantly adjusting those riders up and down. You know, and obviously it's difficult for customers to understand this as well, because, you know, if you go and look at the tariff, you know, online, I want to see the rate I'm paying. You get the base rate, and then it says in the tariff, hey, you have to go add these other riders. Luckily, we have a summary of rider adjustments that DC publishes now that kind of gives you a breakdown summary of all of the riders together. But you know, those riders that change periodically are not small, and they are a significant addition to the customer's bill.
Thank you. You were also asked by Commissioner McKissick about the concept of regulatory lag. Can you speak a bit to that concept and whether it provides an aspect of discipline on utility expenditures?
Yeah, from a regulatory lag standpoint, to the extent that the company is trying to balance its cash outflows and cash inflows, and let's say they don't come in for a rate case and therefore definition of regulatory lag to some degree or to a large degree, that the company would need to internally manage its overall, more likely than not, operation and maintenance expenses in any given year to balance the relative earnings. At least that's my understanding.
And so would you say that there's any benefits to customers in terms of controlling the utility spend in that regard?
Yes, it would have potential benefit of the utilities, for lack of a better word, regulating themselves in relation to their annual spend.
Thank you. I'm going to pass it over to Ms. Lohr.
Okay. Commissioner McKissick asked you a series of questions about rate case expense and your proposal to share those 50-50 between shareholders and ratepayers. Do you recall those questions?
Yes,
Is the primary reason behind that proposal the fact that both shareholders and ratepayers benefit from rate cases?
absolutely, yes.
And any unreasonable or imprudent costs, those would be disallowed separately. Is that correct?
That is correct.
And Commissioner McKissick also asked you if any other jurisdictions split rate case expense, and Mr. Magarira asked you about several jurisdictions that do so. Subject to check, would you accept that Connecticut also recently split rate case expense between shareholders and ratepayers?
Subject to check, yes.
Thank you. That's all our questions.
All right, very good. Well, this panel is released at this time. It looks like the public staff has put forth its panels of witnesses or individual witnesses in connection with the testimony that's been pre-filed in this case. So when we're going to take a break for lunch, and when we return, the Attorney General will have a chance to present her person or persons, as the case may be, for cross-examination. It is now 12:42. Let's just try to get back here around 1:50 today, if we could. Try to move things along. I know we're going to have a hard stop this afternoon, probably around 5 or 5:15. Thank you very much. being the afternoon session, it being approximately 1:50 PM. Of course, the Attorney General, you have your witness on the stand, so we will go ahead and recognize you, madam.
Mr. Burgess, would you please state your name and place of business for the record?
Yes, my name is Edward Burgess and my business address is 4764 East Sunrise Drive, Tucson, Arizona.
Oh, excuse me 1 second. Let me swear you in.
Okay.
My mistake. Could you put your left hand on the Bible, raise your right hand? Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Now go ahead and proceed.
Mr. Burgess, on or about May 29th, 2026, did you cause to be pre-filed in this docket direct testimony consisting of 84 pages, 1 appendix, and 9 exhibits?
Yes,
And on July 13th, 2026, did you also cause to be pre-filed corrected direct testimony consisting of 84 pages, 1 appendix, and 9 exhibits?
yes,
Did your testimony contain confidential information?
yes,
Do you have any corrections to your pre-filed testimony beyond those included in the corrected testimony I just referenced?
no, not at this time.
If you were asked those same questions today under oath, would your answers be the same?
Yes,
Finally, did you cause to be pre-filed a summary of your pre-filed testimony in docket number E-7 sub 1329A?
yes,
Presiding Commissioner McKissick, I respectfully request that Mr. Burgess's pre-filed direct testimony consisting of 84 pages, 1 exhibit, 1 appendix, and 9 exhibits as corrected on July 13th, 2026, and his witness summary be entered into evidence and copied into the record.
Without objection, your motion is allowed.
Mr. Burgess is available for cross-examination and questions from the commission.
All right, Sigfer is first in the queue.
Thank you. Just a couple of quick questions for you, Mr. Burgess. You testify on page 14. I'll let you get there. You testify on page 14 that if DEC's proposal in this rate case is adopted, retail rates will have increased by 43% over the last 5 years. Is that correct?
that's what it says. Yes,
And is that 43% increase over 5 years base rates only, or does it include riders?
that would have been the calculation we did on the total revenue requirement, including the riders. Yeah.
Thank you. No further questions.
Okay. Next in the queue, Environmental Defense Fund.
Good afternoon, Ben Smith for Environmental Defense Fund. Good afternoon, Mr. Burgess.
Good afternoon.
Can you remind me how many times you've testified in front of this commission?
Right. I don't know the exact number off the top of my head, but I've testified in the last general rate cases for DC and DEP, as well as the CPIRP proceedings, both the recent one and the one a couple years ago, and the first one as well. So number of cases I've testified in. Yeah.
And generally speaking, and this, I think, is just a broad question, is the progression of investments that DEC is asking for, how has that progressed over your time as an expert witness?
I would say it's increased pretty significantly. The amount of investment. I mean, I testified to that in my testimony here in this case, that there's been, sort of a steady increase in the amount of capital investment that's been made, and the resulting, rates that are being requested over that period. Yeah.
And you testify a little bit about the disconnect between the projection of the large load and the MYRP asks. Isn't that right?
That's correct.
So I want to understand exactly what, because I reviewed your testimony again during lunch, and I want to put a pin exactly on what you're trying to say with that disconnect. My understanding is that the low growth and the required investments don't necessarily match what's the ask in the MYRP. Am I right there? And can you clarify if I've mixed that up?
Yeah, that's about right. I mean, what I'm trying to articulate that in my testimony is the fact that we're seeing, not only this large increase in investment, both, sort of up until now, but also projected out into the future. So MYRP 2 goes out to 2028. There's investments going into rates for that period, including some of which, might be characterized as for the large load. That at the same time, you're not seeing the revenues from that large load reflected in the calculation of those rates. So as we move out into year 2028, Duke has projected a significant increase in their load in the revenues that they'll be collecting, in large part because of these large customers, but that's not actually reflected in the rates that they've proposed. So you're seeing the increase in costs, but not the increase in the revenue. So the rates as a result are going up more so than they would if that revenue had been included.
No further questions.
Thank you. Next in the queue is Microsoft. All right. Nucor. The attorney for Nucor in the hearing room. Okay. We will assume that means that he has no questions. Walmart.
Certainly gets none.
Well, unless he communicates telepathically, which is a challenge, but he may have that capacity.
Walmart has no questions.
All right. Thank you. Public staff.
Tom Felling with the public staff. Good afternoon, Mr. Burgess.
Good afternoon.
Have you had an opportunity to review various stipulations that have been filed in this rate case since you have filed your testimony?
I have not reviewed all of the stipulations. No, I reviewed some of the ones that were filed months ago, I guess, but not the most recent things. Yeah.
Okay. Well, just based on, any information that you have reviewed in terms of stipulation, as well as having had the opportunity to review Deck's rebuttal, I'd be curious to know how your areas of concern have perhaps changed or evolved regarding the MYRP framework and the cost of service study, if you'd like to offer anything on those topics.
I don't think my view has changed much. I, was under the impression that, some of the stipulations that were filed were on issues separate from what I addressed in my testimony. So I haven't taken a close look to see if I would alter anything, but I don't think that they would be, that would change my view much.
Okay, and also just on the topic of topics that Deck raised in its rebuttal, curious if that had any refinement to your areas of concern on the MYRP framework or cost of service.
No, not really. I think I didn't see anything in their rebuttal testimony that really changed my view on some of the key issues that I raised around return on equity, as well as the absence of the large load growth, this being kind of the two primary issues that I see, and nothing in their rebuttal changed my opinion on that.
Okay. No further questions. Thank you, Presiding Commissioner.
Thank you. DEC.
We're going to wave cross.
Get a wave cross. All right. Redirect.
No redirect, Commissioner McKissick.
And I don't see whether commission staff has questions, but let me look to my colleagues to see if there are any questions. Chair Brawley?
No questions.
Commissioner Tucker? Commissioner Vandermark? In that case,
Commissioner Gaida.
oh, you're right. Excuse me. Commissioner Gaida, excuse me, sir. I don't know where my mind was that momentarily there. Yes. He sent a text a few minutes ago, so that's probably where it was. But in any case, thank you, sir, for appearing for cross-examination today. We appreciate your testimony in this proceeding.
Thank you.
The Attorney General's office now calls Justin Brandt to the stand.
Yeah. And as I mentioned earlier, Commissioner Vandervoort will not be in today. He's kept me posted of his ongoing family emergency, but I don't think he'll be back this week, but we don't know that yet. Good afternoon, sir. If you could put your left hand on the Bible, raise your right hand. Do you solemnly swear that the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Mr. Brandt, would you please state your name and place of business for the record?
My name is Justin Brandt. I work at Current Energy Group. Our business address is 4764 East Sunrise Drive in Tucson, Arizona.
On or about May 29th, 2026, did you cause to be pre-filed in this docket direct testimony consisting of 66 pages, 1 appendix, and 2 exhibits?
I did.
Does your testimony contain confidential information?
It does not.
Do you have any corrections to your pre-filed testimony?
No, not at this time.
If I were to ask you those same questions today under oath, would your answers be the same?
Yes.
Finally, did you also cause to be pre-filed a summary of your pre-filed direct testimony in docket number E-7 sub 1329A?
Yes.
Presiding Commissioner McKissick, I respectfully request that Mr. Brandt's pre-filed direct testimony consisting of 66 pages, 1 appendix, and 2 exhibits, and his witness summary be entered into evidence and copied into the record.
Without objection, your motion is allowed.
Mr. Brandt is now available for cross-examination and questions from the commission.
Sickford, you recognize.
Thank you. No questions.
Okay. Going down to Microsoft. You're recognized.
Good afternoon, Mr. Brandt. Ben Snowden here on behalf of Microsoft Corporation.
Afternoon.
Mr. Brandt, I want to talk about curtailment and load flexibility. On page 50 of your testimony, you testified that all large load ESAs going forward should include provisions enabling DEC to curtail service to large load customers during system emergencies or peak demand events. Is that your testimony?
Yes.
Okay. And the provisions you talk about should be based on what's in most of Duke's current large load ESAs. Is that right?
Correct. I talked about that as one recommendation as a minimum requirement, and then discuss more broadly about the commission developing a flexibility tariff moving forward.
Okay, thank you. And in your recommendations, you recommend that the commission, among other things, consider whether that level of curtailment is sufficient, but also that Duke be ordered to rely on that load curtailment as a planning resource going forward. Is that right?
Correct.
Okay. Mr. Brandt, you would agree that at present, providing uninterrupted operations is extremely important to data centers and their customers, would you?
Yeah, that's my understanding.
Okay. And those customers of data centers may include entities like banks or hospitals who would expect no outages or downtime?
They may. I think the customers of data centers, especially a lot of hyperscalers we're talking about it. I can't speak specifically to who they are.
Okay. Could you take a look at Exhibit 2 to your direct testimony?
Is there a specific page?
Yes, but just generally, this document, as I understand it, is a draft report to Virginia's, or a draft report of Virginia's Joint Legislative Audit and Review Commission that was provided to the Governor and General Assembly of Virginia. Is that right?
Yes.
Okay. And I'm sorry, what is the title of that document?
Data centers in Virginia.
Okay. And you rely on this report in several places in your direct testimony, right?
I cite to it and use it as an example.
Okay, could you turn to page 75 of that document, please? I'm sorry, it is actually 76 of your exhibit. It is marked as page 58 of the document itself.
Yeah, I'm there.
Okay, it's chapter 5, natural and historic resources impacts.
Yes.
Okay. Okay, and could you just read the first two sentences of that that first paragraph on that page?
To ensure constant operations in the event of a power outage, data centers maintain on-site backup power. Data centers report that providing uninterrupted operations is extremely important to their customers, which can include banks and hospitals who expect no outages or downtime.
Okay, and you've got no reason to disagree that certain data centers do find that uninterrupted operation extremely important?
Yeah.
Okay.
If you could speak a little louder and more directly into the microphone.
Sorry.
Thank you.
And would you agree, Mr. Brandt, that for that reason, not all data centers have an equal ability to reduce their actual on-site consumption of energy by shifting or reducing computational load?
Yeah, I think it's my understanding that there are certain types of data centers that do have more flexibility within their operations themselves than other types. I'm talking about sort of AI training and some of those options rather than cloud computing.
Okay, thank you. And so when you say cloud computing, can you just explain just very quickly what you're referring to there?
Those would be data centers that are housing applications and I guess data for specific customers.
Okay, and you would agree that for those data centers that need to provide uninterrupted operations or that don't have the flexibility to reduce their demand, they are most likely to respond to a curtailment instruction by switching over to their backup generation. Do you agree with that?
It could be backup generation or on-site storage, but they would likely need some sort of power supply, yes.
Okay. So looking back at your exhibit, this page, okay, so could you read the next sentence in that paragraph that you just read?
In Virginia, nearly all data centers use diesel generators for backup power.
Okay, okay. And do you believe that that statement's accurate?
I don't have a reason to doubt it, no.
Okay. And would you expect that in North Carolina, it would be similar, that diesel generation would be the predominant form of backup generation for data centers?
It would be without explicit direction from the commission or local regulators. I guess I'm not familiar specifically with data centers in North Carolina.
Okay. Have you heard testimony from other parties in this proceeding that are you familiar with the 50-hour curtailment number in Duke's ESA curtailment provisions?
Yes, I've reviewed that as part of their filing, yes.
Okay. And you heard the testimony from other parties in this proceeding that 50 hours of curtailment that's in Duke's current ESA terms, that number is based on the number of hours that an emergency diesel generator is allowed to operate for demand response on an annual basis?
I have not listened to all the testimony in this proceeding, but I will trust your characterization.
Okay. Well, let me ask you this. If load curtailment or load flexibility were required for all data centers going forward, would you anticipate that the main way in which customers would satisfy curtailment instructions would be to shift to diesel generation?
I think I discussed in my testimony that I would advocate that it should be clean behind the meter generation. So not diesel, either battery storage paired with renewable energy generation or some other form of backup generation that's not reliant on diesel.
Okay, I'd like to talk about that in a few minutes, but in the absence of a program that sort of facilitates that or a directive, you'd expect that it would be diesel generation that would provide load flexibility?
Yeah, in that hypothetical, yes.
Okay. And I'm not challenging here the potential benefits of load flexibility, which you can talk about in your testimony. But wouldn't you agree that there are some potential drawbacks or unintended consequences of relying on diesel generators for demand response purposes?
Again, yeah, that's why I caveat the recommendation, because diesel generators can have adverse consequences to local air pollution.
Okay. Could you talk about that a little bit? Would you mind elaborating?
I'm not an expert on environmental regulation, but it's my understanding that diesel generators produce a number of air pollutants as part of their operation.
Okay. Could you look at page 10 of that exhibit 2, please?
Okay, I'm there.
All right, you see that. And you see in the last paragraph, it says that data center generators are run mostly only for maintenance, and most data center operators interviewed by the JLARC staff reported experiencing 0 to 2 minor outages per site in the last 2 years, with nearly all outages being only a few hours long. Do you see that?
I'm sorry, I'm trying to find it.
Okay,
Yes, I do see it.
Do you see it?
Yes.
Okay. And I'm sorry, is that, that's page, marked as page 10 at the top, but is that the? In any event, at least according to this report, data center operators are currently in Virginia, only running their diesel generation outside of maintenance activity a few hours a year at most. Is that right?
Yes.
Okay. And a demand response program that along the lines of what you are talking about in your testimony would result in backup generators being run up to 50 hours a year. Is that right?
Potentially, yes.
Okay, so that's something like a 10-fold increase in the amount of runtime for those generators. Is that right?
Assuming this characterization about Virginia applies to Duke.
Understood. So going back to the unintended consequences of relying on diesel generation and data centers as a demand response resource, you would expect, if this were required at scale, a significant increase in the air emissions from those diesel generators as compared to using them only during emergency situations. Is that right?
Yeah, again, I'm not advocating for the use of diesel generators in this way, but if one was, that would be the impact.
Okay. And those increased air emissions, the impact of those would mostly be felt locally in the communities where those data centers were located, wouldn't they?
Again, I'm not an expert on sort of how the impacts of these types of air pollutants, so I can't speak specifically to that.
Okay, understood. But you would anticipate increased noise impacts as well if there was a significant increase in the amount of runtime for those generators?
Again, I'm not positive how that noise from generators would change the overall noise impacts of a data center versus baseline.
Okay, understood. Let me ask you this. If implemented at scale, do you think that relying on diesel generation as a demand response resource could have impacts on the cost or the availability of diesel fuel in North Carolina during the kinds of events where demand response is most likely to be triggered?
Commissioner McKissick, at this point, I would like to object. Mr. Brandt has said several times that he's not advocating for diesel generation, nor is he an expert in the impact that that would have in North Carolina.
Would you like to be heard?
Yeah, he is. I mean, he is testifying about he's advocating for the continued deployment of this 50 hours of demand response. We will talk about his alternative proposals for doing that. I really like to talk about that. He also, with his testimony, sponsored a report that specifically discusses diesel generation as a demand response resource, and I'd like to talk about that exhibit as well. So this, I don't have much more here, but this is
to the extent you want to make further inquiry into that exhibit and how it relates to his testimony, I will allow it.
Okay.
And overrule the objection at this time, but please make sure it's narrowly focused in terms of your inquiries.
Okay, understood. I will do that.
Thank you.
Mr. Brandt, could you just look at page 57 of your exhibit 2?
I'm there.
Okay, and do you see the little sidebar there?
Yes.
It's a full quote. Could you read that, please?
Most data centers' backup generation comes from tier 2 diesel generators, which cannot and should not be used as a demand response resource because of their emissions, nitrogen oxides, carbon monoxide, and particulate matter.
Okay, thank you, Mr. Brandt. So I want to ask you whether there are other ways to achieve some of the benefits of load flexibility that you talk about in your testimony without the potential unintended consequences of relying on diesel generation. And so on page 65 of your testimony, and I'll give you a minute to get there. This is lines 16 to 17.
I'm there.
Okay, and there you say that zero carbon behind the meter generation or energy storage are available that would enable backup generation to be used for flexibility programs. Is that your testimony?
Yes.
And these would be resources that are paid for by the customer, right?
Yes, generally.
Okay. Mr. Brandt, would you agree that the benefits of load flexibility in the way that we're talking about it mostly relate to addressing resource adequacy concerns on the utility system?
Yeah, I think that's a reasonable characterization.
And so for the most part, those relate to the entire grid and are not site specific for the most part.
Well, not necessarily. I think a lot of the benefits of flexibility is speed to power in the short term to allow data centers to connect more quickly before the full build out of the resources is necessary to meet their peak demand. So there's a lot of benefit to the data center customers themselves around flexibility.
But in terms of the benefits to the system, those are sort of system wide rather than being confined to a specific site.
Again, given the sort of large load growth related to data centers, I don't know. I think a lot of the benefits are accruing to those customers in terms of speed to power and the ability to build fewer resources to meet that load. So while there may be some, depending on how costs are allocated, some benefits more broadly, I'd say the vast majority accrue to data centers.
Okay. Well, let me ask you this. Is there any reason that zero carbon generation or energy storage that's funded by a large load customer would have to be located behind that customer's meter to provide benefits to the system?
No, you could do it in a distributed fashion, I believe.
Okay. And would you agree that when it comes to battery storage resources, those resources might actually be more beneficial when they're not behind a specific customer meter?
Potentially if there's locational benefits, and also if you could stack benefits to the customers themselves if you were siting it at customer facilities.
And if those battery storage resources were operated at the direction of the utility, they could provide broader system benefits, couldn't they?
Yes.
Okay. So in the conversation about load flexibility and its benefits, would you agree that the commission or stakeholders should be considering options not just for behind the meter generation or battery storage, but also offsite resources that could provide some of the benefits of load flexibility at the cost of the customer, the large load customer, without incurring some of the unintended consequences of relying on large scale use of diesel for demand response?
Yeah, I guess I'm not opposed to considering distributed options, but I think behind the meter is a place to start and is certainly an easier path to take.
Okay, thank you. Those are all my questions.
Thank you. Looks like Walmart.
No questions.
Public staff.
Thank you, Presiding Commissioner. Good afternoon, Mr. Brandt. My name is Tom Felling. I'm an attorney with Public Staff. On page 33 of your pre-filed direct testimony, lines 3 through 6, I'm going to read it to you just in case you're not already there, and then ask you a question about it. Your question was, why is it important to establish a large load tariff now rather than waiting for circumstances to change? And your first sentence in response to the question, a large load tariff needs to be established, emphasis added before large load customers interconnect and execute contracts. So understanding that that's your testimony, I have two questions for you. Do you believe that a general rate case is the right forum for the commission to consider a large load tariff or any tariff?
I'm going to object to the extent that these are friendly cross questions, and presiding Commissioner McKissick has already sustained objections today for the same reason. Thank you.
I'd be happy to respond, Commissioner McKissick.
Yes,
If I could be heard. I believe that this is a matter that's in controversy between the parties. This is an expert witness who's offered testimony on that. Regardless of the position that our agency has taken, this is information that's relevant to the commission's determination of matters before it. So this is not designed to elicit friendly cross, but cross that's relevant material to matters the commission will need to determine.
Are you distinguish? Is the testimony you're seeking to elicit at this time based upon nuances and differences between what this expert witness has provided and what in the position of the public staff?
Well, so I believe that this is important because he said that the time is now, and I'm asking whether this forum and this docket is, in his expert opinion, the right place for this to be considered.
If that is the sole question, then I will permit that sole question. But I think his testimony speaks to it already, to be candid.
Okay, and that's, I'll defer to the commission on the topic. I just wanted to be heard on a response.
That's fine. If you may answer that question, sir.
So I think I advocate in my, well, I agree. Well, I state that time is important and of the essence. I advocate in my testimony for a expedited separate proceeding. I think as has been raised in this record, this is a complicated issue and it deserves the specific focus and testimony and input from parties that is not in the record before the commission right now. So while I don't agree that one can establish tariffs and a rate case is an opportunity where a large load tariff could be established, I'm specifically not advocating for that in this proceeding.
And I guess one follow-up, just.
And what is that, sir?
Do you agree that traditionally rate cases are avenues where commissions, utility commissions consider the development and approval of tariffs and rates?
Yeah, traditionally, but I think we're seeing nationally, there's been a split on this around large load tariffs. There are a lot of commissions and jurisdictions that are taking the approach of wanting to look at these things separately rather than within a broader rate case where there's lots of other issues. But I don't disagree that tariffs are at issue in a rate case generally. Yes.
No further questions, Commissioner. Thank you.
All right, so we're going to go back for redirect.
No redirect, Commissioner McKissick.
All right, we do have one or two questions here from our commission staff. It's been reduced to one now. Please explain why the Attorney General is recommending ESA provisions, a mandatory large load tariff, and a new customer class for large loads at or above 100 megawatts. What additional benefits or protections would creating a new rate class provide that is not already covered by the ESA provisions and a large load tariff?
So I think by establishing a new rate class, there's a lot of additional opportunities to address some of these questions about cost allocation and who pays for what costs and when. If we're treating large load customers, as I state in my testimony, the large load customers we're seeing that are proposed to come online are unprecedented. And as a result, require solutions that are different from the sort of traditional embedded cost approach we've taken to sort of cost allocation and assigning cost to customers. So by having a tariff for these unprecedented and different customers, we can establish stricter consumer protections, but also as we think about some of the issues, raised by public staff on this issue around either directly assigning costs or assigning specific costs to customers to ensure that they're sort of paying the incremental cost to serve them, that it would be much easier to accomplish through a separate rate class rather than merely through ESAs and other contractual arrangements if those customers are part of an existing rate class.
Thank you. Let me see if my fellow commissioners have questions. Chief, Chair Brawley,
No questions.
Commissioner Tucker, me, okay. Commissioner Gaida. Looks as if there are no other questions of you at this time, so you're hereby released. We thank you for providing testimony and coming forth to subject yourself to cross-examination.
Thank you.
Thank you. All right. Looks like Sigfer is ready to transition and call forth your witness.
Yes, thank you, Presiding Commissioner McKissick. Sigfer calls witness Brian C. Collins to the stand.
Give you a minute to get seated and situated, sir. If you could put your left hand on the Bible and raise your right hand. Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Good afternoon, Mr. Collins.
Good afternoon.
Would you please state your name, business address, and current position for the record?
Yes, my name is Brian C. Collins. My business address is 16690 Swingley Ridge Road, Suite 140, Chesterfield, Missouri, 63017. And I am a consultant and managing principal with the firm of Brubaker & Associates Incorporated.
And did you prepare and cause to be pre-filed in this docket on May 29th, 2026, direct testimony consisting of 73 pages, including one appendix?
Yes,
And your testimony did not contain any confidential information, did it?
it did not.
Do you have any changes or corrections to your pre-filed direct testimony?
I do not.
And did you also prepare and cause to be pre-filed on July 2nd, 2026, a summary of your pre-filed direct testimony in docket number E7 sub 1329A?
I did.
Okay, Presiding Commissioner McKissick, at this time, I would move that the pre-filed direct testimony of Sigfer witness Collins, consisting of 73 pages, including one appendix, and the pre-filed summary of his direct testimony be entered into the record as if given orally from the stand at the appropriate time.
Now is the appropriate time. Therefore, without objection, your motion is allowed.
Thank you. And Presiding Commissioner McKissick, Sigfer does respectfully request the opportunity to ask a few questions on direct examination of this witness in response to the public staff's recommendations filed in its testimony for the adoption of Schedule LL. And in support of this request, Sigfer does respectfully share with the commission that on June 12th, 2026, Sigfer filed a motion for leave to file supplemental testimony in response to the proposed Schedule LL submitted by the public staff. That motion was denied by order of the commission on June 18th, 2026. However, the commission stated in its order two things that I think are pertinent to this request this afternoon. First, the commission stated in its order denying Microsoft's motion as well as Sigfer's motion that, quote, the public staff's proposed large load tariff is not a change of rates requiring notice to interested parties under NC General Statute 62-134. And because of some testimony from the public staff's large load panel that we feel is inconsistent with that finding, we would request the opportunity to respond with very limited testimony this afternoon. And also, the commission's potential decisions in this docket have the potential to impact not only DEC customers, but also DEP customers and potentially even Dominion Energy North Carolina customers as they come in for their general rate case hearing later this year. The commission also included in its order a statement to the effect of we would have the opportunity to ask questions of witnesses and to call witnesses, and that's what we are doing this afternoon. And finally, I would just note that in the carbon plan proceeding in that hearing very recently, the public staff was allowed to provide supplemental testimony live from the witness stand, and we would respectfully request the opportunity to do so this afternoon.
Anybody would like to be heard? Go right ahead.
Thank you, Presiding Commissioner McKissick. Will Freeman for the public staff. I would object for several reasons. I think the traditional method is all interveners file at the same time, and to then allow them to file again essentially is sort of out of the normal order. We'll have 50 server rebuttals if we keep going down that road. I think the CPIRP was different in that we had to change our position in light of new information, whereas here, these are facts that have been known. We didn't get new information from the applicant, right? We got public staff filed some positions. And so, and this is the first I heard of it, so I'm kind of trying to go off the top of my head as well. But I think that as we move further out of the normal course, we're just getting into this, everyone's giving testimony from the stand and no one knows what it is ahead of time. I understand that we in DEP made a change to our testimony, or a refinement, let's say, which became an exhibit yesterday if memory serves. But I don't think there was anything else that was unforeseen. And this was the exact subject of a motion. I'm going from memory here. Thought we had a motion. I think Ms. Kress referenced that there was a motion that was denied. So I feel like we're kind of getting back into that territory again.
And respectfully, if I may just respond briefly, Mr. Freeman said that these were facts that have been known. We have heard testimony in this proceeding that no one saw the public staff's proposed schedule LL prior to the date when it was filed in this proceeding. Mr. Collins' testimony was also pre-filed on that same day. We had no opportunity to review the public staff's proposal and respond to it in any way. And respectfully, given that it does have the potential to impact SIGFR's member companies, we respectfully request the opportunity to be heard on this.
I think there's one other person who wants to chime in.
Position on whether or not this should be allowed, but I do believe that the other party should be entitled to the opportunity to cross-examine on any new information that's brought to the record.
Come to the mic so you could be heard.
I'm Ben Smith from Environmental Defense Fund. I don't have a position on whether SIGFR's request should be granted, but I would say that to the extent it is granted, the other parties who have previously indicated cross time should be able to add on, or in my case, be given the opportunity to cross on new information brought to the record.
Go right ahead.
Yeah, I'll tell you. Manash Magrier on behalf of NCJC et al. As a general matter, obviously, we'll note just for the record that NCJC et al. Did not oppose Microsoft's motion for leave to file supplemental testimony. I do think this is slightly different because the parties did not have any advance notice as to, the possibility of witness Collins giving live supplemental testimony on this specific issue. Obviously take into account SIGFR Counsel's position with regards to potentially new facts being elicited through testimony from the public staff's witness. That being said, I think I agree with counsel for EDF. I was definitely not prepared to cross-examine this witness on his potential thoughts and statements on the LL class. And so would, I think, join his request with regards to allowing parties to have the opportunity to perhaps add additional time to whatever cross they already reserved, just in the interest of fairness.
Yes.
Presiding Commissioner, yeah, Ben Snowden for Microsoft. I will note, in preparing our motion in our reply, I have looked at the procedural history of a number of rate cases, and in almost every rate case, there is supplemental testimony, there is settlement testimony, there is second supplemental testimony. The public staff, I do recall, in the last rate case, elicited new testimony from its own witnesses on the stand that was substantially different from its prior testimony that was filed. It can be disruptive. The world did not end, and I believe that we can rely on the commission and the presiding commissioner in this and in future cases to draw the line if things begin to get problematic. This seems to me to be a relatively minor accommodation.
that recognizes that parties have due process rights to be heard on proposals from the public staff that were not known prior to their filing their rebuttal testimony. So I would support SIGFR's motion.
Any other parties seeking recognition to address this issue? Seeing none. I'm going to overrule the objection. I'm going to allow that testimony to move forward. Please keep it narrowly focused in scope. Other parties, other interveners that would like to expand their time to address any additional issues that emerge during the course of this cross-examination will have an opportunity to do so.
Thank you, Presiding Commissioner McKissick. Mr. Collins, are you aware of any DEC customers who meet the threshold criteria of Schedule LL of 50 megawatts peak demand and 80% load factor?
Yes, it's my understanding that there are some customers that meet that criteria.
To your knowledge, is the public staff, through witness Lucas's testimony, proposing that DEC monitor the load profiles and characteristics of all non-residential customers, new and existing alike, to determine whether they should be swept up into Schedule LL?
Yes, that's my understanding. So that is a concern that an existing customer that meets that criteria could be swept into a new tariff.
Presiding Commissioner,
Have-
I object to that question and answer and move that it be stricken. That is reflective of information that is not in the record. That is not Mr. Lucas's testimony. This is clarified on the record yesterday, and to the extent that council would like to we can recall the large load panel. We can ask this question, but to presume on the false assumption that that is the testimony is improper evidence.
Excuse me, those are very intense allegations. Mr. Lucas testified on the stand regarding his intent that DEC monitor current existing customers' load and load profile and load characteristics, and that if they were, quote, behaving in a certain way that would trigger the eligibility criteria of Schedule LL, that they should then be subject to Schedule LL. This is a very serious issue with potentially very drastic implications for SIGFR member companies. And I think this issue absolutely needs to be fleshed out for the record.
Mr. Felony.
If that is the belief of the witness, then it should be elicited through the witness's testimony rather than counsel testifying for the witness. Mr. Lucas was very clear on what the recommendation was yesterday. So that testimony will speak for itself, but I would ask that counsel not testify through questions and ask instead what the witness's understanding is.
And just Presiding Commissioner McKissick, I was trying to follow your directive to be very efficient as I could possibly be, and very narrow in scope. So to the extent that public staff objects to the question, I disagree with the basis, and I think that there is evidence in the record, perhaps inconsistent evidence from their witnesses, but we can argue about that later, and I don't think now is the appropriate time to do that.
Would you like to restructure your question as to form?
Yes, sir, absolutely. Mr. Collins, is there any concern from SIGFR that existing customers could be subjected to the public staff's proposed Schedule LL?
There's some concern. It's just not very clear from the record thus far whether or not they will be.
Is it fair to say that there are unanswered questions with respect to the implementation of the public staff's proposed Schedule LL?
Yes, that is correct.
Have DEP or Dominion Energy North Carolina customers had an opportunity to be heard on the public staff's proposed Schedule LL?
No, they have not.
And in North Carolina, is cost of service-based rate making the law of the land?
Yes, that's my understanding. The statutes, the PBR statute, require that rates be based on cost of service, that subsidies be, limited to the, greatest extent practicable.
Does Sigfer want to be part of the solution here?
Absolutely. That they do want to be a part of the solution.
Is Sigfer ready, willing, and able to actively and collaboratively participate in an expedited stakeholder process or an expedited separate docket?
Yes, that was my recommendation in my direct testimony to have a separate docket, and we stand by willing to participate in such a docket proceeding and willing to do that on an expedited basis.
And do existing customers like traditional manufacturers and others pose a different risk profile than some of the new customers seeking to take service under the ESAs that have been at issue in this proceeding?
Yes, there's been some discussion of that. Traditional manufacturers that have been on the system for a long time really present a different operational risk to the utility than a new large load that may come onto the system. They've been around a long time. They've paid their bills. A lot of the equipment that's been put into place to serve them has been depreciated, but they're still contributing fixed cost recovery to the utility.
Excuse me.
And the risk of them pulling up stakes and moving out of the territory of Duke is probably lower than a new large load that may come in and face different economic circumstances and decide to leave. So.
And last question, I believe, will the billing determinants from new large loads help to spread fixed costs over a larger base, putting downward pressure on rates for all customers?
It will, to the extent there's very large loads that come onto the system. They'll be paying for not only new investments, but also making a contribution to existing assets that are in rates, that they, were not responsible for. So they'll be paying for not only existing equipment, but also, new investments going forward.
Thank you. Those are all my questions, Presiding Commissioner McKissick, and Mr. Collins is now available for cross-examination.
All right. Let's see, the next in the queue is Microsoft, I'm saying. Is that right?
Microsoft is waved cross. So this
You wave cross?
Yes, sir.
Environmental Defense Fund has questions. I don't know if you want to go through alphabetically, given the new information. I don't want to tell you.
I typically go through it in the sequence which is specified. So I don't want to start deviating from that general flow. North Carolina Gesture Center et al. Appears to be next in the queue. Is that right?
Happy to go at this time. I'm not sure if Kuka had.
Did Kuka have questions of this witness? Come on up. I'm sorry. Just come on up to that center chair in the order that you are typically and traditionally listed on the documents.
Thank you, President
Sure.
Commissioner. This will be very brief. Just one question that's flows from the redirect or the direct examination. Marcus Trathan for CUCA. Council asked you about the potential application of the public staff's proposed Schedule LL to existing customers. If I could just clarify, what is your understanding of the public staff's position on that issue?
I saw the first day of staff's large load panel testimony, and I believe Mr. Lucas, in response to a question, did indicate that existing customers that meet the criteria threshold in terms of load and load factor, could be subject to that tariff, and that the company would monitor existing customers, whether or not they would meet that criteria in future.
That's all I have. Thank you.
All right. Microsoft. North Carolina Gesture Center et al.
Good afternoon, Menashe Magru on behalf of NCJC et al. Just bear with me. I'm just going to get set up here real quick. Okay, Mr. Collins, good afternoon.
Yeah.
Do you have your direct testimony in front of you?
I do.
All right, so on page 6, beginning on line 22, and let me know when you're there.
I'm there.
Hold on, I'm not. I'm sorry.
Yep, that's fine.
I'm there.
So beginning on line 22 and continuing through page 7, lines 1 through 3 of your testimony, you note that the commission concluded, and this is with regards to, I think, the cost of service study stipulation from the last go around, that based upon the evidence presented, including the evidence offered in support of the stipulation, the commission, and I'm sort of cutting up the quote here, but the commission approves the cost of service stipulation. Is that more or less what you've said there?
That's correct.
Okay. And so I take it you reviewed the commission's final order in that sub 1276 docket,
Yes.
and you were actually a witness. I think you were SIGFIR's witness in that rate case. Is that right?
In the DEC rate case, I believe, yes.
Yeah. And to the best of your knowledge, no party challenged that cost of service stipulation in that sub 1276 docket.
To my recollection, they did not.
And in contrast, in this proceeding, at a minimum, the North Carolina Justice Center and the AGO have proposed different or alternative cost of service or cost allocation methodologies.
That's my understanding.
Okay. All right. So moving on. So page 28 of your testimony, and let me know when you're there.
I'm there.
All right. So beginning on line 9, you note the standalone batteries here, and I'm paraphrasing, are generally not required to obtain a separate CPCN, so a certificate of public convenience and necessity. You see that language more or less?
Oh, yes, I don't see it in this section, but I think I did say that earlier in the testimony.
All right. Apologies on the incorrect line site. Believe moving to should still be page 28, but line 11. And if it's not, I can get you the right line site. You note that the project by project economic test, prudence determination, and cost overrun controls that a CPCN proceeding would otherwise provide are largely absent for standalone batteries within the context of MYRP. Do you see that language, or are you generally familiar with testifying along those lines?
Yes, I don't see that language in the site you provide, but I did generally testify to that.
Do you have the North Carolina Justice? We've got a judicial notice and redirect notebook, and if you don't, Presiding Commissioner McKissick, could I approach?
You may.
Okay.
I haven't gone back to work.
There's so much for here.
I was trying to deal with something in the back of the room.
I think.
All right, witness Collins, can I have you turn to, it should be tab 109 in that binder.
Okay, I'm there, tab 109.
Yeah, and so this is an order granting a CPCN. Do you see that?
Yes.
All right. Recognizing obviously this is a commission order, but also recognizing this witness is not a lawyer. Presiding Commissioner McKissick, at this time, I would ask that the commission take judicial notice of its order granting certificate of public convenience and necessity in docket numbers E2 sub 1349 and EC 67 sub 57, which was issued October 16th, 2025.
Judicial notice is hereby taken and notated of the order which you cited and identified.
All right, thanks. All right, going back to your testimony, you note on page 28, but given that somehow these sites got messed up, I'm gonna just double check that that's right. Okay. Yeah, so this is page 28, so this is lines 13 through 14, so 28, like the actual page numbers for your testimony. Just let me know when you're there.
Yes, I'm there.
So you note there the 6 battery energy storage projects together total approximately 1.55 billion on a system basis. You see that?
I do.
Okay. Have you had the opportunity to review testimony from the public staffs, witnesses, should be Thomas and Williamson in this proceeding?
Generally familiar with it.
All right. May I approach Presiding Commissioner
You
McKissick?
may approach.
So I'm going to hand counsel and then also the witness. These are 2 pages. This is testimony that's been filed in this proceeding. So this is
And I would just object to the extent that this is not a pre-filed exhibit that the party has provided notice to us or anyone else of.
May I respond?
Yes.
This is testimony that he's generally familiar with. This is not an exhibit that is, let's say, for example, some report that needs to be self-authenticated. This is evidence that's already in the record. I am not going to be asking him questions that are outside of his expertise, just with respect to testimony that he's already familiar with. And so,
what does this document consist of, sir?
this is regarding a specific distribution spending project that the public staff reviewed and had some assessments with regards to, but this is literally just for purposes of comparing numbers. That's it.
Do you want to just ask him about his knowledge or familiarity without trying to, I mean, it may refresh his recollections sufficiently that he can answer the questions that you have in mind?
Yeah, I mean, the purpose, again, he's generally familiar with it. I mean, to the extent that he were to say, perhaps, in response to the questions that I would have otherwise asked, I am not familiar, could we refresh? The purpose of this is so that he is oriented with regards to what I'm going to be asking questions about. Again, I'm not trying to ask him questions in.
So you just want to refresh his recollections? It's not something you tend to introduce as an exhibit?
No, absolutely not. This is testimony that's in evidence.
You may
Yeah.
proceed.
All right.
Overrule the objection.
Okay. So I'm gonna have you start, I think, with should be page. Actually, let me have you start with page 69 first.
No, you refer to page 69. You were paying to a specific document, not the document in his possession.
I'm referring to the page of the testimony that he's been handed, page 69 of that testimony, and this is the Thomas and Williamson testimony.
Okay. All right. I just don't want to get into the point where we're dealing with documents that you say you're not going to potentially introduce it as
No,
an
I'm not.
exhibit. It's only for purposes of his recollections.
Yes.
So you're trying to just pinpoint where you want him to focus his attention. Is that the purpose?
That is the purpose, Presiding Commissioner.
You may proceed.
All right. So turning to this is page 69 of Thomas and Williamson's testimony. Do you see that table 7 that's there?
I do.
And do you see the total distribution MYRP2 spend that has been identified as 1.7 billion?
Yes.
Is that roughly consistent with like your recollection of the projected distribution MYRP spend from your review of the testimony?
Yes.
Okay, and just again, bigger number, obviously, the 1.7 billion and the 1.55 that you're identifying for these storage projects.
That's correct.
Okay. All right. And then can I have you turn to that other page, to page 11? You there?
Yes.
And you see, should be towards the end of that page, there's mention of the next gen GIS project. Do you see that?
Yes, down towards the bottom.
And you see that that's a project the public staff is assessed and determined to have been subjected by cost overruns and delays. Do you see that?
Yes.
Okay. All right. Moving on, and those are all my questions, Presiding Commissioner. Just was trying to refresh his recollection. It's not my intent to enter this into evidence as a separate exhibit. He has said that he has reviewed this testimony, so that's the extent of my cross in regards to that.
Okay.
All right. So moving on. All right. Not asking you to provide a legal opinion here, witness Collins, but to the best of your knowledge, do distribution projects typically require CPCN?
I believe they generally do not.
Okay. And to be clear, these guardrails that you're proposing with regards to these battery energy storage projects, those would not by and large apply to distribution MYRP projects.
I'm sorry, could you repeat the question?
Yeah, sure. The guardrails that you're proposing, these clawback mechanisms, other mechanisms with regards to battery storage projects that may or may not be subject to cost overruns and delays, those guardrails would not apply to distribution MYRP projects.
That's correct. I did not recommend such in my testimony, but if the commission were apt to do so, that would be their discretion.
All right. Presiding Commissioner McKissick, I have a couple questions, I think, just based off of the supplemental testimony that was provided on the stand.
Please be brief.
I will be very brief. And so witness Collins, I think I heard you say from the stand some of your concerns with regards to the public staff's proposal for Duke, I believe, to monitor the load and load profiles of these potentially eligible LL large load customers. Am I remembering that testimony correctly?
Yes, I believe so.
These are these customers whose load and load profiles would be monitored. I mean, presumably these are customers who are already, receiving metered service from Duke Energy. Is that a fair assessment?
I think so, yes.
And you're generally aware of, Duke's advanced metering infrastructure project where it installed, for the most part, if not all, Duke customers essentially have smart meters that allow Duke's different functionalities with regards to load and load profile. Are you generally?
Objection. We are far afield from the very limited supplemental testimony, and to the extent the witness has knowledge of Duke's AMI meters that he can answer from the stand is one thing, but I think we are far afield from his area of expertise and also from that which he has testified about.
I'll hear you out.
My question is simply what he can testify to with regards to his knowledge. What I'm hearing as a concern, and again, this is cross-examination I'm conducting kind of on the fly based of what I've heard, is that there are concerns that what the public staff is proposing is going to essentially, I think, create issues, whether those are privacy issues or, trade secret issues with regards to its proposal. And so I'm just trying to sort of get kind of down to brass tacks as to what the concern is in light of the already existing capabilities that Duke has to look at the usage of its customers. So to the extent he does not know the answer to that question, that is fine. But if he does, I'm just asking to the extent of his knowledge. And I do think it's relevant given what I believe to be, but I don't know, his party's concerns with what the public staff has proposed.
I'm not quite sure how this relates to what he testified to.
And again, I mean, if it's a question where I can sort of like,
Do you want to narrow it further?
I will do my best again, trying to cross on the fly, not knowing the entirety of his concerns, but happy to try and narrow this a little bit further down.
If you could, because yeah, but
Okay.
see if you can do that.
Yeah.
And I'm going to overrule the objection at this time. However, if that objection is renewed and we're not zeroing in and focusing on something that's substantive as it relates to the testimony he just provided, that would become concerning.
Okay. I guess as a foundational question, so that I'm narrowing down on this, can you elaborate on what SIGFR's concerns are with regards to the public staff's proposal that it would monitor the load and load profiles of potentially eligible large load customers?
Yes, I guess the main concern is that by monitoring these customers that, otherwise, weren't subject to the tariff, that they would become eligible for the tariff through the monitoring and then be subject to, new charges that could potentially increase their costs.
Okay, so the concern is with regards to the retroactive application of this as opposed to the means by which Duke would be assessing whether or not customers would be eligible.
Objection to the form of the question.
Sustained.
So to clarify, the concern is that they could be eligible and pay more money.
I think that's a fair statement. Again, it's not very clear, and that's one of the reasons why we would like to see a separate proceeding to further investigate that.
Okay. No further questions.
Thank you. Public staff. Oh, you're right, environmental defense funds back there. Yeah.
Good afternoon, Ben Smith from the Environmental Defense Fund. I just have a few questions based on the additional testimony that came today. Mr. Collins, you discussed having some unanswered questions about Schedule LL. Do you recall that?
Yes.
Are you aware of whether or not SIGFR sent to public staff any data requests after they filed their testimony, direct pre-filed testimony?
I don't believe there were any.
Okay. Do you recall discussing traditional manufacturers that pose a different quote unquote risk profile?
Yes.
How many of the traditional manufacturers in North Carolina have a load factor over 80%?
I do not know the answer to that question.
And could you give a percentage or anything like that?
I haven't done.
Objection asked and answered.
Well, if I'd like, can respond.
Yes.
The first was asking for a total number. The second question was asking for a percentage.
And presiding Commissioner McKissick, the witness said he did not know. And so he's being asked again to answer a question he has already testified he does not know the answer to.
What I'm going to do is this. Can you restate what your response was?
I do not know.
Your objection is sustained.
Okay. Do you recall discussing billing determinants and how large load can have downward pressure on rates?
Yes.
What analysis did you perform in this rate case that shows adding new large load customers will result in downward pressure on rates?
I have not. It's just general knowledge. And again, that would be something that we would want to look at, I think, in the separate proceeding.
And my final question, were you listening during Duke witness Hager's testimony or watching?
I saw some of it, but not all of her testimony.
Witness Hager, and I'm paraphrasing a bit here, discussed how there are certain charges for upgrades to transmission lines, distribution lines that are going to be socialized across rate classes. Are you familiar with that concept?
I may need a little more context.
So when you pay for improvements or new transmission lines, for instance, those costs are socialized across rate classes based upon a formula. Are you familiar with that?
Somewhat.
So with respect to the downward pressure on rates discussion, to the extent that there are new transmission lines that are triggered by new large load customers, how would the downward pressure on rates discussion interplay with the socialized costs associated with transmission line payments?
I think the downward pressure would exist from, those new customers paying for existing transmission assets that are in rates. So those fixed costs would be spread over more billing determinants.
No further questions.
Thank you. We're approaching a time for afternoon break. We can do that either before your cross-examination, Mr. Felling, or after your cross-examination. Which would you prefer?
Chair, I think I have maybe 10 minutes or perhaps less, so I'll defer to the chair, but I'm ready.
Why don't
to
you go ahead and proceed?
Okay. I will. Tom Felling with the public staff. Good morning or good afternoon.
Good
Mr.
afternoon.
Collins. I was curious. I was trying to listen to your testimony from the stand while trying to also prepare to ask you some other questions on it. So if you'll indulge me, I think you indicated that you did listen to the testimony from the public staff's large load panel, but I'd like to know whether you listened to it from start to finish, including my redirect.
I don't think I listened from start to finish. And I don't think I saw that. I think they testified yesterday morning as well.
Well, I think it spanned a couple days, but yeah,
Yeah, I was traveling to North Carolina yesterday morning when I think they took the stand yesterday. But yeah, I did watch most of it on whatever day that was when they took the stand. So
if you had an understanding about what their testimony was, it could be that your misunderstanding was based on you not seeing the full testimony. Is that a fair statement?
Objection to the characterization of this witness's, excuse me, Mr. Felling's question.
I hear you.
I think it's a fair question. The witness can say that he didn't misunderstand it. I can ask a follow-up question. I'm happy to redraw or withdraw and try again. I'm just trying to move through the cross chair.
I overrule the objection.
How about I'll rephrase. If you had a misunderstanding or about what the recommendation was, I think you indicated that you thought it wasn't clear. Is it possible that that misunderstanding or that area not being clear could be in part due to you not hearing their full testimony?
oh, that's a fair statement. Okay.
And in fact, did you hear counsel from Nucor during their cross-examination ask specifically Mr. Lucas and Dr. Weaver whether public staff schedule LL would only apply to new customers or customers who expanded, their incremental expansion was over 50 megawatts and also subject to that 80% threshold? Do you recall that question and their answer?
I don't think I saw that question and answer.
Okay. Mr. Collins, how long have you been an expert witness and appearing and testifying before utility commissions such as ours?
See, I've been a consultant at Burbank Associates since 2001, so about 25 years as a expert witness employed with BAI. Before that, I was employed with the Illinois Commerce Commission from 1994 to 1998, so about 4 years, and I was an expert witness for staff.
Fantastic. Do you think in any of that time as being an expert witness, you've offered a response to a question that you then needed later to provide clarity and follow up to?
Oh gosh, I'm getting old. There may have been an occasion where that could have been.
You're only human, right?
Right.
Okay. And specifically in response to my redirect of the large load panel, and this is to your concern about whether Duke's, the public staff's recommendation that the commission direct Duke to monitor the load characteristics of customers, and I think your concern was that that was to existing customers. Did you hear my redirect of Mr. Lucas on that topic at the conclusion of that panel's testimony?
Let's see, I did hear Mr. Lucas talk about, gamemanship. I think it was one of the reasons why he wanted, monitoring of customer loads. I don't know if I heard your redirect question.
Okay. Well, and I think hopefully save us some time by just reading the testimony myself. But if you need to turn to their corrected testimony, that's page 39. I'm going to read from lines 9 through 14. And this is the exact same recommendation that I read to Mr. Lucas and asked whether this was still his testimony. And that was, we also recommend that the commission require DEC to monitor the load characteristics of new customers whose load and load factor meet the criteria for Schedule LL and require those customers to begin using Schedule LL at such time as they meet the Schedule LL qualifications. Did you hear his response that was his recommendation to the commission?
I don't think I heard that response.
Okay. All right. And in terms of that use of new customers, is it your understanding or is it reasonable to assume that those new customers would apply to the customers that were taking service in the time period reflected in Schedule LL?
Objective form of the question.
You want to be heard?
I'm asking him if that's a fair assumption to make. He can confirm or deny it.
I'll overrule the objection.
I'm not sure if I understand your question. Could you repeat the question?
Sure. And but in the use of new customers in that recommendation, is it fair to assume that that use of new customers aligns with the public staff recommendation that tariff LL apply to customers taking service on or after January 1, 2027? Since that is the topic that this testimony is addressing.
That would seem to be correct.
Okay. Have you read Schedule LL that's been proposed by the public staff in this docket?
Somewhat familiar with it. I've looked it over, but I don't have it committed to memory.
Okay. Multiple tabs that I've had open here. I have misplaced it. Oh, here we are. I can ask you to turn to it. I can just read it to you. It's your preference, but this would be public staff, large load panel exhibit 3, page 1.
Objection, if he could put that in front of the witness to the extent he wants to ask questions on it.
Do you not have a copy of that in front of you?
I do not.
Okay. Well, I'm just going to read it to you and then I'm going to ask you a question about it. I don't need the
That
witness
will
to
be fine.
confirm that's what it says. So I'll represent to you that large load panel exhibit 3 in the availability section says it says that it applies to customers who request an incremental service meeting the criteria above shall be subject to the following provisions. Do you agree that customers who request incremental service would apply to existing customers who are requesting service over and above their current service?
Objection, again, with a complicated rate tariff, like what is proposed in Schedule LL, for this witness to competently answer a question as to its interpretation and implications and applicability, respectfully, he needs to have it in front of him.
Okay, tell you what we're gonna do. It's now 3:14. We're gonna take a break, come back at 3:24. Mr. Felling, if you can have a copy of that exhibit available or the LL schedule that you prefer to, so the witness can review it, that would be excellent. And that way he can acquaint himself with the details and the provisions which are provided, and you don't have to summarize it or restate it.
That'll work, Chair. Thank you.
Okay, we can now stand in recess for 10 minutes. All right, Mr. Felling, you were conducting cross-examination.
Thank you, Presiding Commissioner. I do have copies of Schedule LL. I have shared it with the witness. I've got other copies that I can hand out, but I'd actually like to ask one question before I move to Schedule LL, if I could.
Go right ahead, sir.
Mr. Collins, just wanted to ask about one other portion
Oh,
of,
1 second. I see that Commissioner Brawley and Commissioner Gaida have not re-entered the room. So let's wait for them to re-enter the room.
Yeah, the rest of the world doesn't stop.
Well, it stops if Chair Brawley's not here. The rest of the world may not, but in this room, we do.
Well, I was just thinking about how the rest of the world didn't stop. So that they came and said, well, we got this rate case, but.
And Commissioner Gaida has returned as well. All right. Go ahead, Mr. Felling. You may resume your cross-examination.
thank you, Presiding Commissioner. Mr. Collins, do you know, as you were observing or listening to parts of the large load panel's testimony, whether you were listening when they were cross-examined by counsel for CUCA? Do you know if you were listening during that time? I think it was Mr. Tratham.
I don't recall.
Okay. Well, I'm going to go over a question and answer that were elicited, and then we can kind of turn to compare that to Schedule LL that I believe you've got in front of you. So the question from Mr. Tratham was, okay, so I believe it was established with the cross-examination by Ms. Kress. I won't repeat that, but the proposal would apply to incremental expansions by existing customers of 50 megawatts or more, so long as the load factor is satisfied. The answer from the panel was, yeah, if a new customer of 50 megawatts or greater and an incremental increase of 50 megawatts or greater would require a customer to be on this tariff. Did you hear that question and answer yesterday?
Objection just to the extent, could you please point me where you are in the transcript, Mr. Felling? And is this volume 14, the expedited transcript as requested by Duke?
I can't speak to whether it was requested by Duke. I can speak to it being volume 14 of a public transcript in this docket, and that being on page 235. That would be lines 5 through 12. However, I'm asking the witness just for his own recollection, as opposed to verifying the truth of my.
Understood. You may answer the question.
Could you repeat the question one more time?
I can reread it all, but my question was whether you heard that question and answer as it was given live from the hearings.
And my answer is I don't believe I did.
Okay, but you've at least heard it now as I've read it. Is that fair to say?
Yes.
Okay. Now, and you've got Schedule LL, which is Corrected Public Staff Large Load Panel Exhibit 2 in front of you. Is that right?
Yes, I have that.
Presiding Commissioner, I've got extra copies
If you could go ahead and circulate those to the commissioners. Sure. Thank you, sir.
Does anyone else need copies? Yes. Mr. Collins, if you're looking at the first paragraph of Schedule LL large load that's titled availability, would you look at the last full sentence that is the halfway of the second to last line all the way to the last line? Would you mind reading that?
I'm sorry, could you repeat that?
The line, the last full line beginning with customers who request incremental service. Do you see that?
I see that.
Would you mind reading that for me, please?
Customers who request incremental service meeting the criteria above shall also be subject to the following provisions.
And in terms of this language, customers who request incremental service, does that seem to be the type of customers that were discussed in the Q&A that I referenced from the transcript?
It seems to be, one concern that I have, and I don't think, any of the testimony that I've heard or the tariff explains it, but I'm going to give you a hypothetical and explain my concern. What if you have an existing customer with 45 megawatts existing, and it expands with 10 megawatts. And now it's 55 megawatts at 80% load factor. Does it now become subject to this tariff? And if it does, then it would be subject to additional minimum demand provisions that it's not subject to. Its cost will likely go up. So, that's one concern I have that I don't think has been answered by the tariff or, any of the testimony.
And we've established you did not hear all the testimony yesterday. Is that correct?
That's correct.
Okay. So if the response from Dr. Weaver responded to that concern and gave an answer to what would happen in that scenario, would you accept that that answer is in the record?
I'd have to take your word for it.
Okay, I believe I can turn to Mr. Collins, are you aware of the commission's E100 sub 208 large load technical conference docket?
I'm aware of it.
Okay, did you participate in that large load technical conference docket?
I did not.
Are you aware that SIGFR withdrew or indicated that it did not wish to present at that large load technical conference?
Objection to the extent that this references a document, if Mr. Felling could direct us to that document rather than characterize SIGFR's position.
Go ahead, you may be heard, Mr.
Presiding Commissioner, I think that the filing that I'm referring to, I don't have in front of me, is in the record. And if the witness is either aware or not aware of it, I'll accept his answer.
I'll overrule the objection. Go right ahead, sir.
Yeah, I'm not aware of that.
Mr. Collins, are you aware that SIGFR met with the public staff multiple times as the public staff was preparing the development of its large load tariff, and that the public staff was seeking and requesting input from SIGFR and its membership on provisions of a large load tariff that would or would not be agreeable, or topics for a large load tariff that would or would not be agreeable to SIGFR membership? Are you aware of those meetings?
I'm aware that there were some meetings. I know at least one because I think I was a participant on Teams with council on that meeting. And it was more of a brainstorming session, giving our thoughts on a possible tariff, but we were never given an official proposal or, some document to look at and comment on.
Presiding Commissioner, I think those are all my questions. Thank you.
Okay, thank you. Go ahead, redirect.
Thank you. Yes, I do have redirect. Mr. Collins, you were asked a number of questions from various council, but I want to take us to the expedited transcript, volume 14, in this docket that was just published very recently, because indeed, you noted that the panel didn't finish testifying until yesterday morning. And I believe this volume only covers the afternoon session from the previous day. In any event, I want to take us to volume 14, which you do not have a copy of in front of you because, again, it was just published. But much like Mr. Felling did, I'm going to read you a portion of the exchange and ask if you heard the exchange as it was happening in real time. So for everyone who is following along, this is volume 14, page 199, beginning at line 17. Question, okay, and would this also apply to an existing customer who is currently taking service in a load ramp schedule that would incrementally increase its load over 50? Answer, yeah. If it ramped up to over 50 megawatts and an 80% load factor, it would also come under our tariff, our proposed tariff. Did you hear that exchange yesterday or the day before yesterday? Excuse me, Mr. Collins.
I believe I did hear that exchange.
Okay, I would like to take us to page 207 of the same transcript, beginning with line 7. Question. So it's fair to say that an existing customer currently in DEC service territory could potentially be subjected to this Schedule LL if their load characteristics change in the future? Answer, yes. Did you hear that exchange?
I'm pretty sure I heard that as well.
Okay, And continuing on the same page of the transcript, beginning at line 12, did you hear question? Is the public staff planning to also monitor the load characteristics of existing customers whose load and load factors meet the criteria for Schedule LL and potentially require those customers, even if they are currently taking service under a different rate schedule, to migrate over to Schedule LL? Answer, well, a couple things. First, the public staff is not going to do that monitoring. We're requiring Duke Energy to, and it's not really a migration. That customer would have to be under an existing schedule and also conform to our tacked on Schedule LL. Did you hear that exchange?
I did hear that.
And last reference, line 24, same page. Question. So the eligibility criteria as for which customers are going to be subjected to this mandatory Schedule LL, it includes potentially existing customers currently being served under LGS, OPTV, HLF, or HP tariffs, correct? Answer, that's correct. Did you hear that exchange?
I did.
Thank you. Mr. Collins, this is Schedule LL being proposed by the public staff is a mandatory tariff. Is that right?
Yes.
And does that mean that if a customer meets the eligibility criteria, then it does not have a choice as to whether or not it will take service under that tariff?
That's my understanding.
Mr. Collins, is it fair to say that there are at a minimum inconsistencies with the public staff's own testimony on this issue?
I think that's fair to say.
Mr. Collins, you were asked a few questions about the cost of service stipulation, and I want to ask whether, in your opinion, the cost of service stipulation is consistent with cost causation principles?
Yes.
And does the PBR statute require that the commission allocate the revenue requirement in a manner consistent with cost causation principles?
Yes, I believe the statute specifically calls out a minimum system study for rates, and again it mentions of reducing interclass subsidies as well in the statute.
Thank you. And you were asked some questions by counsel for public staff about the public staff's meetings with SIGFR about a potential large load tariff. Can you share whether or not the public staff at any point in time provided SIGFR with a proposal that it could respond to in advance of Schedule LL being filed as part of the public staff's direct testimony in this proceeding?
I don't recall us being provided such a document or proposal.
If that document had been shared with SIGFR, would SIGFR have provided feedback and shared its concerns with the public staff ahead of time so that maybe some of these issues could have been resolved on the front end without being resolved in the hearing room?
Absolutely.
Thank you. No further questions.
All right, we'll now move to commissioner questions. And I do have a few questions from our commission staff, which I'll address to you. Mr. Collins, during the commission's large load technical conference in E100 sub 208 last year, SIGFR's counsel, Mr. Ledford, indicated that matters involving rate design, rate allocation, and cost allocation are traditionally addressed in a general rate case. Despite saying on page 26 of your testimony that a new large load tariff could materially affect cost allocation among classes and the assignment of interconnection and network upgrade costs, you now recommend this matter be addressed in a separate proceeding outside of this rate case. Why has SIGFR now changed its position? It seemed to have flipped.
Well, a large load tariff was not presented in the company's direct case. We agreed to a stipulation on cost of service without the existence of a large load tariff. And now we sit here today with a large load tariff presented by staff in their direct testimony, and then we also have one now from the company in rebuttal. So we just have not had adequate time. We have a lot of concerns and questions that remain unanswered, and that's the reason for the request in my testimony to move this to a separate proceeding. And again, as I've stated in my testimony, what happens here in this proceeding will likely set precedent for not only DEC customers, but also DEP customers and as well, possibly Dominion Energy North Carolina customers. So I think it's important for those customers to have due process and, have their concerns. And on behalf of SIGFR, we're definitely willing to work with parties in that proceeding and do it on an expedited basis.
And let me make sure I understand you correctly. I mean, you do not contend that it's not within the purview of the commission to establish a large load tariff in this proceeding. Is that correct? I mean, it would certainly be within our purview.
That's my understanding.
So you do not debate that, or you just believe that it would be functionally better to have a separate proceeding to address the concerns that might be posed by a large load tariff?
Yes, that's a fair polarization of my testimony. Yes.
And I assume that you would, if such a proceeding were established, you would not have objections to it run concurrently with the timelines and timeframes the decision might be made in this proceeding relating to a large load tariff, notwithstanding there might be a separate proceeding to receive testimony or information from interested parties or stakeholders.
I think we're willing to do whatever it takes, Commissioner.
All right. All right. Now, on page 30 through 31 of your testimony, you recommend a battery cost cap, which incremental costs are subject to a disallowance or 50-50 sharing between shareholders and ratepayers. What is your recommended cost cap for projects?
My intent would be to use the cap that the commission sets for each project. So that would be the cap, whatever you approve for each project.
Okay, now on these same pages, you recommend a mandatory clawback mechanism for projects delayed beyond a defined window or cancel. What is your recommended allowable window for delay? And if you could elaborate on that.
We wanted to remain flexible and really, allow the commission to, pick a window that it's comfortable with. So I really didn't have a specific recommendation.
So you have no specific recommendation related to a clawback mechanism as it relates to a NYRP case?
Well, if I understand your question, is how much of a delay would a project be allowed in order for it to be subject to the provision? And again, I think SIGFR remains flexible and coming up with a reasonable a window that would appeal to everyone involved.
Okay. And your final recommendation on this subject is to return underspend to customers for completed battery projects. So I guess first I'd like to know, would this mechanism apply to project overspend as well? And how would this recommendation interact with your recommended cost cap?
So I think the cost cap would be the measure to which any underspend or overspend would be determined.
And what is the total amount of underspend or battery projects completed during MYRP1?
I've seen some of that information, but I don't recall off the top of my head.
You do not recall? Okay, that's fine. And of course, your clawback mechanism recommendation appears to be because battery projects are not subjected to CPCN requirements. For comparison, can you walk us through the resource planning and cost oversight processes that apply to a conventional generating facility versus a battery project?
Well, it's my understanding in the IRP process, both conventional generators and also battery storage projects are recommended, by the company and then, ultimately approved by the commission. It's my understanding that, traditional generation like CTs, combined cycles, those would be subject to certificates of public convenience necessity proceedings. And it's my understanding that battery energy storage projects would not. So they would not be subject to a lot of the front end scrutiny and analysis that goes into traditional generation.
All right. Now, Mr. Collins, you stated on the stand that you were aware that some customers do meet the criteria for 50 megawatts and 80% load factor, but were unable to provide numbers. What is the source of your awareness of this information? And what do you mean by some customers? Can you give a range or number?
Well, I'm aware of, certain customers, due to my work here in North Carolina, and all the rate cases that I've been involved in that, would meet or approach that criteria. But, I just can't give you an exact number of how many customers, meet that criteria at this stage.
And of course, Mr. Collins, you stated on the stand that traditional manufacturers have different operational risks than those signing new ESAs. Please provide specific operational risks posed by these new signed ESAs and your recommendations for how Duke can mitigate these risks so that other ratepayers are not adversely impacted.
Well, with respect to operational risk that's presented by both, a long-term existing customer, regardless of its, load type, and a new customer, is that, that customer has been on the system for a very long time. It's, paid its bills. It has provided rate recovery for assets that were, constructed to meet its requirements from the utility. A lot of its equipment is likely depreciated. So there's not, a risk of under recovery of new investment for those long-standing customers on the system. Now with a new large load that might require, significant investment, that provides the utility with a different risk. It could, leave after so many years, after, requiring these investments. So there's a risk of under recovery from that customer. One of the things that I have seen, and I think, Duke and the staff have suggested it in this proceeding, is, minimum demand provisions related to maybe generation, transmission, and distribution, long-term contract commitments, collateral security. Those are things that can be used to, mitigate some of that risk. But again, I don't have a proposal for those mechanisms in this proceeding. Again, this is one of the things that we'd like to, further investigate in a separate proceeding.
Okay, now, Mr. Collins, you stated on the stand that new large loads will bring down rates for all customers, but in your response to EDF Council, you stated that you did not conduct your own separate large load impact analysis. What then is the basis for this claim?
I've done a lot of rate analysis over the years in my profession. When you have a new large load that comes onto utility that does not require significant new investment, as generation transmission can be very lumpy, so there can be some excess capacity built on the system. So if you have that situation, and you have a new large load come in, and the utility requires very minimal new investment, and that large load provides a tremendous amount of new billing determinants, the existing fixed costs of the utility are going to be spread over additional billing determinants, and that's going to bring the average down. So that's going to put downward pressure on rates for existing customers. We're going to be able to spread those existing fixed costs over more sales, and that's going to put downward pressure on rates for everyone.
So what recommendations within this rate case will cause such a rate decrease to occur?
I'm sorry, could you repeat your question?
Yeah, what recommendations within this rate case will cause a rate decrease to occur?
Again, I don't think I can really answer that question. I haven't seen any analysis that would, indicate such.
All right, now, Mr. Collins, you state on the stand that there may be risk of traditional manufacturers leaving under certain proposals. Can you provide more information as to what specific elements of a large load tariff would cause traditional manufacturers to leave?
Well, under my hypothetical that I responded to staff council, with my 45 megawatt example of an existing customer that maybe expands to 10 megawatts or expands by 10 megawatts, and now its total load is 55 megawatts. Again, it's not very clear to me if it would be subject to this new large load tariff. But if it were, then that means, 45 megawatts would now be subject to, new demand, minimum demand provisions, maybe new collateral requirements. I don't know if its existing ESA is going to be reopened, and now it's going to be subject to a longer contract term. Those are all things that could apply to an existing customer that could raise its costs. When it came onto Duke's system, it made a decision to locate on Duke's system, based on the circumstances that it knew at the time. So, by being subject to a new tariff, that's going to change the circumstances. It might affect its business model. So, it could put its future operations at risk.
Now, Mr. Collins, you're a very experienced expert witness who's testified in many jurisdictions for quite some time. How many years has it been?
Let's see, from 94 to 98, I was an expert witness for the commission staff. So 4 years there, and then over 25 years in my current position with Baker and Associates. So about 29 years or so.
Which is quite substantial. I guess the question I have in my mind, you taken the stand today and discussed testimony provided by the public staff's large load growth panel. But during the course of your testimony, you stated that you didn't even hear and observe a good deal of their testimony or redirect because you were traveling or trying to get here. So I'm just wondering why you would take the stand and answer a series of questions about their testimony without having full and complete knowledge and awareness of everything that was stated before you took the stand and began to answer questions.
I've read the testimony, listened to as much of the hearing as I could, and based on the evidence that I heard, I answered the question to the best of my ability.
Do you think your answers might have been different if you had listened, heard, and observed all of the testimony that was part of the record?
I did miss some of the redirects, so my answers could be different.
That's fair to say. I understand. Let me see if there are any other questions of my colleagues. Chair Brawley, Commissioner Tucker, Commissioner Gaida. Okay, opportunity for questions on commissioners' questions. I see Sigfer.
As long as no one else has questions.
Okay, go right ahead.
Thank you. Following up on Presiding Commissioner McKissick's last series of questions to you, to the best of your knowledge, did you have an opportunity, as limited as it may have been, to review the recently published expedited transcript from day one of the large load panel's testimony?
Yes.
And we discussed some of the exchanges that were transcribed in that transcript on redirect. Is that right?
That's correct.
And as we sit here today, we are still waiting for day two, the second part of that transcript to be published in this docket, correct?
That's my understanding.
And so neither of us and no one in this room has yet had an opportunity to review that expedited transcript because it's not yet been completed and made part of the record. Is that right?
That's my understanding.
In response to a question from Presiding Commissioner McKissick regarding businesses' decision to locate in North Carolina or to expand in North Carolina, what is your position regarding whether a large load tariff would make North Carolina more or less attractive to do business?
Well, I think a lot of the details, we have questions about, and again, that's why I, suggested we have a separate proceeding, but, to the extent that we don't get the large load tariff correct, and, based on cost causation as, recommended by the statute, we could, cause unintended consequences and, new businesses may not come to North Carolina.
And so is it fair to say that SIGFR seeks to avoid those unintended consequences and is ready, willing, and able to work collaboratively with other parties to make sure that does not happen?
Absolutely.
You got a question from Presiding Commissioner McKissick on what could be done in this rate case to lower rates. Do you recall that question?
Yes.
Okay. Is there a difference between cost avoidance and savings?
Well, when I think of cost avoidance, I look at, the difference between maybe what is proposed by a party or the utility, versus what the commission issues in its final order. So that would be, cost avoidance. Cost savings in my mind is, do we do something that reduces current rates?
And so when we talk about downward pressure on rates, at least in the context of your testimony here today, are you talking more about cost avoidance? Rates are going to go down in an amount lower than they otherwise would have, or excuse me, up in an amount lower than they otherwise would have? Or are you talking about savings?
Probably cost avoidance.
Okay. Thank you. No further questions.
Thank you, sir. We appreciate your testimony today. You're hereby released. And of course, the next in the queue here is Environmental Defense Fund.
Presiding Commissioner, Nick Jimenez with NCJC et al.
Okay.
My understanding, and I've participated in this, is we have agreed with other interveners that are, they have graciously allowed us to put up our witnesses first, one of which has a flight in a few hours. If that's all right with
Okay,
you, we would.
all right, that's fine.
Thank you.
The schedule moves around from what's printed, so. Schedule moves around, the times move around.
So, what source?
If you could put your left hand on the Bible, raise your right hand. Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Oh. Go ahead.
Thank you, Presiding Commissioner McKissick. Mr. Wilson, could you please state your name, title, and business address for the record?
My name is John D. Wilson. I'm Vice President at Grid Strategies LLC, whose business address is 9207 Kirkdale Road in Bethesda, Maryland, and I operate out of Lexington, Kentucky.
Please briefly describe your role and responsibilities at Grid Strategies.
I am an expert witness in state regulatory proceedings, and I also do studies for various clients on topics related to electricity regulation across the U.S.
Mr. Wilson, on May 29th, did you cause to be pre-filed in this docket direct testimony and 2 exhibits which contain confidential information and collectively consist of 150 pages?
Yes.
On July 8th, did you cause to be pre-filed in the E-7 sub 1329A docket a summary of your testimony consisting of 5 pages?
Yes.
On July 9th, did you cause to be pre-filed in this docket corrected testimony which contains confidential information and consists of 118 pages?
Yes.
Do you have any other corrections you need to make to your testimony?
No.
Presiding Commissioner McKissick, I would move to have Mr. Wilson's pre-filed direct testimony and exhibits, which collectively consist of 150 pages, pre-filed testimony summary consisting of 5 pages, and corrected testimony consisting of 118 pages, entered into the record as though given orally from the stand, and to have the exhibits attached to his pre-filed direct testimony identified as pre-marked.
Without objection, your motion is allowed.
And Presiding Commissioner, given the events of this afternoon, I would ask the commission's leave to ask one question that would elicit further direct testimony in response to the public staff's proposed large load tariff.
I'm going to go ahead and permit it since it's one question.
Yes, sir.
But let's try to limit it. I'm trying to be fair, but at the same time, I don't want to create challenges in terms of logistical things that can occur with everybody else seeking similar privileges along the way and changing cross-examination times and the like. But in an effort to be fair, you may proceed.
Thank you so much. Mr. Wilson, can you very briefly give your opinion of the public staff's large load tariff proposal?
Thank you. Thank you, Presiding Commissioner McKissick, for the opportunity to share my opinion. In general, I understand the reasoning behind the public staff's proposal and the balance it tries to strike and support it with some significant modifications, some of which relate to items that I identified in my direct testimony, and some of which actually I have derived from the live testimony of the Duke witnesses. So I'll briefly run through those modifications that I would recommend. First, the most important one, I think, is the term. That was a significant area of disagreement that was testified to by the public staff, where they disagreed with my recommendation of 20-year term and recommended the 15-year term. And I would accept their 15-year or 10-year for the smaller companies term if it were tacked on to the end of the load ramp. My concern there being that a company could propose a ramp schedule that was a very small amount of power at the first front end of it, with most of the energization occurring in year 5, and therefore essentially cutting the public staff's proposed term of 10 or 15 years down to 5 or 10 years for most effect. And that then has carry-on effects in other aspects of their proposal. The second thing I'll mention is that I would still maintain my recommendation for the thresholds and the minimum billing demand that are set forth in my testimony. The thresholds being 25 megawatts and 85% load factor, and all loads above 100 megawatts, irrespective of load factor, and the minimum billing demand of 85%. The third thing I want to mention is the exit fee language. That I think is a really important thing, because there's a compounding effect of a lot of these percentages that you've heard about that hasn't really been summed up. And I want to turn back to the cross-examination of public staff that was conducted by Mr. Snowden, where he was going through an example 720 megawatt contract demand customer, and doing some quick math of my own based on his numbers. A customer that customer's implied obligation for fixed costs, if they operated at their full contract demand over 15 years, would be $2.7 billion. But the cumulative effect of the reduced billing, minimum billing charge, or excuse me, minimum billing demand of 75%, the exit fee discount of 75%, the 5-year ramp up period, and then the 20% contract reduction in the exit fee, excuse me, the 20% contract reduction, I misspoke, not in the exit fee, but in that is discretionary to the customer. You add all of those things up, and that same customer could reduce their financial obligation over 15 years to just $552 million. So instead of $2.7 billion, $552 million. And that reflects a very substantial cost shift. So I think the commission needs to, in looking at the public staff's proposal, needs to think through the implication of the cumulative effect of all of these different pieces, and whether together they present, whether they really do protect other customers from cost shifts. Finally, another issue that's been discussed quite a bit is whether there should be a large load class established now or wait until the next rate case. And I would just reflect on a lot of the cross-examination that was very concerned with the fact that this was not presented as Duke's proposal, but that it was presented later in the case, and it makes it harder to review. If the commission does not rule in such a way that the class is established in advance of the next case, Duke may not choose to propose a new class. And if that's the case, then it's effectively dead in the next case as well. So making that decision now is important for the next case. I agree with all the concerns about establishing the class now in terms of applying that class to rates through the cost of service study and redoing that. But I disagree that the commission can't go ahead and establish that it will be a class and that it would be treated as one for purposes of reporting and for purposes of future cases. However that's accomplished is, a matter of procedure and not of importance to me substantively. And then very briefly, we also mentioned our testimony, the clean transition tariff being included as an option to the large load tariff. I would still continue that recommendation. And finally, I support, again, one of the strongest aspects of the proposal of the public staff is their required facilities approach. And I support putting the language for that in the large load tariff itself. Right now, as I read the proposal, it's only in the ESA. And so I think it's important that it be included in the tariff itself for consistency with the way that other similar matters are handled. And those are the modifications that I would recommend to the public staff's proposal. Thank you for the opportunity to share that.
Thank you. Thank you, Presiding Commissioner. The witness is available for cross-examination and questions from the commission.
All right. Let's see. Sigford?
I have no questions. Thank you.
All right. Trying to go down here real quickly to see who has reserved your time. Who is next in the queue? Microsoft? Come on down.
I was planning to wave my cross, but my name got called. I couldn't resist. I just have one or two questions. Good afternoon, Mr. Wilson. Ben Snowden here on behalf of Microsoft. Just a couple of questions. You mentioned your recommendation that you mentioned from the stand a few moments ago that you believe the commission should look at the cumulative impacts to ratepayers and cost shifts of all the different pieces of a proposed large load tariff. Is that right?
Yes.
Okay. Would you also agree that on the other side, the commission should also be looking at the cumulative impact of all of the different pieces of the tariff and the different obligations on large load customers themselves?
Yes.
Okay, thank you. And you also talked a moment ago about required facilities. And I want to, you mentioned that you believe it should be in the tariff. Do you have a sense of how the allocation of costs that would be required to implement that tariff language would be done?
Yeah, after listening to all the cross-examination over the past few days about how that might be done, I went back and read the testimony and found that it was pretty clear to me how that would be done. I recognize it's on a case-by-case basis, but as someone who reviews these type of subjective matters in a lot of cases, I do think it's pretty clear what the definition of required facilities is. And I would note, I might have that in my notes here. I don't seem to have that, the name of it, but there was a proposal made by, I think it was Microsoft. It might have been another party in Nevada for a very similar mechanism. And it also, I think the name of it is escaping me, but it's, I think it's the same basic concept as what Microsoft proposed there. And I think the idea is, it's going to mainly affect transmission facilities, I think. And to me, identifying transmission facilities that are required but not customer dedicated is still a pretty straightforward task. I do think I agree with the idea that after this is done for a number of years, there may be the potential to put in place more codified, so to speak, guidelines for the company to follow that would provide customers with more transparency. But I do think that upfront, the approach proposed by the public staff is appropriate.
Okay, well, let me ask you a quick question. So I think you would agree that the what is proposed conceptually for identifying dedicated facilities, which are required to only support a specific project, that is a fairly straightforward exercise in your view?
Yeah.
Okay. But the public staff also talked about allocating the costs of other required facilities, which might benefit, either be built for or might provide benefits to other customers or to the system as a whole. Do you recall that?
Yes.
Okay. And is there a proposal on the table here that you know of for how that would be done? Or are you looking to other jurisdictions for ways in which it might be done?
I think the public staff's, the way that they have described it, provides adequate guidance to the company, in my opinion, as to how that might be done. I think there would be room for parties to come in and dispute that at some point, and that might lead to more clarification around that. But I do think it's adequate as a starting place. This is not something that I find unusual in these types of matters, that there is a general approach that's agreed to first and it's refined over time by commission further review. So I don't think the lack of a highly precise, sort of algorithm that one might apply in all conceivable circumstances at the front end is a reason to not go forward with this proposal. I think it is the concept behind it is very fair. As a matter of sort of context, commissioners, our firm recently completed a study where we looked at federal cost allocation of transmission costs. And you're probably generally aware that the Department of Energy required FERC to initiate a proceeding in which it looked at how cost allocation is affecting customers, for transmission costs. And, we reviewed, I think, a dozen different options for that. And it's complex. Cost allocation questions like this are complex. There's lots of people who would like to say, let's just direct assign all the costs. There's people who want to say, let's do it on a benefits basis. There's different different criteria. I think this is what you're getting at, Mr. Snowden, is that there's sort of different criteria there, and the public staff were not super clear as to which criteria they were recommending. Was it benefits based? And if so, which benefits, that sort of thing. I think that's a fair question, but I think it is one that in the context of these very specific proposals, for most of them, there's not going to be a lot of ambiguity. There may be some, in fact, I would be surprised if there were not some where there would be more ambiguity, and that might be something that might come up in a rate case where parties might contest that the allocation decision recommended by Duke Energy was not correct. So I think it would be appropriate for Duke and the counterparty in that to be aware that any contractual agreement that they reach around required facilities is the entire tariff. And, we heard exhaustively the other day that the tariff itself the contract itself is subject to commission modification, if the rules of the commission change. So I think this is something that everybody needs to go in eyes wide open, that we're going to make a good faith effort to get the costs allocated correctly. And then once that's done, there is the possibility of review and revision.
Okay. And you just mentioned a few moments ago the Nevada framework, the framework that was proposed by Microsoft in Nevada as a possible jumping off point for a conversation about that. Is that right?
Yeah, and thank you for confirming that my recollection on that was right. I made a note of that earlier and just couldn't find it.
Yes, great. That was cited in Mr. Gable Frank's testimony.
Great.
Okay. All right.
I'm sorry, that was referenced in Mr. Gable Frank's testimony. Those are all my questions. Thank you.
All right. Let's see. According to the schedule I have, Nucor had reserved time, but I don't think Nucor has counsel here at the time being. Walmart.
No questions from Walmart.
That takes us to the public staff, unless I've overlooked someone. Not seeing anyone I've overlooked. Go right ahead.
Thank you. The public staff has no questions.
Okay. Any redirect?
Yes, Presiding Commissioner, just one question.
Okay.
Mr. Wilson, you were just talking with Mr. Snowden for a while about required facilities and direct assignment. Just to be clear about this concept, does direct assignment of those costs in the public staff's proposed large load tariff fully resolve your concerns about recovering costs to serve large load customers?
No. It addresses a portion of the cost. So I think that was one area also that got a little confusing in the conversation. So for example, there was a lot of discussion about whether certain proposals by public staff would address the timing issue, whether costs are recovered from a large load customer at the same time that they're being expensed in rates or recovered in rates in general. And so the required facilities charge fully addresses that concern, in my opinion, because you've taken that out of general rates and you've directly assigned a portion of those costs to customers, et cetera. The portion of costs that remains in the general embedded cost rate structure, and that would be recovered through, in part through the demand charge and energy charges to the customer, would be still an issue that a lot of the other provisions that we've just discussed would be mitigating. I'm not certain that even the best proposal cobbled together from everyone's recommendations would 100% address these concerns, but I think we can get a long way there with the record in this hearing.
No further redirect.
All right. I do not have any questions from our commission staff, but let me see if my fellow commissioners have questions. Chair Brawley, Commissioner Tucker, Commissioner Gaida. Okay, sir, you're released at this time. We appreciate your testimony. Thank you for appearing today.
Thank you.
All right.
Commissioner McKissick, looking at the time, I'm just curious in the amount of cross reserved. Just wondering if you want us to proceed with our next witness.
You're welcome to proceed. I don't think we'll be able to conclude it. We'll probably have a hard stop at 5:15 today.
Well, then we would, NCJC would call Dr. Steve Keim to the stand.
Okay. We're trying to get through all the witnesses who made trips from out of town. They're here. You can put your left hand on the Bible, raise your right hand. Do you solemnly swear the testimony you're about to provide in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, title, and business address for the record.
My name is Steve Keim. I am the president of Narrative 804, 625 North Siegel Road, Madison, Wisconsin, 53705.
Please briefly describe your background and qualifications.
I have been involved in regulations since 1980. So this is my 46th year. I've worked for 21 years on the staff of the Wisconsin Commission and have been consulting for the gap of that period. I have a doctoral degree in finance and corporate strategy, a master's degree in finance, and I'm a chartered financial analyst.
On May 29th, 2026, did you cause to be pre-filed in this docket direct testimony consisting of 69 pages with 4 exhibits marked SK1 to SK4?
I did.
And did you cause to be filed non-substantive corrections to that testimony on July 9th?
Yes.
Do you have any other corrections to your testimony?
I do not.
If the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
Yes.
And did you prepare a summary of your testimony that was filed on July 8th?
Yes.
Presiding Commissioner McKissick, I would move to have Dr. Kimes' pre-filed direct testimony and summary entered into the record as though given orally from the stand, and to have the exhibits attached to his pre-filed direct testimony entered into the record.
Without objection, your motion is allowed.
And this witness is available for cross-examination and questions from the commission.
Okay. I have Attorney General that had reserved time, but I take it you're waiving your time? And that brings us to Sickfer,
No questions. Thank you.
which takes us all the way down to Walmart,
No questions.
which takes us to the public staff.
Thank you. Will Freeman, an attorney with public staff on behalf of the using and consuming public. Doctor, could you tell me, does the law require the commission to prevent a stock price decrease when determining the appropriate ROE?
Well, I'm not a lawyer, but I can read the Hope decision, and the Hope decision says that a loss of market value does not invalidate a commission order.
Thank you. No further questions. Thank you, Presiding Commissioner.
All right, any redirect?
No.
I don't think you have to worry about the time. We do have a few questions from commission staff, and we may have a few questions from our commissioners. Sir, on page 60 of your testimony, you state that ROEs above the cost of equity may be appropriate under the right conditions for some utilities. What are those conditions, and what is your assessment of DEC in regard to those conditions?
There are a couple reasons why it might be above. The most important of which is a performance reward. We talk a lot about performance-based rate making. Regulation has always been performance-based rate making. The commissions have in the past. For the history of regulation, when a utility has done something particularly well, they will actually explicitly grant an ROE that is above the cost of equity. Now, there are some more fundamental questions. The ROE equal the cost of equity actually in economic theory assumes essentially perfect competition in non-utility markets. And that's not true. So if you wanted to mimic what a real market is, you could include a premium for that. Now, these are generally not big premiums, but so there are really two. One is a reward and one is aligning with an imperfect market. And your answer was, now this is with respect to DEC. This is where I come in as the financial expert without a lot of local knowledge. Those are local questions. Those are things that this commission looks at and says, oh, you did a great job on the low income program. I cannot know the waterfront of all your issues. So what I've proposed is that the commission look at DEC and say, this is what they do well, this is what they do poorly, and that might generate then one of these rewards. That is a very difficult part of the process, there's no question about it. But I don't know enough about DEC as a utility on its local operations to really weigh in on that.
Okay. Now, in his rebuttal testimony, DEC witness Coyne criticizes your use of market-to-book ratios as a guidepost for determining an appropriate ROE. What is your response to his criticism?
So I think, to be clear, the market-to-book ratio is still standard finance. If the utility or any company's stock price is above its book value, the ROE is above its cost of equity. The question is, how does the commission use that? And I do not suggest, if you read my testimony, strict adherence to drive the stock price down to book value. It is still a particularly important marker. And, you know, there's the article by former chair Van Nostrand at the Department of Public Utilities, which is in my exhibit, that says that gap has just gotten so big. A market book of 2 is quite large. When I started at the Wisconsin Commission, the market books were 0.8. And we kind of worked up to about 1.1, 1.2, and that was what people thought might be appropriate. So is the market to book a valid measure? Absolutely. Should it be a target? It can be, but should it be two? No, that's just too high.
Okay. Now, in his rebuttal testimony, a DEC witness Cohen criticizes your single-day estimate for dividend yield and lack of support for your risk-free rate in the CAPM. Why did you make that choice instead of relying on a trailing average?
Because finance theory makes it clear, and the evidence shows that current price today, as counterintuitive as this might be, is the most accurate predictor going forward. Because if you think about what you're doing, you're taking stale information and you're saying, well, I'm not going to just take what I know today. I'm going to go back as far as 180 days and use that information. Back when we had a different Fed chair, we weren't having a conflict with Iran, all of those sorts of things. That information is all in the current stock price because investors know that. And when they price the security, so to the extent it's relevant, that is actually making your estimate less accurate. I've written a paper on that. It's you can confirm it with evidence. It sounds counterintuitive, and there's a technical reason. If you just bear with me for a second, stock prices follow what's called a non-stationary stochastic process. What that means is there's no information left in the old data. There's no relevant information there because the market can adjust every day to all of that information plus any new information. So I do that. Now, the Mr. Coyne is actually correct because I forgot to put the site of the day that I used the interest rate, but it's the same day as the stock prices. I should have said that's the same day. It was single day, same day.
Okay. Now, in his rebuttal testimony, DEC witness Heath calculates that your recommended ROE results in funds from operations, our FFO, slash debt, below Moody's downgrade threshold and limits DEC's ability to respond to unexpected events. What is your response to this analysis, and how can the commission be certain that your recommended ROE will maintain DEC's credit rating under Moody's methodology?
Okay, Commissioner, there's a lot in that question. All right. So first of all, why would the funds from operations go down? Go down because customers are paying less. If the bonds are downgraded because of that, the cost of debt will go up, but the savings from the ROE reduction are much bigger. So the idea that we would look at cost of debt or bond rating to determine whether customers will pay more or less is just incorrect. It's an ROE reduction is much more powerful than a credit rating increase. So the bond rating is often looked at as like a badge of honor, or somehow we're going to save customers money. 70% of the utilities in the United States have a BBB bond rating, which is lower than DEC. That's the standard, is BBB. There's nothing wrong with the BBB, and it's not true that BBB rated companies have higher costs of capital, which is debt and equity combined. If you're following, it's that the cost of debt is the bond rating, but the cost of capital is more complicated. The cost of capital is 5 variables: amount of debt, cost of debt, amount of equity, cost of equity, and tax rate. When you run that equation, and that's the one that matters, you do not find that BBB is more expensive than single A. It has a higher debt cost, and that's the easiest thing to see. But everything else works behind the surface. And so the fact that 70% of utilities in the country are at BBB, and the commission says, you could do AA. If you wanted to, you could give an ROE of 11 and you could move the common equity ratio up to 60. Well, why don't we do that? Because it's so expensive. Start to see that there's actually a cost of maintaining a strong bond rating. So I don't doubt that. I know for sure that the FFO will go down because our recommendation is 9.1, but it doesn't mean that customers will pay more for capital.
Okay, very good. Let me see if my fellow commissioners have questions. Chair Brawley. Commissioner Tucker. Commissioner Gaida. Questions on commissioner questions?
Before I have questions on commissioner questions, Presiding Commissioner McKissick, I believe early on you had a two-part question for Dr. Keim. the first was single day versus trailing average, and then you had a second question about CAPM that I'm not sure Dr. Keim addressed, and I didn't get a chance to jot it down. Could you just refresh me on what that second question?
Okay, sure. Let me get back to it.
I believe it was just the interest rate. The second part was, what was the date of the interest rate?
Oh, maybe.
And I responded to that.
Okay,
Yeah.
I apologize. I missed jotting it down, so I was afraid it didn't get answered. So and now I'll just see if there's questions.
Questions of Commissioner questions? Yes, sir.
Not from Duke.
Not from Duke. Okay. Do you have any, Mr. Neal?
Yes, Presiding Commissioner McKissick, on the question you had from Presiding Commissioner McKissick about market to book ratios, could you, in your testimony, you cited Roger Morin for the proposition. I think it's at the bottom of page 13 into page 14. Can you just remind the commission what Roger Morin's position was on this issue?
So Dr. Morin states that as long as you maintain a market to book of 1, you've essentially set the ROE at the cost of equity, and that is consistent with Hope and Bluefield. So if you hit it's the bare minimum, but if as long as you're there, you're not going to confiscate capital. So it's an austere minimum, but it survives the tests of Hope and Bluefield.
And you were you were giving response to the question about whether or not the commission should be concerned if the FFO to debt ratio changes, and you gave in your response, you talked about the majority of utilities having the BBB bond rating. Can you remind the commission about another example you gave in your testimony about a lowered ROE in this interaction between increased cost of debt versus a decrease in the cost of equity?
Yes, if you bear with me for a moment, I have to, I have a visual on Arizona Public, on page direct 36, if people want to refer to that. It shows Arizona Public Service Pinnacle West, which is the parent of Arizona Public Service Corporation. The Arizona Corporation Commission in November of 2021 lowered the ROE of Arizona Public Service Company from 10 to 8.7, 130 basis points. And there was obviously a market reaction to that. The stock price went down and the bonds were downgraded and the cost of debt went up. But if you look at this picture, you can see that Pinnacle West never hit the threshold, the market to book of 1, never came close to that. And it began issuing $600 million a year more it added $600 million a year more in investment after the lower ROE. There just simply isn't a relationship. We hear a lot, but if you look at the data on these things, you see that we are so far away from hitting thresholds that are damaging to either consumers or the company, that there's just a huge cushion in there. And the Arizona Public Service Corporation not only continued its business, but it actually substantially increased its investment. So there's just not a record that these things are as awful as they're made out to be. If we have to move beyond the rhetoric and look at the data, and that picture on page 36 shows you there's really not a problem.
No further questions. Thank you.
All right, sir. We appreciate you being here this afternoon. We appreciate your testimony and your release at this time.
Thank you, Commissioner.
Come on up. As I mentioned, we do have a hard stop today at 5:15, so we'll go as far as we can. Sure. We'll give you a minute to get settled. and may get everything done. If you,
Good afternoon.
Good afternoon.
Could you please state your name and business address? for
if
the
you
record,
could do one thing first, put your left hand on the Bible, raise your right hand. You solemnly swear the testimony you about provide today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You may proceed.
Can you please state your name and address for the record?
Sure. My name is Carolyn A. Berry. My address is 2001 K Street Northwest, North Building, Suite 500, Washington, DC, 20006.
And where are you employed, Dr. Berry?
At Bates White Economic Consulting.
And what is your position there?
I'm a partner.
Are you the same Dr. Carolyn Berry who caused to be filed in this docket on May 29th, 2026?
Yes.
Testimony of 16 pages and 2 exhibits.
Yes.
Was that testimony prepared by you?
Yes.
Do you have any corrections to your pre-filed testimony at this time?
No.
If I were to ask you the same questions that were in your testimony, would your answers be the same?
Yes.
Did you cause to be filed in this proceeding a summary of your testimony on July 13th, 2026?
Yes.
Is that summary a true and accurate to the best of your information and belief?
Yes.
I ask that Dr. Berry's direct testimony be copied into the record as given orally from the stand. And I also ask that her summary be entered into the record.
Without objection, your motion is allowed.
The witness is available for cross-examination.
It looks like Sigfur's in the queue.
No questions. Thank you.
All right, it looks like, is it EDF?
Good afternoon, Ben Smith for Environmental Defense Fund. Ms. Berry, I want to talk to you about near the end of your testimony, page 14.
Yes.
And there's a question, is the rate case the appropriate proceeding for the development of a large load tariff? Do you see that question?
Yes.
And your response, I think, as I paraphrase it here, is no. Is that in response to any rate case proceeding, or is it just this rate case proceeding?
This rate case proceeding.
And what's the basis for that position?
Part of it is just the sequence of events and the ability to, the fact that there wasn't a large load tariff presented initially and it came in after the fact, and there wasn't a robust opportunity to propose alternatives or to dig into the details of what was proposed.
Thank you. And so you talked about sequencing. Is it your position that the utility, either in this rate case or generally, has to be the one to introduce a new tariff?
Not necessarily. I think that, well, I guess in a rate case, if it depends upon what, how many rounds of testimony you get to put in. And also it depends upon what the history is, if it had come up previously, in a prior case, or there had been proposals on the table before. So I guess it just depends upon the history in the jurisdiction you're in.
But a general rate case proceeding it requires effectively a full accounting of a utility's investments, isn't that right?
Yes.
And wouldn't it be correct to say that that's an appropriate time to consider rate and class allocations?
Yes.
So I guess I'm asking then, why wouldn't it be an appropriate time to have a new tariff?
If there was ample opportunity to examine it, the tariff in this proceeding is as staff says, a radical, don't know if they use that word, historic shift in methodology. So this is something completely new. And you would need a fuller vetting of that.
And so would that fuller vetting then have to be pushed to the next rate case?
Or a different proceeding.
Okay, but backing up a little bit, discussing class and rate allocations in order to sort of do a full assessment of how the new tariff would work, wouldn't it, doesn't it logically follow then it would have to come in the next rate case?
Ultimately, I think, there's many questions. There's sort of the whole format. I guess there's a threshold question. Do we even need a new tariff? First of all, has that even been established? And then, what framework are we going to use? There's a lot of big issues that need to be fleshed out. I think that those could be fleshed out. And then when you got to the rate case, you could implement what had been agreed to or decided upon.
Thank you. No further questions.
All right, thank you. Looks like Microsoft is next in the queue, which would take us to public staff, if I'm reading the schedule correct.
No questions, presiding commissioner.
All right, is there any redirect?
One redirect. Counsel for EDF asked about having a tariff in a rate case. Isn't it the position in your testimony that the tariff could be in a rate case or in a separate proceeding, as you noted?
Yes.
So we don't need to wait for another rate case if the commission were to put this in a subsequent docket.
And decide all the issues.
Thank you.
All right, I do not have any questions from our commission staff, but let me look to my colleagues to see if there are any questions. Kara, bro.
No questions.
Commissioner Tucker, Commissioner Gaida. Hold 1 second, please. I saw a hand raised in the rear of the room. Have I made a, is there a question you have of this witness? The one I saw has been stricken. And I'm looking at my commission staff. It looks like Commissioner Tucker may have a question. Go right ahead.
Ms. Berry, just quick, one question. On page 14, you said that we shouldn't have tariffs in a rate case. Is that what I understand from your testimony?
In this rate case.
In this rate case?
Yes.
Because there's not been ample time to evaluate the current LL.
That's right.
Yeah, just too many things that have not been evaluated, flushed out, I think is the term you used to determine that. Is it, you speak so softly, and I can't hear well, but did you state that it could be done and should be done in a different proceeding, standalone tariff case, or way to evaluate cost causation for the large loads?
Yes, in a separate proceeding.
Okay, very well. Thank you, ma'am.
And it looks like your name appears in 2 different spaces within questions that I have here. So there are a few questions of you, okay, from our commission staff. Dr. Berry, Google has publicly stated that its data centers are increasingly capable of providing demand response by shifting machine learning workloads, and that this flexibility can reduce the need for new transmission and generation investments. Is that an accurate characterization of Google's public position?
I'm sorry, what were you reading from? I don't know what their public position is.
You do not know what their public position
I know what they're involved. I don't know if there's an official corporate public position, I guess. I know things I've seen in the press that lay out their positions. I don't know that there's one thing.
Okay. Well, answer these questions to the best of your capacity then.
Sure.
All right. Given multiple public commitments in other states that Google has made, are you confident that flexibility and curtailment provisions being considered for a potential North Carolina large load tariff could be met by Google's data center facilities in North Carolina without materially affecting its operations?
So in my testimony, I explained in detail how data centers in many cases cannot provide flexibility, especially the older data centers, which I believe is what is in North Carolina, and how it's very data specific. So I don't know all what that data center in North Carolina is used for, and if it could provide flexibility. My understanding is that it's limited. So if the question is, can Google provide flexibility in North Carolina? I think the answer, based on what I know, is not now, but they would like to. I know that it is an area they're working on actively and trying to find solutions so that they can provide flexibility. They think that's beneficial to them. Having more transmission capacity available is greatly beneficial for new loads that want to get on the system. So it's a priority for them. But I don't think they're there yet in North Carolina.
Okay, now Google has publicly represented that their data center flexibility can support grid reliability, facilitate interconnection, and reduce the need for additional infrastructure. Should the commission understand those statements to mean that data is prepared to invest in the operational capabilities necessary to provide meaningful demand response and operational curtailment in North Carolina?
It's my understanding that they're looking for ways to do that. Again, it's locational. It depends upon what the need of that particular data center is. And I think that there are certain circumstances where they cannot provide flexibility, but there are others where they can, and they're working on technology to try to expand those abilities.
Okay, now Google publicly states that its data centers can provide meaningful demand response and flexibility. Should utilities reasonably rely on those statements when planning generation and transmission investments needed to serve Google's future load in this state?
I'm sorry, I didn't get where the question was in that.
All right, simply when Google publicly states that its data centers can provide meaningful demand response and flexibility, should utilities reasonably rely on those statements when planning generation and transmission investments needed to serve Google's future load in this state?
I think that they shouldn't rely on statements, but they should be having a conversation directly with Google when they're doing this kind of planning. There's a lot of, if people talk and could come up with joint solutions, which is in the vein of the CTT tariff, building something for the system that you're in jointly, or, getting on the same page with that. I think it's a win-win for both the data center and the state.
All right. Now, Dr. Berry, in your testimony, you criticized DEC's contract approach to large loads, which could be addressed within the scope of this rate case, yet you appear to recommend deferring it to another proceeding. Do you doubt the ability of the commission to consider the complexity of this issue or of large load tariffs in general within this rate case?
I certainly don't doubt any abilities of the commission to evaluate what's in front of it. I think, though, that the commission needs a full set of information to evaluate. And, the contract approach, my issues with the contract approach only are that, those are company by company, and no one has visibility into exactly what's happening inside of those contracts except the commission. And I think that for public scrutiny, a large load tariff assures the public that there are a set of terms and conditions, a minimum set that apply to all of these companies. And if they're going to do something else in an ESA, that's got to be better than what's in the generic, public tariff.
Dr. Berry, in rebuttal, DEC's proposed its own large load tariff, how does that change your recommendation to defer a new large load tariff on pages 14 and 15 of your testimony?
I still think that there's not been enough opportunity to comment on these tariffs. And I think that more input from stakeholders could make the outcome better.
Thank you. Don't have any further questions. I don't believe my colleagues do. We will have questions on commissioner questions.
No questions.
And I'm not seeing any from anyone else. You are released as a witness. We thank you for coming forth and providing additional information for our respectful consideration during the course of this proceeding.
Thank you for the opportunity to speak with you.
All right. And we're at 5:03. We can go 15 minutes. Do you think is anything we can accomplish in that time frame? Yes, go right ahead.
Raise an issue, Marcus Tratham for CUCA. You may have dealt with this issue already, but CUCA, and I know others are in this position, have had two witnesses whose attendance was waived. When would be the appropriate time to read in their testimony into
You can go ahead and make an appropriate motion at this time.
Okay. As CUCA, well, pursuant to the commission's order excusing his attendance from July 8th, 2026, CUCA moves that the pre-filed direct testimony of witness Sean McLaughlin filed on May 29, 2026, consisting of 34 pages, 4 appendices, 5 exhibits, and the summary of the testimony be entered into the record at this time.
Without objection, your motion is allowed.
There was no confidential information with that filing. My second witness, pursuant to the commission's order for excusing attendance from July 15, CUCA further moves that the pre-filed direct testimony of witness Billy S. LeConte filed on May 29, 2026, and then corrected by filing on July 13, 2026, consisting of 45 pages, 3 appendices, and 12 exhibits, as well as the witness's summary of testimony, be entered into the record at this time.
Without objection, your motion is allowed.
And I just note that there were confidential and public versions of Ms. LeConte's testimony.
Duly noted for purposes of the record.
Thank you very much.
Attorney General's office.
Commissioner McKissick, I would like to make a similar motion for our witness Daniel Casera. He pre-filed 124 pages of testimony, 1 appendix, and 15 exhibits on May 29, 2026. That did include confidential information, and a witness summary was also filed in docket number E-7 sub 1329A. I would move that those be entered into the record as well.
Without objection, your motion is allowed.
Thank you.
Commissioner McKissick, Peter Ledford, appearing on behalf of the North Carolina Home Builders Association. I would similarly move the direct testimony of Christopher W. Millis, which was filed on May 29th, 2026, consisting of 15 pages of testimony and 1 exhibit. The testimony of Aaron P. Lange, consisting of 20 pages and 6 exhibits, and the testimony of Laura T.W. Olive, consisting of 36 pages and 2 exhibits that were filed on May 29th, 2026 in this proceeding, as well as their testimony summaries that were filed in docket E7 sub 1329A be moved into the record as if given orally from the stand, and that the exhibits be admitted into evidence.
Without objection, your motion is allowed.
Thank you.
Joining in, Ethan Blumenthal on behalf of the North Carolina Sustainable Energy Association. I likewise would move that the pre-filed direct testimony of Albert Lynn submitted on behalf of NCSEA on March 29th or May 29th, 2026, and consisting of 27 pages along with 3 accompanying exhibits, as well as his witness summary submitted it on July 13th in docket E7 sub 1329A also be moved into the record at an appropriate time.
This is the appropriate time.
Yeah.
Without objection, your motion is allowed. Any other procedural or housekeeping matters that we need to attend to before we adjourn for the day? Go right ahead, sir.
Thank you, Presiding Commissioner Nick Jimenez with NCJC et al. I've just been informed I may have neglected to move Mr. Wilson's exhibits or request to move them into the record along with his testimony at the appropriate.
Go right ahead. Do you want to identify them any further than just say exhibits?
Yes, sir. So this would be testimony of
I can certainly go back to my schedule if you need me to, but go ahead. You should have them readily accessible.
trouble describing them. The exhibits attached to his pre-filed direct testimony. I know there were two of them.
Do you want to take care of that housekeeping detail in the morning?
Thank you.
Okay. I think your guardian agent has arrived.
Indeed, Mr. Neal to the rescue. Yes, these would be exhibits JW-1 through JW-3, actually.
Without objection, your motion is allowed.
Thank you.
Any other housekeeping matters before we adjourn for the day? If not, it's 5:09 the afternoon. We will reconvene in the morning at 9:30 a.m. We look forward to seeing you then. Have a great evening.